Hey guys. Hi. Yes, much congratulations are in order. Thank you guys so much. We hit, I think we're at like 503. You guys, I'm so excited. So excited. It's a huge milestone, right? Thank you, QB. Thank you. Let's see. I appreciate that. You guys are my tried and trues. Yes, make sure to hit the thumbs up on your way in the door. Do all the other YouTube things too. Like, subscribe, share, hit that notification bell. Ding, ding, ding. Hey Sherry. Hey Morgana. Thank you, babies. Thank you. Thank you, Patricia. Thank you, Sherry. Yay. Hey Nicole. Good to see you and thank you. I appreciate that. I appreciate it. I'm sorry, you guys, if you got a notification earlier today about the Karen Reed hearing, my plan was to share that. But then it was like over and done with before Law and Crime ever came out with their feed. And QB was messaging me and she's like, it's over. And I was like, wait, what? It hasn't even started yet. She's like, nah, yeah, it started and it ended. It's done. So I deleted that stream schedule. I mean, I had it scheduled. And I just went ahead and deleted it. I'm like, no, no, no. So, and then QB was chatting with me about the Black Swan stuff. So the opening statements I'm thinking are supposed to start tomorrow. Um, I don't know that there's confirmation of that, but I think so. Um, and so QB was like, you know what? That Stand Your Ground hearing was really good. You should check it out. And I was like, okay, let's do that. Let's do the Stand Your Ground hearing. Um, hey Gail, good to see you. Hi Gail. Look, I got my schmammer. My schmammer. I'm gonna play whack-a-mole soon. Gosh. But hey, everybody coming in. Thank you guys. We've gotten a new group of new subscribers here recently. I'm super excited and hi. If you're new and you're popping in, would love for you to say hi if you want to stay in the shade, you know, of the if you want to stay in the shade, I appreciate that too. August 9th, hearing wait. August 9, hearing for motion to dismiss. January 27th, new trial hearing. There, you're all caught up. Hey, Kel. Hey. We're talking about Jenny's Gail Gavel on Friday. Yeah, we were. I was saying Gail Gavel, Gail Gavel, Gail Gavel, Gail Gavel, Gail Gavel. She actually left a comment and said she liked the song because I made up the whole song. I don't even remember what the song was now. But I just kind of bloop right off the top of my head. But anyway. Hey, Lauren. Hey, girl. Hi, girl. All right. All right. So I'm going to go ahead and jump straight into this motion, or not this motion, this hearing. And let me add it here to the stage. Whoa. Whoa, Nelly. Whoa, Nelly. Wait a minute. Except Judge Bev made it sound like she'll deny the motion. I didn't think she was supposed to be there for this hearing. I thought she was going to be out of town, but whatever. She was there. So yeah. All right. I'm going to click play. We're going to start this. So, for those of you that know about the Black Swan, Ashley Benefield, you will already, learn this information. Thank you, Lauren. Hi, Deborah. Hi, and welcome. I thought Judge Bev had been benched. Ooh, I don't know. I thought she said she was going to be out of town and not available, and some other judge was going to take over for this hearing today, but that wasn't the case. She found her way back. Way back. Right? But anyway, we're going to do, hey, Kayleen, good to see you. We're going to jump straight into this. It is, her and her bangs couldn't miss this hearing. I know, right? Her whole bangs. Oh my gosh. My phone's over here doing all these things. But with Ashley Benefield, so I'm not like super knowledgeable about this case. And so QB said that I do know that they had this stand your ground hearing back. It's been several months, right? Like a year ago or something, QB. I don't know. Is when this was. It's a 2-day hearing, but we're going to get in what we can get in before tomorrow. And welcome, Deborah. I'm glad to have you here. Glad to have you join us. We love our new peeps. QB says trial recap. Ashley Benefield is charged with second-degree murder for the death of her husband, Douglas Benefield. She is 32. He was 58. Yeah, I know they're like 30 years difference between them. I ain't judging. But so in her defense, her defense counsel had this stand your ground hearing. It was a 2-day hearing, apparently, I think QB said, because there was a day 1 and then there's a day 2. They're each like 8 or 9 hours long. Yeeks. We ain't gonna have time, but we'll watch what we can watch and get what information we can get from this. The stand your ground motion was denied by the judge. And so, I mean, she's, Morgana says, hey, don't, I'm not judging. My husband's much older than me. Not 30 years, but he was shot to death in Ashley's bedroom in September of 2020 while helping her move back in together with him. Ashley has not denied pulling the trigger, but has argued that she did so in self-defense. Of course, the prosecution disagrees. Oh, the second day is only like 2 hours. Okay, well, good deal. All right. They wanted a continuance and want the judge to be removed. 24 years difference, Morgana. Tried to tell Steph she needs an older man. Watch Steph pop in later and be like, wait a minute, what are you talking about me for? All right, so we're going to watch this hearing because she said, QB said, my fear of watching this prior to the trial was that we would learn things that were not going to be relevant to the trial because the lawyer or the judge did deny it. But QB said that she's watched it and it's spicy and lots of information. So, we'll garner some good information from this hearing. I'm going to put it on 1.25 speed. If we get to a part where, it's not easy to understand, I'll knock it back down to normal. Okay. So let's go. Here we go.
Is where we established a prima facie case that the force used was justified. The state stipulated to that, and Your Honor signed an order so designating it. At that point, the burden shifts to the state to establish that the force used was not justified. That's what the statute says, and that's what the case law holds. The standard that state has to meet to do that is clear and convincing evidence. So that leads us to what I think is a very appropriate consideration, Judge White, which is what are the parameters of a motion such as a stand your ground motion? I would suggest to the court that was pretty well defined in the second DCA case of Bowie versus State. I'll give the court the site at 292 Southern 3rd, 471, and specifically page 483, second DCA case 2020. The court there pretty much stated.
Sorry to interrupt, but QB, I just realized what that machine was, what that was there on the screen where you said Deborah, and I just now got it. That's QB's way of saying facts, like FACTS, like facts. That's true. Those are facts. But that's a fax machine. And so I love it. I love it. Facts. Oh my God. Nicole says my husband's 10 years older than me and my mom is 10 years older than him. Love a good age gap, right? We love a good age gap. I love that. Every allegation she brought against Doug were dismissed. No evidence. They did say that every single, she exhausted every single judicial whatever, right? With no facts. No facts. No fax machine. Take that, Siri, right? I had to look at it real hard, Patricia. I was like, what even is that? I thought it was a calculator at first, and then I'm like, is that a typewriter? Like, I couldn't figure it out. And I saw her put that the other day on another chat, and I was like, what? I didn't. I thought it was just a miss. She hit the wrong button. Now I got it. It's a fax machine. I feel like it's all PDF to email now. It is. Absolutely. You can find fax machines at the Goodwills and in, landfills and stuff. There were a couple he admitted to, but charges were not brought. So I heard, and I don't know if it's something we'll hear in this hearing today, but he did admit, and I heard him audibly say that the gun did discharge and hit the ceiling. And he did agree to that did happen. But I don't know what the circumstances around that were. Patricia, yes, Siri wants to say facts instead of facts. Who faxes? Even accused him of poisoning her and the newborn baby. That baby was subjected to hyperbolic testing. I did hear, I think it was QB or no, somewhere I heard that there was like toxicology or whatever you want to call it, tox stuff on her. Taylor Swift resurrected typewriters. Maybe fax machines are next. Maybe. I don't know. All right. I'm sorry to interrupt. We'll get back to it.
Stated that the inquiry for the court is to entertain any evidence which establishes that the force
I've
that
got
was
it on
used was
1.25.
not justified, which means, Judge White, that any other inquiries are irrelevant, specifically motive. Motive, a lot of times at a trial, is not required. It's never an essential element, but when it is available, it's a very powerful tool for the state to present to a jury. Abuse allegations, also irrelevant, as is Ms. Benefield's psychological state. Why are they irrelevant? They're still, of course, subject to the rules of evidence, even if the court entertained them. But the question then is, why would they be irrelevant? And it's our position, Judge White, that they're irrelevant simply because they are not material to the stand your ground statute's requirements. As the court knows, the issue is, was Miss Benefield in a place where she had a right to be? Was she involved in any criminal wrongdoing? And did she have an objectively reasonable fear of great bodily harm or death? So the case law supports exactly that. One of the benefits, Your Honor, of being in the Second Circuit is we have very well-defined case law on stand your ground. And I'll cite to the court two things in particular that should apply across the board to this hearing, respectfully. The first is in Riggins versus State, which is in our brief. It's at 344.
I was thinking the same
Southern
thing,
Third,
Patricia. I'm like, this dude
625,
needs to
page 626. Also a
razzle
second
dazzle it
DCA
up.
case in 2022.
I agree.
Therein, the court held that the trial court, this is a quote, the trial court is to assume all facts as true. Secondly, I would cite to the court also in our motion, the case of Jefferson versus State, 264, Southern Third, 1019. Again, a second DCA case, 2018. Here's what the Jefferson court had to say in upholding the stand your ground motion and immunity filed by the defense. Quote, we are mindful that there will be situations where the accused is the only available witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of section 776.032, subsection 4, stand your ground. In closing, Judge White, I think that the state will be unable to demonstrate in any capacity, much less by clear and convincing evidence, that Ms. Benefield, knowing what she knew on the day of this incident about DB, which is the objective standard, Douglas Benefield, was not justified in using deadly force to prevent great bodily harm to herself or death. Thank you.
Thank you, sir. All right, State.
State calls Tommy Benefield.
Judge, I suppose now we're into our omnibus motion and then
And you're talking about your omnibus motion
yes, sir.
under, hold on one second. I'm looking through. Go ahead and put whatever it is on the record. We're going to get to
Yes,
Tommy
sir.
Benefield.
Number two, yeah.
Number two.
I had lodged an objection to any Benefield family member testifying without personal knowledge of or participation in the events immediately preceding the alleged homicide. I then followed that up with a discussion about testimony by non-expert witnesses who lacked personal knowledge and cited the Florida Evidence Code. And I also included in the memorandum for Your Honor the following. As the court knows, in a homicide case, the accused has the absolute right to open the door or keep it closed as it relates to character evidence. Only the accused can inject character evidence, after which the state is permitted to rebut it. It is the same thing with a witness's testimony under 90-404, Your Honor. Mr. Benefield is limited. The state can establish that Douglas Benefield had a reputation for peacefulness once it's attacked. The rule is very clear. So it has yet to be attacked. Mr. Benefield can only testify as it relates to the rehabilitation of character by the state for peacefulness to his reputation in the community. Mr. Benefield did not live here in this community. He can only testify to his personal perception of his cousin's reputation for peacefulness, which the Florida Evidence Code does not allow. That's our objection, Your Honor, respectfully.
Thank you very much. State.
And Judge, the state does not intend to elicit testimony about reputation.
Okay. This is a great example of what I was saying when we were talking about the hearing is I heard your objection. I'm going to reserve on it because I don't know what these witnesses are going to say. I don't know quite where we're going. You guys know the case so much better than I do. So for now, I'm going to allow it, and I'll reserve at the end for, so keep making your objections. I'm going to reserve on those, at least this one. Some of them might be a more clear call, but we'll pour it all in the pot and see what we get.
Understood, Your Honor, and I might say I'm quite comfortable with the court proceeding that way. I have no doubt.
Thank you. But let me say this. Having sat on both tables, you make every single objection as we go that you feel you need to make. But I understand completely you have just a general objection to all of that character evidence, the background. You want to focus on that particular day. Got
Hey,
it.
Miss King.
Yes, ma'am. Okay, thank you.
Benefield.
Will stand against your face, sir. Raise your right hand. Be sworn.
Do you solemnly
Penny,
swear or affirm
girly.
the testimony you're about to give in this
Hey.
case to be the truth, the whole truth, and nothing but the truth?
I do. Okay. You have to take the back chair, stay about 12 inches from the microphone, please.
Hello, sir.
Morning, Judge.
My name is Judge White. I'm presiding over this hearing. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It adjusts up, down, left, right, wherever you're comfortable. If you just speak in a loud, clear voice, it'll pick everything up.
Yes, sir.
Good morning.
Good morning.
Let me just ask, can you see?
Okay, this is the cousin, right? Tommy, is that his name? Doug's cousin.
I can, Your Honor, it's being blocked a little bit by the court. We're not getting-
If you need to readjust yourself or reposition, please feel free to do so. Yes, ma'am. I'm sorry.
Please state your name.
Tommy Douglas Benefield, Jr.,
How do you spell your names?
TOMMIEDOUGLAS BENEFIELD JR for Jr.
And what was your relationship to the deceased Doug Benefield?
First cousins.
And how close were you?
We were close our entire lives, and I was instrumental in him going into the Navy when I was in the Navy. Both naval officers, both flying off aircraft carriers, both did other work for the government. And then all the way through his business career and his dual career in the government and in private, probably talked weekly to monthly, depending upon the times of our lives.
Okay.
I visited his family multiple times in Charleston.
And let me just ask,
yes, ma'am.
before he died, where did he live?
Well, he was in an apartment down here at the very end.
But before he moved to Florida, where did he live?
Charleston, South Carolina, 701 Preservation Place.
And where do you live now?
I split time between Jacksonville, Florida and Atlanta, Georgia. My wife and I have a spa business in Atlanta, Georgia, and I work 2 weeks a month in Honolulu, Hawaii.
And what is your job?
I'm a flight instructor for Hawaiian Airlines, teaching pilots in a particular airplane.
So let me ask you a little bit about Doug. At the time that he was murdered, how old was he?
He was just 1 week short of 59. He's born October 5th, 1961.
And how tall was Doug?
5'9", 5'10".
How much did he weigh?
I'd say 160 to 170.
And you already said before he moved to Florida, he lived near Charleston, South Carolina?
In Mount Pleasant, a suburb on the north side of the river.
Okay. And just before he moved down here to Florida, who did he live with in the house?
Just Eva and himself, except for the time that Ashley was living there previously.
So you said Eva. Who's Eva?
Eva is his biological daughter, first daughter, with his longtime wife, Renee.
And how old was Eva at around this time?
15, I believe.
So a teenager.
Yes, ma'am.
When did you first meet Ashley?
I had an overnight. I was flying for Southwest Airlines, had a change in a schedule. They sent me to Charleston, just me, not the rest of the crew, to take a plane into Charleston. And I texted Doug and said, hey, I'm going to be in Charleston tonight. Let's go to dinner. He texted back, great. April 14th, 2017 was the date.
You seem to remember dates well.
I have a very good memory, ma'am.
Okay. So you remember the exact date was April 14th?
Yes, ma'am. And I keep a diary and a flight log, so I know exactly when it was.
So did you in fact meet up with Doug?
Yes, when I got into Charleston, ahead of the hotel, I texted Doug again, and he said, Ashley's not feeling well. Could you take Uber up to Mount Pleasant to the house?
Overruled.
Did you know who Ashley was?
I had never heard of Ashley at that time.
So he spoke it like you knew who she was.
Yes, ma'am.
Did you take an Uber to their house?
Yes, ma'am.
Once you got to the house, did you meet Doug
I met Doug and Ashley together.
and Ashley? Was that the first time you'd ever met the defendant?
Yes, ma'am.
Did you speak with both of them together about their relationship and how they met? I'm assuming you were basically like, who are you?
We spent 4 hours together.
Okay.
We started at the house. I got her short life story, their life story together at that time.
So their life story together at that time, did they say how long they had known each other before they got married?
Yes, ma'am. It was almost a sense of pride for both of them that they had only known each other 13 days.
And how old was Ashley at the time?
At that time, Doug was 54 and she was 24, I believe.
So 30-year difference.
Yes, ma'am.
Between them. And I think you already answered this earlier, but did Eva live in the house with the two of them?
Yes, she did.
Did the defendant ever mention that she had a job?
No, ma'am. It was only past history stuff and what she was doing temporarily in the 2016 timeframe.
Was she interested in the ballet?
Yes, ma'am. She was a former ballet dancer. And by this time, they talked about the American National Ballet they had founded in February.
So let me stop you
Yes,
there.
ma'am.
So was Doug interested in the ballet?
The way a husband is, proud of his wife, supportive, knew nothing about the ballet except its existence, I think, prior to that.
And prior to this meeting with Ashley and all this, had he ever expressed any interest in the ballet?
No, ma'am.
Okay. So you mentioned February. So they started a ballet in February?
So there was an old ballet that was defunct called the American National Ballet. When Ashley wanted to start a ballet and make this a special ballet, a diverse, non-judgmental, non-stereotyping ballet, Doug found a name and found an old ballet, and that's, I believe, February 27th of 2017 is when they founded it on paper.
So a couple of months
I'm
before
sorry,
you met.
Suzanne. Continuing relevancy objection. I don't want to keep.
Understood.
So you mentioned that was February of 17. So that was roughly 2 months.
Yes, ma'am.
before You met Ashley. And how was the ballet being paid for? Did they discuss that with you?
Doug did. They both did.
Okay.
Uh,
Ashley did as well.
She talked about it.
Yes.
She understood what Doug was having to do to raise money and to put money personally into it. Doug was very, very good in all his businesses about doing the founding paperwork and establishing an LLC. And he had done the same with the ballet. He had built a website, just typical of Doug, to build it all himself from scratch.
And you said he put his money into it.
I know he put his money all the way till he ran out.
And then did he also have other money?
There were investors, including his business partners and other donors through the process. Yes, ma'am.
Okay. So it was actually formed in February of 17, but was there a formal launch of the ballet?
So the night I spent with them, they talked about the upcoming events. There was an informal launch in May. There was a formal big donor party that I was a part of, brought all my business partners, a lot of veterans that I work with to a McKee House event in August, I believe 12th of 2017. So that's the ballet that I learned when the event was coming out and planned on being there and bringing all my people.
Okay. During this time, 2017, at some point, did Ashley and Doug decide that they were going to have a child or try to have a child?
That wasn't a part of that first meeting night.
Right.
We talked about everything else and caught up on everything that we hadn't known. But it wasn't a part of that night. We ended up leaving the house, going back to my hotel, having dinner together. I'm a master trainer in a medical device. It's a pain relief device. It helped her, helped him. And then they headed back home that evening, but there wasn't any talk that evening about having a child.
Was there talk later on, specifically with the defendant, about the child?
Certainly. Vasectomy reversal is a very intrusive surgery for men. And when they made the decision they were going to do that, he and I talked about it at the time, in particular because of my medical device background, that could help him.
So they decided as a couple that they were going to have this vasectomy reversal to try and have a child?
Yes, ma'am.
And did the defendant, in fact, get pregnant that year?
He had the vasectomy reversal, and 3 months later, she got pregnant. I believe because we talked about it later, that the conception date was July 10th of 2017.
And at some point shortly after that, did she move away from their home in South Carolina?
Yes, so August 12th is when we had the McKee House event, the big donor event, introducing the other members of the staff of the ballet and everyone involved.
Ween baby,
Ashley and her mother
hey.
Alicia were there.
Hey,
I was
Ween
there.
baby.
And 2 weeks later, I believe on the 26th or 27th, they
Yes,
made the
you hope you're
decision
doing well.
together that it would be better for her because of her morning sickness
Bye.
to go live with her mother because Doug traveled for work and was busy. And that was what was presented to me by both of them.
And her mother lived in
Lakewood Village here in the Sarasota-Bradenton area.
Florida.
Yes, ma'am.
And so shortly after that, did Ashley move?
I believe on the 27th of August, because Doug called me both on the way down and the way back.
Did he help her move?
Oh, yes, ma'am.
Did he move with her?
No, ma'am.
He stayed in South Carolina?
Yes, ma'am.
Ween baby, so this is it was a stand your ground hearing previously that was denied, but this is for the Black Swan trial, which starts tomorrow. Ashley Benefield. Yeah. And apparently it is a hot mess. A hot mess express. How are you though, Ween baby? It's good to see you. Hope you've been doing well.
So that was August of 17.
Yes, ma'am.
Did the ballet eventually go under? And when?
So the ballet opening, the actual launch to the public was September 18th of 2017. That's a landmark date in this case in my history because it's the date Ashley and her mother went back in the house and got her stuff and she filed against him.
Okay, we're not
I'm
going to talk
sorry.
about all of that.
I'm sorry.
So shortly after this whole time, we're going to skip ahead, did the ballet eventually collapse completely?
Yes, ma'am. I'll answer it more directly. I apologize. So they launched it publicly on September 18th. The biggest performing arts center in Charleston is called the Gaillard Center, Big Performing Arts Center. And they actually had an opening performance on December 7th of 2017. And the dancers had been paid through December 15th. And by the end of the month, everything was finished.
Okay. So by the end of December 2017,
Everything's done.
it was defunct.
Yes, ma'am.
During the time that you encountered Doug and Ashley together and talking to Doug, how did he act about Ashley?
He was completely in love, completely supportive, starstruck, visibly, physically, you could tell by the way he treated her, took care of her on the opening night that I met her, and then it continued through the entire relationship until I never saw them together after the separation.
Okay. And when was that?
Well, physically, August 27th of 2017, when he drove her down.
So you never saw them together after that you can remember?
Well, I'll leave a caveat on that. I spent a weekend down here with Doug, Ashley, her mother, spent one night in the home where Doug was killed or murdered. And I don't remember that date. It could have been after the separation, probably was, but I just don't remember that date. But that would have been the only time that I saw them together after that.
Well, Ween baby, we have a
period.
trial coming up. This Ashley
Thank you.
Benefield one starts this week.
Okay. Thank you.
Cross. And let me just say, I completely understand that based on my evidentiary ruling so far, how do I say this? I know you probably wouldn't have asked a bunch of questions, but certainly for your cross-examination and any proffers of cross, I understand it's going to be broader than what it might have been.
Maybe not.
All right, maybe not. And please, sir, feel free to, you can question from either podium, wherever you feel more comfortable.
Thank you. Good morning, Mr. Benefield. I'm Neil Taylor. I'm appearing on behalf of Ashley Benefield. I regret that I need you under these circumstances.
I understand, Mr. Taylor. Thank you.
You were a pilot
Yes, sir, still am.
and consistent with being a pilot, in listening to you and your detailing of events and dates and times, it's pretty stereotypical of the discipline that a pilot generally brings to their profession. Would you agree?
Yes, sir. You want the best people up front that work like I do.
All right. And you've told us that as a first cousin, you were very close with Doug Benefield.
Yes, sir. I was closer with Doug in our adult lives than my own brother, who was still alive at that time.
All right. Now, Doug was not a pilot.
Yes, sir, he was.
A commercial pilot?
No, sir, a Navy pilot.
Okay. Not a aviator, not like the second seat, but the actual pilot?
So in a multi-crew plane that he flew, the S-3 Viking,
Yes, sir.
he started out as a naval flight officer out of training, and then he became a second in command, which is like the first officer in the airline world, actually at the controls. And that's how he finished his flying career in that airplane. So he flew the plane, he flew in the front of the plane, and not always in that position.
Okay. Now, being as close as you were to him, you were aware, were you not, that he was an accomplished, among other things, martial artist?
I never saw that personally.
Were you aware of it?
I knew that he was a wrestler in high school.
Actually, he was on the judo team in high school, was he not?
Well, he was a state all-star wrestler, which is I'm very aware of, but I was not aware of the martial arts being a part of it.
So as close as you were, he never spoke to you about his accomplishments on the high school judo team
No, sir, more about the wrestling.
or his training in the military for martial arts.
The same training, the military doesn't train in martial arts.
Did he confide in you the training that he went through once he left the service through the private sector in conjunction with servicemen, both active and retired?
Not specifically, because we don't talk about that stuff if we're in really special programs.
Okay. Tell us about the physical condition Doug Benefield was in. He was built pretty well, was he not?
He was in terrible condition the night I met Ashley. He was in pain from his ejection from an airplane in the Navy that led to back surgery that year in 2017. He was not in good condition at that time. He became in good condition after he bought the device that I am a master trainer in, and it brought him back to health.
Yeah.
He was in very
Oh,
good
I
condition.
forgot this guy
He
is
was
a
regularly
life
going to
coach, or not a
CrossFit.
life coach, but a
I'm
health
sorry, I
coach.
mean CrossFit. Some CrossFit, some fitness facility called Iron Tribe, which is a Christian-based workout facility. And I believe the last pictures of him on Facebook are in that gym. He was in very good shape at the end.
You saw the pictures?
Yes, sir, I've seen the pictures.
Okay. And they accurately depict the shape that he was in at the time of his demise?
Yes, sir.
Now, you've told us that he was, I think the words that you used, Mr. Benefield, was starstruck with my client, Miss Benefield.
Yes, sir, I would say that.
You're married,
Yes, sir.
happily so.
I'm very happy.
How many years?
Just over 4.
All right. Do you own a weapon, a firearm?
Objection relevant.
I'll overrule.
I own firearms, but I do not have a concealed carry permit like they did.
All right. And you're familiar with firearms from your time in the Navy, I trust.
Less from the Navy than after.
Okay. Have you ever fired a firearm inside your home? Intentionally?
Not intentionally or unintentionally.
Did your cousin Doug ever tell you that he admitted to firing?
Objection, Judge. This is part of what we were not going to get into.
So the objection is relevance?
The objection is relevance, and that there were certain complaints against that this defendant made against the victim that were denied by Judge Moreland in a hearing, and this is one of those.
Okay. So is there a written agreement not to get into this and that written agreement delineates everything,
No,
or is
but
this?
I thought we were not going to get into the specifics about the, other than it was shooting into the ceiling.
Yeah, well, I intend to stay within the four corners of my motion, but I think it's a fair cross-examination based on what he's testified to, his intimate knowledge of Douglas Benefield.
Okay. I don't know. I don't know what the agreement was to get into or not get into. I don't know what the relevance of this is going to be. It may be relevant. It may not. But again, I don't have.
Yeah,
to
and their
unring the bell
daughter
with a jury
Eva was
here,
the
so
one that
for now,
found
I'll
her, I
allow it.
think,
I may
right?
decide later it's completely irrelevant. I don't know.
Understood. May I?
Yes.
Have you ever fired a firearm inside your home intentionally?
No, sir.
Have you ever considered firing a firearm inside your home intentionally to intimidate your wife?
Objection,
speaking.
relevance of this question.
Hold on. Let the question finish. Let the
Mhm,
question
right,
finish. Go ahead.
Patricia.
Sir, hold on. There's gonna
That's
be
how
a-
my
Yes,
husband
sir.
is too.
Go ahead. Finish your question.
To intimidate your wife into not speaking any further?
Go
And
ahead.
what is the relevance of whether?
I just need objection relevance
Relevance.
sustained.
Did your cousin ever share that with you?
My
Objection
cousin,
hearsay.
He's so nonsensy, this
my
judge.
cousin
huh?
admitted both privately.
Is the answer yes?
I would like to answer your question and be very accurate, sir, like I've been all along.
I understand, however, Mr. Benefield, this is
Yes, sir.
cross-examination.
Yes, sir. He inadvertently fired a gun in his home.
No, he testified under oath that he intentionally fired.
Objection is her question.
Improper impeachment. Go ahead, sir.
Did
Sustained.
he ever acknowledge to you that he intentionally fired the
No,
weapon?
sir, he did not.
Did he ever tell you that he threw a loaded gun at Ms. Benefield?
Mm-mm.
Perhaps we talked about that. I don't remember that specific event like I remember the inadvertent firing.
Right, Kel.
Did he ever acknowledge to you that he punched the dog in the face so hard that it rendered the dog unconscious?
That's not what happened in his story to me.
Were you there?
No, sir. You asked me if I talked to him.
Did he ever acknowledge to you that he punched the
Oh my
dog
God.
in the face so hard that it knocked the dog out?
He admitted hurting the dog, but that's not a detail I remember.
Is the answer to my question no or yes?
Would you restate the question, please?
Did he ever admit to you punching the dog in the face so hard that it knocked the dog unconscious?
No, sir.
Did he ever tell you that he regularly carried a loaded firearm?
Of course.
All right. And to be clear, it was a firearm that was also cocked. All that was necessary was to pull the trigger.
Mm-mm-mm.
I don't remember that detail, but I'm sure that he carried it appropriately or he wouldn't have carried it.
Okay. You don't know whether he carried it wrapped or not.
No, sir.
Did he acknowledge to you that he placed a tracker on Miss Benefield's car?
Oh my
Yes, sir.
God.
Did he?
Oof. Now we're starting to get into like Micah Miller stuff. Trackers and all kinds of weird.
Acknowledge to you that he was caught at night by a neighbor peering into
Objection,
Miss.
Judge. Counsel is testifying just to find out if this witness has the information.
Correct.
If he
So-
wants to call a witness, fine.
Your Honor, he's testified.
Hold on.
Right, Patricia?
The way cross-examination works.
Yes, sir.
Is that the attorney is allowed to ask his question.
Yes, sir.
Generally, it's going to be yes or no. If you can agree with it, you agree with it, and then you agree with it in total,
Or not.
or no.
Yes, sir.
And if it's a question about, do you know, you know or you don't.
That's right.
And
So right there, QB goes to show he's not biased. Right? Except none of it was proven. Did he not admit it? Because he did admit to the shooting of the gun at the ceiling. He did admit to that. Because remember, we were talking the other day in that article that I was reading about the what do you call it? The deposition that he took in that like custody issue or whatever. The friend did say that he hurt a dog. He admitted to the gun. Okay. Okay. Well, we will continue on. We will continue on.
state, I understand what you're saying on the counsel's testifying. That's another issue. Obviously, if there was a jury here and so forth. With me, I'm not going to be influenced by the question. The witness can say, yes, that's true, or no, it's not. I know that. I don't know that. So go ahead.
Thank you, Judge. Did he admit to you and acknowledge that he was caught by a neighbor of Miss Benefield's at night, standing in the neighbor's yard, peering into Miss Benefield's window?
I don't remember that from him.
Is that something that you think you'd recall?
Yes, sir.
Is that something that you would expect of the Douglas
The
Benefield?
prosecutor,
that
she's
you
about
knew
to just
what
come up
you
off
did?
that table.
It's a possibility, not a
Shake
regular
her
habit.
head.
case.
Did he acknowledge to you, Mr. Benefield, punching holes in the drywall of their home out of anger?
I'm aware of one, not many.
And finally, did he acknowledge to you beating up his first wife, Renee, on their honeymoon?
I'm not aware of that.
When he lived here in Bradenton, Mr. Benefield, I want to be clear about something. At no time, to your knowledge, did he live in the same residence as Ms. Benefield.
I know that they were on the lease together in the final apartment, but I don't know if they ever were in the apartment together, but they were on the lease together.
Okay, so my question to you is, did he reside in a separate apartment here in Bradenton?
He had an apartment in Bradenton. Yes, sir.
I don't believe I have anything further.
Yes, sir. Redirect.
Your Honor, give me 1 moment.
Yes, I was going to say, if you need a moment, go ahead and do that. Hold on 1 second.
Your Honor, something for the court to consider at a later time. If the court would take a look at 90-806 of the Florida Evidence Code regarding hearsay, it states that once hearsay has been admitted and allowed by the court, the opposing party is entitled to move into evidence any testimony of the witness referred to, the non-testifying party, that exists. So in other words, during the state's examination of Mr. Benefield, wherein hearsay statements were allowed, the defense is entitled under 806 to move into evidence the entire statements of any prior statements made by Mr. Benefield, the deceased. If the court would take a look at that rule, I'll address it later on.
Okay, so the doctrine of completeness? The doctrine of completeness?
Yeah.
For that particular, each particular
It's
statement?
actually separate from the doctrine of completeness, but pretty much the same thing. It basically says when hearsay is allowed, the hearsay statement in any capacity or any statement of the non-testifying witness may be admitted into evidence by the adverse side.
I guess it'll just depend on what the statement is and when it was made and the relevance and sure.
Yes, I'll address it with the court at the later.
Okay. Yes, ma'am, redirect.
Just for the record, Judge, I completely disagree that that's what 9806 says. And in my direct examination of Mr. Benefield, I was very specific to only get Ashley's comments, not Doug Benefield's comments with reference to hearsay. So just that will be my response to that. So the defense asked you about this punching a dog issue.
Yes, sir.
And,
Yes, ma'am.
and you said that's not the story I got. What was the story you got?
The story I got was that Doug was sitting on one of his chairs with an ottoman. He always wore short shorts, bare-legged sandals, just like the night he was killed. And the dog jumped up in his lap because the dog was I picked up the dog after his killing. So I'm very familiar with Sully. Big dog, big nails, jumped up in his lap. And he was frustrated and it hurt. Aggressively pushed is one way, is what he told me. He admitted that was more than he wanted to do to the dog, but it was due to his frustration at the time. He pushed the dog off of his lap because it was cutting into his legs.
So at no time did he say he punched a dog?
No, ma'am.
At no time did he say that the dog went unconscious?
No, ma'am.
And the defense asked you if you were aware if Doug told you that he put a tracker on the defendant's car. Were you aware of that?
No, ma'am.
Okay. The defense also asked if you knew about Doug punching a hole in the wall.
I knew about one punch.
And what was the reason for that punch?
Frustration.
The defense asked you if Doug regularly carried a firearm. Did Ashley regularly carry a firearm?
Even the first night she met him in front of Secret Service in the area. Yes, ma'am.
So did she have a concealed weapons permit?
I understand she does.
And did Doug have a concealed weapons?
Yes, ma'am.
No further questions.
All right. Did you have any further questions before we let this witness go?
Yes, one. Mr. Benefield, where did you obtain the explanation about what happened to Sully by your cousin?
Both from Ashley and Doug.
Your Honor, now, again, I would direct the court's attention to 806. And briefly, if I may, Your Honor, I'll read to the court why I believe it's appropriate. Attacking and supporting credibility of declarant When a hearsay statement has been admitted in evidence, credibility of the declarant may be attacked, and if attacked, may be supported by any evidence that would be admissible for those purposes if
Right,
the
Deborah.
declarant had testified as a
He's a
witness.
really good witness.
Evidence
for
of a
sure.
statement or conduct by the declarant at any time
Yes,
inconsistent
Queen Baby.
with the
Yep,
declarant's
yep.
hearsay statement is admissible, regardless of whether or not the declarant
Queenie
has been
wears short
afforded
shorts.
an opportunity to deny or explain. Okay, so I think any statement inconsistent with this witness's repetition of a hearsay statement by Douglas Benefield is admissible. And I would suggest that the exhibits to our stand your ground motion clearly apply to that.
I'm not into body shaming or like looks shaming, so to speak, you know. But the nair thing, I'm like, yeah, I can't wear short shorts, get your nair and all that because this defense guy's used up all the nair on his bald head. Sorry. I like a bald dude. I'm not saying anything bad. I mean, look at Mr. Clean. Mr. Clean is a very handsome man, right? Sorry. Yay.
I don't know which exhibits we're talking
I
about.
don't either. And Judge, I would argue that the only person that elicited hearsay was defense counsel. So defense counsel cannot elicit hearsay and then try to impeach the hearsay that he elicited. So I would object and disagree with that.
Yeah, I don't know what are we,
Judge, Your Honor may recall that during the direct examination by Ms. O'Donnell, Mr. Benefield related conversations that took place with the deceased, Douglas Benefield. And specifically, there was a hearsay objection. The court overruled it and allowed it. That opens the door to 806, Your Honor.
right, I didn't hear argument on it. Which specific statement was it?
I believe, among other things, Mr. Benefield testified to everything relating to the ballet. I believe he testified to statements about how enamored Douglas
Right.
Benefield, the deceased, was with Ashley Benefield. Those hearsay statements alone, Your Honor, open the door to 806 so that any statement by Douglas Benefield that is inconsistent with that testimony is admissible.
I don't remember any statements where, you know what, this would probably be better. So we're talking about your testimony.
It's okay.
I'm going to excuse you to the
Yes, sir.
hallway.
No worries.
The rule of sequestration has been invoked.
Yes, sir.
That's a rule here in the state of Florida, probably other places too. That says once you're called as a witness, your son is as a witness, you're not to discuss your testimony, the questions asked, the answers given with anyone at all until you're released from your subpoena or the hearing or the proceeding is concluded.
Yes, sir.
So that rule has been invoked. So when you're outside, you can't talk to anybody.
Yes, sir. I understand the rule and I'll follow it.
All right, thank you, sir.
Yes, sir.
We'll call you back in as soon as we can.
Yes, sir.
Massachusetts State Police, Lauren. Remember all the bald guys in the retrial?
All right, the witness has stepped out. On that particular point, that's a pretty decent notes, and I was listening. My notes are not that he said that, just that he observed that Mr. Benefield was starstruck. I mean, nobody clarified, how do you know that? Did he say it? Was it your observations? So I don't think that's necessarily a statement. What other statement in particular? There was one I overruled. I didn't see it as being offered as the truth of the matter asserted, so I didn't see it as hearsay.
Sure.
I know there was one of those.
My objection was on the basis of hearsay.
Mhm.
The court allowed it. And I think if you will, the danger of 806 and why it can be a two-edged sword is that it does not restrict the subsequent admission to anything relevant to the hearsay statement that is allowed. It rather sets up the credibility issue. And once a hearsay statement is allowed into evidence, then any other statement that the declarant made that is not available is admissible if the credibility of the declarant is being attacked. So, for example, on cross-examination, I questioned the witness about these violent acts by the deceased. Some he acknowledges were told to him, some he denies were told to him. If I have an admission, even though it's in a hearsay statement, if I have an admission by the declarant, it is at that point admissible according to 806 in evidence. It doesn't make a difference that the hearsay statement, Judge White, is related to the hearsay that the court admits.
So you're saying if one hearsay statement is let in, whether, and let me also say, somebody might object to hearsay, overruled doesn't tell you if I overruled because I don't see it as hearsay. It was a statement, but it wasn't offered for the truth. Could be that I went through the catalog of exceptions and found as one of those. So I wouldn't read too much into overruling a hearsay objection.
Sure, and I understand.
And 806, familiar with it, and it's when a hearsay statement is put before the prior fact or into evidence, that the hearsay declarant's credibility can be attacked or supported as allowed by the rules. I don't think it kicks open the door to any possible hearsay statement the declarant ever made on any topic at all.
Respectfully, if it goes to the declarant's credibility, I would say it does. And I think that the statute and the case law will support that because again, it's not tied to the
No,
relevance.
I didn't say credibility. I said any hearsay statement. That's what I'm hearing, that we can bring in any hearsay statement.
To the extent it supports
Or
an attack on the credibility. Yes, sir. Yes,
that I don't disagree with. A hearsay declarant's credibility can always be attacked or supported pursuant to the rules.
right. So it's our position then that any hearsay statement that supports or attack on the credibility of the declarant is admissible. And specifically in our motion, we have several of them and we appended them as exhibits. So I think that they are now admissible by 806.
I'm not sure exactly which ones are, but state.
And Judge, I'm confused because at the base of it, the defense elicited the hearsay.
Hey,
And then he tried
Spins,
bring
good to
the
see
hearsay
you.
to
You suck at lurking.
the hearsay statement that he brought in. I don't understand this, but 806 says that once a hearsay
We do have
statement comes
Karen Reed
in,
on our
that other
brain,
evidence
right?
can
We
come
do.
in, which would have been used had the person testified. So I think we're still bound by the rules of what can come in. Just because someone may be impeached on one statement doesn't mean every hearsay statement they've ever said comes in. That's different than credibility. So to be honest, Judge, I'm a little confused.
I am too. And let me make sure I understand. You had mentioned something,
made your record
and I didn't want to get into it too
down.
much. The witness was here. And I think this was also mentioned, Mr. Taylor, I think this was also mentioned in the,
Let me just say real quick. Thanks, new people, for popping in. Would love for you guys to hit the thumbs up button on your way in the door, or if you're on your way out the door, we would love for you to give a big thumbs up. Yes, Morgana, thank you, thank you, thank you. And if you're new, say hi in the chat. We don't bite. We're good people over here. We're not scary people.
defendant's motion
I'm
in
excited to
limine,
have new people
that there were
pop
some
in.
discussions about certain evidence not being relevant.
We just hit the 500 subscriber milestone here, and I am so excited. And like that's, first big milestone, and it's very exciting. Very exciting. Yeah, we don't bite hard, said Spins. Thank you, Deborah. Thank you. Yes. Thanks, Gail. Thank you, Gail.
And you were to just talk about very surface level things, but it seems like a shovel out. We're going to start digging some holes.
Point well taken, Your Honor. Actually, the discussion was limited to.
You guys are
allegations
awesome.
of abuse. That is to say, both Suzanne and I felt, rather than going down the rabbit hole of litigating whether or not the allegations of child abuse against the daughter were true or not, we would not go there.
So the agreement was limited only to allegations of child abuse.
Absolutely, Lauren. I'll take it.
We never executed.
Hey, Billy. Good to have you here. A little nibble now and then, yeah. Thank you, Sherry. I love you.
State.
We did
I love
have that
you too.
conversation about the child abuse allegations. I do not remember specifically excluding anything before the child abuse allegations. And if there was a miscommunication, I apologize, but I had assumed that that would be a part of the let's not go down rabbit holes, because the issues that have just come up have already been litigated and have already been ruled on by another judge. So I was under the impression we were not going to get into those that happened in South Carolina.
Yeah, again, I don't know as a part of the agreement. I can say this. So there's two general ways a hearing like this can go. And I'm talking very, very broad strokes. One is how I thought we had agreed to do this was that
Thank you, Ween Baby.
pretty much we're going to let stuff in
Thank you. I appreciate
and
that.
object as we go. And then I'll decide the relevance or if things are relevant or not relevant. And I understand that that means a lot of things come in that might not normally come in. And those things may be relevant or not relevant. So I'm going to listen and hear a lot more testimony and see a lot more evidence than I might not normally. But it's to allow you guys to just put on your cases. The other way is we take a step back from that and I will grant or overrule objections as we go. I personally think that'll take a lot longer, but it'll also limit how much evidence is put into the record. And we can do it that way too. My rulings so far, I would think both of you would agree, have been very generous towards admissibility because that's what I thought we agreed on. So, but if that approach is then going to be, well, Katie bar the doors, here it all comes. And we're going to
Katie bar the
spend
doors.
tons of time. We're going to stop here. We're going to get off the bus. And we're going to spend a day looking around over here. Then we're going to get back on the bus. We're going to go a little way down. We're going to get off the bus. We're going to look all around here. I'm not doing this so I can have hours upon hours of testimony about somebody shooting a gun in a house, punching a dog, putting a tracker on a car, peering into a window, punching a hole in drywall, and alleged domestic violence in a prior marriage. I'm not going to hear hours and hours of testimony. So I need to know. I'll start with the state, start with the defense. Are we going to do
Thanks,
the plan that we
Henry.
originally laid out, which is, hey, put your stuff
Thank you
in,
so much.
right? And then I'll figure it out as we go. Or am I going to throttle this down and I'm
I
going to start
appreciate that.
listening to more objections? Not that I haven't been listening, but take more of the approach of, no, we're not letting irrelevant stuff in. We're not going to have hearsay. State.
Judge, I would not want to continue with everything that we're doing now. I don't necessarily think that we need to completely curtail it, but I do think that some of it needs to be throttled down. If there's an objection, I think that you should rule on it appropriately.
All right. So that's a mix. All right.
So
A
I think
mixed
that
bag
would
here.
be the former position, which I agree with. I am quite comfortable. There's no jury here. I am quite comfortable with the court parsing the evidence when the time comes for the court to rule and author an appropriate order. And that was why I said I'll address it later. I wanted to make my point and move on. And I'm satisfied if we continue to go that way. I
All
think
right.
it's going to be consistent with time savings and efficiency.
But it hasn't so far because we're spending a lot of time having this discussion now.
Yes.
So it hasn't been the time savings that I had planned.
And let me-
So I guess my question is, I don't know what statements you want to get in. I don't know what evidence that you want to get in that you're arguing comes in under 806, which, if I'm understanding your arguments, I don't think I read as expansively as you do. I think a hearsay declarant's credibility can be attacked or supported, if attacked, as if the hearsay declarant had testified, but that's still within the bounds of the Florida Evidence Code. I don't think it kicks open the door for every hearsay statement that has ever been made. But the second DC will tell me if I'm right or wrong. So let's call the witness back and we'll see if we're on the same page and we can go from there.
I believe we were at the end of defense cross, or I was at the end of my redirect. Were you going to, I don't know. I don't know if we need the witness back. I'm like,
I will tell you this,
Agreed.
there was recross. The question was, how did you hear about Sully? And did you hear about it from
That comment
Mr.
made me
Benefield or Ms.
giggle.
Benefield? The answer was, I heard from them both.
Queen Baby's New Kittens is psychopath.
so it's
Now-
on defense cross.
I'll just say, I don't know where this is going. I don't know how much you plan to get into
God.
defense. I've read, this is not the entire pile of what you sent me, but this plus everything else you sent, I've read it. I've read it.
Hey,
I
Sheree.
understand, well, the portions of the depositions, I didn't get entire depositions. I've read it. I mean, I understand that what he said about that, the incident with the dog. I understand what she's saying about the dog. I just don't know how far we're going to go down that hole.
I hear you, Judge. We're finished with Mr. Benefield.
Okay. I don't want to curtail you. If you have any questions, I want you to ask your questions.
I understand. I appreciate it. We're on the same page.
All right. All right.
Yeah, Ween
So
Baby.
Mr. Benefield is
The
done.
trial that starts.
And he can be,
The trial that starts, they just set the jury today. But they're supposed to I think, have opening statements are supposed to start tomorrow, but they held this stand your ground hearing. Let's see, what day was this held on? 1 year ago. So July 6th. Um, yeah, this was a year ago. Yeah. Wait a minute. Well, this here is dated. This was streamed live on July 6th, 2023. So it was just over a year ago. Yeah, Ween Baby. That's what we're watching today, is because we're going to get some information from this as sort of like get to know some of the details before the trial, right? So that's what we're watching. But anyway, yeah, sorry. I was just catching up here. But we're going to get a lot of the details from the story, some of the different accusations and all that kind of thing. So we'll be a little bit prepared, I guess, so to speak, for when the trial starts. But she is on trial for murder, but her defense is it was self-defense. But pre-trial info is good to get details. Yeah, I agree. I agree. You're right.
Released.
That's my next question. After each witness, I will ask, can the witness be released from their subpoena? So, state.
Yes.
Yes, sir.
All right. So we're going to call the next witness, and can you let Mr. Benefield know that he is released from his subpoena? And who's your next witness?
I'm sorry.
Your next witness.
Oh, Stephanie Murphy.
Stephanie Murphy. Who's Stephanie Murphy?
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
Where did I put my notes?
Stay about 12 inches from the microphone.
No. Hello, ma'am. My name is Judge White. I'm going to be presiding over this hearing. As the deputy said, you get about 12 to 15 inches from that microphone. It adjusts up, down, left, and right to wherever you need it comfortable. And if you just speak in a loud, clear voice, it should pick up everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name
Stephanie Murphy.
and what do you do for a living?
I'm an attorney.
Oh, I
What type
remember
of law
her.
do you practice?
I practice family law.
And do you work for someone or are you self-employed?
I'm self-employed. I have a firm in Sarasota.
How long have you had that firm?
I've had the firm for approximately 15 and a half years.
And were you hired at some point by Doug Benefield?
Yes.
Do you recall when you were hired by him?
I first met with Doug Benefield on March 13th, 2018. He retained me on a partial retainer the following day on the 14th
Queen
of March.
baby.
Okay. And what was the purpose of him hiring you on that day?
On that day, I was retained for a limited purpose of communicating with Ms. Benefield with regard to the upcoming birth of their child.
Okay, so the defendant was pregnant at the time,
Correct.
and do you recall when her due date was?
Believe the original due date was April 8th of 2018.
And
Queen babies comments always kill
you
me.
said your initial responsibility was to communicate with her.
Yes,
So did you attempt to communicate with her?
I did. I sent her a letter via email on March 15th, 2018 at approximately 9:59 in the morning.
And without getting into all the specifics in the letter, basically what was the gist of it?
The general gist of the letter was that with knowledge of the upcoming birth of their child, Doug wanted to express his interest and desire to be part of the birth process, to be present if possible, but also wanted to communicate that if Ms. Benefield felt uncomfortable about that, he wanted to respect her space.
Your Honor, for the record, object to hearsay and relevance.
Yeah. Is this being offered for the truth?
No, it's just basically being offered to show that this is how the communication started and that the letter was sent to Ms. Benefield.
Okay. Did you want to respond to that? I'll just say, I was not taking this as for the actual truth of this.
Yeah.
If it's intended to be for the truth of these matters, then that's a different issue.
No.
Well, I think it's obviously intended to quote unquote educate Your Honor, based upon the hearsay that this witness has to offer. So
Okay.
continuing relevancy.
Yes, sir.
Hearsay check.
Go ahead, ma'am.
Okay, thank you. Did you ever, let me back up. I don't know if you said this, but in what form did you send her this communication?
It was a letter that was saved as a PDF that was emailed.
Did you ever receive a response from her?
She never responded to me directly, no.
To your knowledge, did she ever respond to Doug?
No, not at that time.
At some time shortly after that, so the baby was born in, or when was the baby born?
Well, baby was actually born quite early. The next day after receiving my letter, she checked herself into Tampa General Hospital and then started a induction of labor process. And so the baby ended up being born about 3 weeks early, I think March 19th of 2018. I may be off a day or two.
So middle of March. the baby was
Correct.
born. What, to your knowledge, was Doug there?
No, he was not there. He had no idea baby was born.
Did
Wow.
the defendant file for an injunction shortly after?
Yes.
And what date was that?
My memory is that it may have been, excuse me, May 1st of 2018. It could have been in April. There was a bit of a lag between when she filed it and when we had knowledge of it because the injunction was actually denied, but a hearing was scheduled. So Mr. Benefield was not served.
Okay, so just to be clear, you said the injunction was denied. Are you saying the temporary was denied?
Correct.
Okay, so an injunction was filed, a temporary was denied, but it was set for a hearing, is that what you
Yes,
said?
that is correct.
All right. Do you recall when the first hearing was set approximately?
It was shortly after we found out about the injunction. So I think we found out, meaning I found out on May 6th of 2018 that the injunction had been filed, which is how we knew that the baby had been born and what the baby's name was. And then the hearing was originally set for shortly after that. I think just a couple of days.
Okay.
Ended up getting continued anyway at Ms. Benefield's request.
Okay, so it was set pretty close in time, but it ended up getting continued.
Correct.
Before the hearing was actually held, did you end up filing something on Doug's behalf?
Yes, quite a few things.
And generally, what did you file?
Generally, it was a petition for a parenting plan unconnected with divorce and a motion for psychological evaluation. Those were the initial pleadings that we filed.
Ultimately, were these issues all to be addressed at the same hearing?
Ultimately, yes. Well, let me clarify. No, because then when the hearing ultimately took place, it wasn't the original petition for parenting plan unconnected with divorce. It was actually an emergency motion for a temporary time sharing and parental responsibility. But both cases traveled together. And so pleadings or motions in both cases were heard at the same time.
Okay, so while the motions themselves may have changed, the two case numbers were heard at the same time.
Correct.
So at the time, Doug had an emergency motion for time sharing.
Yes.
And what, just briefly, what is that?
When there's a child, there's no such thing in Florida as custody anymore. Parents have time sharing with children. Ms. Benefield was withholding time sharing of their daughter from Doug. And so the appropriate way to seek time sharing was through the court versus taking matters into your own hands.
Okay.
He was also seeking parental responsibility, which is the decision making.
Okay. And when was that hearing held?
It was held on 2 different days. It was July 30th and September 17th of 2018.
So you did have part of the hearing on July 30th, 2018?
Yes.
And did not finish, I'm assuming?
We did not finish.
What judge was it?
It was Chief Judge Diana Moreland.
And before that first hearing, was there a motion to recuse the judge?
It was a motion to disqualify Judge Moreland.
And was it granted?
That's crazy, Morgana.
And they appealed that decision and filed a motion to stay pending appeal. That was also denied.
So the hearing continues.
Correct.
Then it continued again for the rest of the hearing in September.
Yes.
So I don't want to get into the specific facts of the allegations in the injunction, but if you could just tell us generally, what were the topics, the injunction?
It was a wide range of topics. The most alarming was she had allegations that she was poisoned by heavy metals and that the baby had also been poisoned in utero. She alleged violence of a dog.
Oh, I'm sorry. I thought we were going to talk more about the poisoning. So
Okay.
violence with a dog.
Correct.
poisoning.
Right. Threats, and that he had discharged a gun in the home.
Okay. After this hearing, did Judge Moreland make a ruling?
She made a ruling at the conclusion of the second day in September. Yes.
And what was that ruling?
Her ruling was
I'm going to sustain as to her ruling on these issues. I mean, I'll hear.
And-
Go ahead.
I'm sorry.
You put whatever you want on the record.
This we may need to have argument about, Judge. It is my argument, it's the state's argument, that the content and the manner in which, I have the order recorded, the judge made this ruling sets
Big
the
upset.
stage for the defendant's behavior later on down the road. Because she knew that this judge felt the way she did, and she had a hearing in front of this judge 3 days after she murdered the
The
defendant.
lady on the
So
stand
I think it's effect
wink,
on the
baby,
listener, and I have some case law we can argue.
is the lady on the stand. Her name is Stephanie something. She was Doug's family lawyer, like over his estate and stuff.
But this manner in which this order was given is highly relevant to the defendant's, the effect on her.
Not a
All right.
scintilla.
So
Yeah, I
You're
remember
not
that.
introducing Judge
I
Moreland's
remember
ultimate
that.
order to influence one way or the other to prove that it was correct.
Correct,
It's the effect on the defendant.
correct.
All right.
Whether it be right or wrong, the ruling, I'm introducing it for the effect on the defendant.
Yes, sir.
I don't have a problem with that. The problem that I have, which I think the court is well aware of, is the characterization of the presentation.
Right, absolutely. If it was for the purpose of, hey, judge, this other judge ruled this way, therefore, that's what we want.
Correct.
But if it's to show the effect, and yes, that one of the cases you had submitted illustrated that very point. So I get that. All right.
I want to make sure we're talking about the same thing. I don't have a problem with the state's theory that this decision prompted the subsequent action. What I strenuously object to is the statement by Judge Moreland, the characterization of the quality of the hearing. That, I think, should not be stated in this proceeding. I think it's irrelevant. The decision itself, I don't have a problem with. I can tell the court, well, let me just leave it right there.
All right. I don't know what the statement is. I'm going to have to hear it eventually, and then I just won't consider it, but it was,
First bench.
yes.
QB's like, dude, just hush. Just stop. The black swan there putting her headphones on so she can hear the sidebar chitter chatter. By the way, did you guys ever watch the movie, The Black Swan? I feel like I did, but I don't. Makes me want to go back and watch that movie. It's not about that movie. They're just nicknaming her the Black Swan because, she was a ballerina. All right,
This
let's.
one, kind of a good time to wear. And we got some new headphones. Let's do this. We got some new headphones. And as it invariably happens when you introduce new hardware into a system,
Is it?
we've got to get it fixed. So why don't we do this? It's kind of a good time for a mid-morning break.
Oh, was
So
it
why don't we
weird?
take about 10-minute break? It's 10 after. We'll see everybody back at 10:20. We'll get this issue solved. Ms. Murphy.
I feel like it's
the
an
written
older movie,
sequestration has
right?
been
It's been
invoked.
around
We're
for
going
a
to take a
long
10-minute break,
time.
so you will be, I'm sure, milling
I
about the
can't even
hallway.
remember what
I
it
know
was
you're familiar with
about.
the rule of sequestration and what that means regarding your
But-
testimony and who you can
Yes.
talk to. Please make sure you follow that closely. We'll see you
Absolutely.
back in about 10 minutes.
Thanks so much.
Mentally ill. Yes, baby. Oh, you guys. Kiddo got no ma'am. We're leaving that just like it is. Thank you very much. She got bit over the weekend from mosquitoes. I haven't seen any mosquitoes all summer. And all of a sudden, just poof, out of the blue, it was like she got like 10 mosquito bites on her legs. God love her heart. And she has, if you don't believe it, I didn't believe it, but go look it up. It's called Skeeter syndrome. Both my kids do that, where when they get bit, they don't just itch. I mean, it gets a big, huge whelp and it blisters and hot and swollen and awful, right? So anyway, that's what we're dealing with. Benadryl Central. And like it freaks me out. Freaks me out. But her skin will swell so big that it like bruises almost.
All right, we are back on the record, and go ahead and approach attorneys. So yes, ma'am, anytime the attorneys approach, put those headphones on. We'll turn them on, that way you can hear.
Thank you.
Thumbs up.
So anyway, that's what we've been dealing with this weekend. I did too, Morgana, when I was little. I did that. Like I would get bit and then they would be big, massive, but yeah, she's not happy. I have an EpiPen for bug bites. I'm buying one of those bug bite things. What bug bite things? Go to Amazon and look up bug bite thing. Apparently they work. Also, the Benadryl gel is my favorite. I've seen those mosquitoes with the white stripes. I've seen those before. Yeah. Calamine lotion for the win, right? We've been using Benadryl cream. Not cream, it's the gel, clear gel on our legs. But Deborah, that was something I actually looked up too to make a paste
Okay, can we
out
bring
of
Ms. Murphy,
baking
Attorney Murphy,
soda.
back in? Thank you.
But then we get to the point where we have to
Testimony.
No.
All right.
because sometimes she won't leave them alone, I end up having to cover them with once the itching stops, then I end up having to put the medicated like triple action antibiotic cream on it, or Neosporin, stuff like that. Yeah, I did read that too. An oatmeal bath for Skeeter syndrome is good too. Mosquito bites do me the same. One time I got ate up bad and had to get a cortisone shot. Oh my gosh. Henny is here today. She popped in earlier. I don't know if she is still here. We use the Benadryl clear gel too, Ween Baby. I like that one a lot. I might have to try that baking soda trick. Definitely covered after applying the baking soda paste. Yeah. Well, they're kids, you know. She's into everything, um, and she will not sit still. So, y'all making me itch. I'm sorry. See, now I'm itching too. I'm like, itchy, itchy. All right, let's get back to this. Let's get back to this. She's back
So
with
we
her
were
purse.
talking about the end of the hearing on September 17th, 2020.
She's back with the purse up there on the little area here, whatever you call that. Yes, child. And she's like, "Look at my pretty purse. It's very expensive." Yeah, Ween Baby, that's what I have to watch because they do blister. Um, and then she'll scratch it until it opens and then can get infected if I'm not careful. What's with the fake couture? Calendula. Can you like buy that at Walmart? I don't know I've heard of it, but I don't know what it is. Trying to figure out what that purse is. It kind of looks like a Prada, but like a fake Prada. Have you ever seen the movie Serendipity? On Kate Beckinsale and Molly, is it Molly Shannon? Is that her name? Are land in New York. They hop out of their hotel room and they're walking down the sidewalk, and she's like, "Ooh, Prada, fake Prada," and she's like, "That's a bad fake one." She's like, "That don't even say Prada. It says Prada. It says Prado." She's like, "I can scratch that out and make it an A." I'll have to check that out. Thank you. Thank you. All right.
Where Judge Morley made a oral order.
Correct. She made an oral ruling at the conclusion of the hearing.
And was the defendant present to hear this ruling?
Yes.
She was in court then?
Yes.
All right. I'm going to show you State's Exhibit number 1. Do you recognize that?
I do. Those are my initials.
What is it?
That is the CD of the oral pronouncement at the end of the injunction and emergency timesharing hearing.
And you said these are your initials. So
Correct.
when you listened to it, did it accurately reflect your memory of what was said in that hearing?
Yes.
Ooh,
State manager and
I
evidence
think she
State
might have had a
Exhibit 1.
thing for him.
Okay,
Okay.
same objections?
What, baby?
Yes, sir. Overruled for the same reasons. I'm not accepting it for the truth, just the effect on the listener.
Okay. And then the state will publish it's about 10 minutes long.
Mr. Sessions, start with that one thing, even though I find it very reticent to ever say, well, someone else investigated this, so there's no problem. But I do appreciate the fact that Mr. Sessions argues that people investigated and found that his client wasn't the perpetrator of any domestic violence, et cetera. Because I just read a report by a doctor that just indicated that he had done a full battery of psychological evaluations on Mr. Benefield in this case. He had absolutely no concern of self-harm, domestic violence, or any other type of spurious activity on behalf of Mr. Benefield. Let me just go ahead and say as follows, that this court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Ms. Benefield. Court finds that it starts from basically the absurd of the conversations of what she would have with a child searching the room, finding a shadow box, being so upset, but also at the same time, the testimony where she said, well, they were absolutely like me a lot. They confided in me every conversation. I knew all these horrible things were going to happen because the girls felt good talking to me. We then move forward to the actual presentation that she's had in this courtroom since she entered into this courtroom, the turning on of tears when she thinks it's appropriate, and then we move on to the entire insinuation that there is some type of poisoning going on in this particular case. There is not a single scintilla of credible evidence that Ms. Benefield has ever been poisoned or suffered from any illness of any poison. Court finds that Dr. Hilliard's testimony was suspect. I don't think that the court finds that he reviewed one record appropriately. And in comparison to Dr. Sawyer, I think his testimony, in a word, was bunk. I do find that Dr. Sawyer's testimony was quite informative, and that his information concerning the answer to questions that I had, how there were testing for certain metals on and then testing for certain metals that weren't there. And it's most important to this court was the explanation of the misinterpretation or the use of an improper range, which I think even in cross-examination, there was a misunderstanding that there is a range of these metals are in the human body, not just a single number. So that brings us to the following timeline. I have that in 10/20/2016, there's the respondent goes up there. They're at the respondent's home. Petitioner is up there. He's had back surgery. She moves back to the respondent's home permanently on December 2016. That in about January 2017 through, I'm going to say 5/8/2017, there appears to be a marriage in which there are arguments, and but there is still a very committed relationship to the point where they're talking about having a reversal of vasectomy to have a child. Now, 5/8/2017, the clear evidence is that there is the vasectomy alteration or reversal, and that from that point they begin to pursue having a child. The court will find there is one incident of alleged domestic violence, and I got to tell you, it is de minimis, even though it's huge. Whenever how it was executed, the shot into the ceiling, court is going to find that at no time was the shot by Mr. Benefield at or in the direction of Miss Benefield. The court has seen Mr. Benefield testify, and the court finds that Mr. Benefield is taking on responsibility for that single misstep. But that is a remote type of domestic violence that has occurred. Subsequent to that, it is clear that Ms. Benefield continued to pursue a relationship and have child with this gentleman, that she had a lavish wedding, invited numerous people there, had many people that she could have confided in, saying, I'm in a hellish situation, things are out of control. Just last week, he shot a bullet in the ceiling. That's absolutely not what happens. Instead, she goes through with this lavish wedding. She goes on developing a ballet with her husband at that time, posing in magazines, portraying to everybody in the world that this is a very happy marriage, that we're going down, we're going to start this national ballet at a significant cost, both emotionally, physically, and financially to the parties. That she finally they finally find out that in July 2017 they have conceived a child, and that or they think that that's the date they've conceded in retroactive review, which tells this court that during that period after the shot, that they were still engaging in an intimate relationship. The court does not find credible any type of animal cruelty in this particular case.
The only thing about that is, Deborah says Doug was her sugar daddy. So the only thing I wonder about that, and we was talking about this the other day in the other live stream we did about Ashley Benefield, and my question was, if he indeed was her sugar daddy, which I believe he was, why did she pay for his reversal, his vasectomy reversal? I mean, QB says there were definitely a few things the judge said that I don't agree with. I don't know.
Nor does the court find that the other incidences alleged of punching the wall were directed completely at her, nor were they meant for intimidation. Court's also going to find that 3/2017, they do find about the pregnancy. It's confirmed. And at that time, because of illnesses due to the pregnancy, it is determined as a family, as well as because of the ballet, that they're going to move Miss Benefield to Florida from South Carolina. During all this period of time, what we have is a household that is continuing on. Miss Benefield being in the home,
ran out of
not
money,
making anyone alert. The medical records are devoid of any conversations between her and people that would have been providing protection, those being doctors, etc., indicating in the least that she has any type of poisoning that is appearing in her system, that she has been a victim of domestic violence, and or that this child, Eva, has been the victim of domestic violence. Then we go on, and suddenly we have, she moves to Florida. But even in Florida, we have Irma come through, I think September 11th, that weekend. Mr. Benefield comes all the way down. He makes sure she has a generator if she needs for the storm. He then leaves, and she feels comfortable enough and well enough to go all the way back up to the home that she shared with Mr. Benefield to collect property and transport those items down to Florida for her own use, and without any fear that this gentleman is going to harm her when she's up there. One of the other things allude to as far as credibility problems were the issues concerning the split records that she's asking the Lakewood Ranch to have to, I guess, somehow cover any type of problems or contradiction there might be with the poisoning allegations, as well as the emails that were introduced today between the cousin of Mr. Benefield and Miss Benefield, I guess, trying to curry some kind of upper hand in the in either of these two cases against Mr. Benefield. Court's also going to find that the wife has at this time demonstrated a complete disregard for allowing Mr. Benefield to have any active role in the birth of his child and or the life of his child that he has now not had any contact with. Court's going to find there's been no violation of any injunction. The court did look at and has listened to the testimonies that were provided concerning the injunction that was entered. Quite frankly, it sounds like the court was when you listen to the transcript, was actually telling both of them they need to stay away from each other. And then certainly there was no violation of it whenever there was the oral pronouncement, only be followed by a written pronouncement. Court is also finds there are some issues with the credibility of Miss Benefield when she's actively sitting here telling this court she doesn't like to have publicity, but at the same token, she's participating in articles concerning the alleged poison, etc. As far as the last comment on poison,
Margaret.
there is not one piece of evidence, like I said, that has been
Hi.
established that even if she was being poisoned, that there has been
Hi,
a
Lori.
suggestion of a
Welcome.
nexus of the who, how, and where the poison. That would be rank speculation for this court to jump into the idea that
Sorry, I just put hand cream on my hand and now they're all like oily. I didn't want to touch the mouse, the computer mouse. Sorry. I would have paused it earlier, quicker. I'm glad you're here, Margaret. I'm glad you're here. Hi. I hope you had a good weekend. Better weekend afterwards. After Saturday, that is. Lori says, where did it go? Did they already pick the jury? So from what I gather, they have got the jury picked and the jury is ready. And I'm thinking that, yeah, I think opening statements are supposed to start tomorrow. But I'm still waiting on like if that's 100% confirmed, right? Yeah. Yeah. They said that the jury was ready. So hopefully, I would have thought actually that they would have started with opening statements today, but I mean, if the jury was picked as early as they were. Oh, this is old Lori. Yes, yes, yes. This is I mentioned it in the title of the video that this was a review of a previous hearing. Yes, 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 yes. But this is some we're just kind of like going back and checking out the information to kind of get geared towards getting ready for the trial to start this week. So that's what we are doing. That's what we are doing.
because it happened, it had to be him, especially when I have, in all senses, not a credible witness is the only person that's asking me to speculate. So with that in mind, the court is going to find that at this time, there is absolutely no evidence. And I'm saying no evidence. I'm not saying by the preponderance of the evidence standard, that hasn't even been close to, that there's been a indication that there's an immediate likelihood of domestic violence. There's only the one remote incident. And as of today, there's no reasonably prudent or logical person would think that you're the threat, that you're being threatened by immediate domestic violence. So for those reasons, the court is going to deny the request for an injunction in this particular case.
Good luck, Margaret. You got this, ma'am.
After
You
the
got
judge's
this.
ruling on the injunction, which would be the defendant's motion, did she make a ruling on your motions?
Yes,
And that was time sharing with the child?
it was time sharing and parental responsibility.
Okay. And what was the order, or what did the judge say Doug could do?
There was a temporary time sharing schedule that was
Oh, thanks for
increasing
coming
in
in, Deborah.
frequency and amount.
We'll see you this week. Glad to have you join us. I hope you have a great rest of your day today.
So it started with the first day that he was going to be able to meet his daughter just a handful of days later. After a period of time of seeing her according to the schedule, then it jumped up to weekend time sharing, overnight sharing. Then there was another jump. And so he was able to take his daughter back to South Carolina for time sharing. There was also, I believe, some extended visits,
There you go,
maybe
Margaret.
holiday related. But then
Margaret's
the
plan.
other main component of that order was with regard to shared parental responsibility, which again is the decision making. And Judge Moreland ordered
know.
that Ashley and Doug were to exercise shared parental responsibility so that they would have to confer and make a good faith attempt to agree on major decisions. But the court specifically ordered that Doug Benefield would have ultimate decision-making authority regarding health-related or medical issues. And the order made very clear findings about her extreme concern with regard to Ms. Benefield's medical decisions up to that point, which is why she ordered the ultimate decision-making authority.
And the concern was for the medical decisions for the child.
Correct.
So why is there an escalating frequency of visitation with the child?
Well, Doug had never even been allowed to meet his daughter. So she was, I believe, 6 months old by the time he met her. And so it's just appropriate that you don't just dump a baby with who was at that point a stranger.
Okay.
So it was just to grow and a reunification or a unification, I guess. There's nothing to reunify.
To get the child used to who she was going to.
Exactly.
Okay. So the first time sharing where there was an exchange
Time sharing.
and the daughter's name,
Her name is Emerson Grace Canny.
Oh, what a
and can you
pretty
spell the last
name.
I
name?
believe it's Caney. I have to double check my file to be completely certain.
And where were these exchanges of custody to take place?
Well, according to the court order, they were to take place at Manatee County
Right.
Sheriff's Office, and that's where the first exchange took place.
Were you present at the
Yes,
first exchange?
I was.
And did you arrive with Doug or were you separate?
We arrived separately. By the time I arrived, he was already there. We were both there earlier than the scheduled exchange time.
And was this the first time Doug was meeting his child?
Yes.
What happened during this exchange? Did the defendant ultimately show up with the child?
Yes, she did.
And just explain how that meeting went.
Okay. I had been sitting with Mr. Benefield in his truck, and when he saw Miss Benefield enter the parking lot, he moved the truck closer to the entrance to the building, and she was out in front of the building with the child. Doug and I then approached Miss Benefield, and I hung back a bit, and Miss Benefield saw me, looked at me, and then immediately said, "Are you dating her?" She was very indignant, very upset, and then I responded to that question. Of course, I said no. And then they proceeded to have a conversation where Doug was trying to engage with Emerson, talking to her, ultimately was able to hold her. And Miss Benefield was in very close proximity to Mr. Benefield, probably less than from me to the judge's bench, especially when she transferred the baby over to his arms. They kept talking for 5 or 10 minutes or so, and I kept waiting also there. Then Mr. Benefield turned to me and said, "Okay, we're going to go. Ashley's going to come." And so I pulled Doug aside. We had a communication about it. I warned him that it was not a good idea, given all the allegations that she had raised up to that point. And he said that he was aware of the concerns. He agreed with me, but he wanted Emerson to be comfortable. And he thought having Ashley there, as she was insisting, would help Emerson be a little bit more comfortable. So then I watched them Ms. Benefield strap Emerson into the car seat in the back of Doug's truck. She got in the back seat and they left. I, of course, just left in my own vehicle.
And approximately when was this?
This was September 21st
September 21st of
of 2018,
2018.
just a handful of days after the hearing.
So from this point on, at least from your perspective as the family lawyer, was there sort of a peace between the two?
Well, there was. In fact, they had an agreement that we memorialized into a joint stipulation to expand the time sharing that Judge Moreland had ordered. So within a handful of days after seeing his daughter for the first time, Ashley and Doug had a written agreement signed by both attorneys and submitted to the court that said, you get to see the child even more, exchanging the child anywhere they agreed. If there was no agreement, the exchange default would be at the Manatee County Sheriff's Office, but more frequently, not supervised by her. And that then was the norm for quite a while.
And how long did that last approximately?
About 11 months, I would say. From September of 2018 until August of 2019, they were together all the time. Doug's time sharing was always with Ashley present, so they were certainly behaving as a family. They were quite active on the social scene.
I was going to say, did you ever see them?
They're
I
supposed
did.
to be,
They were in
Margaret.
magazines. I think they were even in SRQ magazine at some kind of ballet gala event
Okay.
together.
So at some point, this piece did not last.
Yes, it did not last.
About when did things start to go
Ooh,
down?
that's a good question, Lori.
Unbeknownst to Doug, they were about to go
Good
downhill in
question.
August of 2019. He was scheduled to move in with Miss Benefield and her mother. So he kept an apartment or a little condo here
I don't
in
know,
the
but I'll be
Sarasota
here
area.
for it.
But his lease was running out. So they had agreed that he was going to move into their home. They moved all of his things inside to their home, emptied the storage unit of his contents into Miss Benefield's home. And the day he was scheduled to move in, as he always said, she ghosted me. She didn't answer the phone. And so I think it was August 16th of 2019 was the day that he was supposed to move in. And then suddenly everything changed.
Okay. So
Just for the record, you want to continue an objection to hearsay and relevancy.
Yeah, we're getting pretty in-depth with this whole situation.
okay, and I can move along.
Okay.
So at some point, did Ashley start filing complaints
Yes.
against Doug?
Yes. She started again. Yes.
And how many complaints were there, if you recall?
I would say a half dozen. They started, I think, in December of that year. And then they just kept on going for another 4 or 5 months. Oh, and there were complaints about the child.
Okay.
They were
So
not about her.
not about her complaints of abuse of the child.
Correct.
Okay. And at some point, did Ashley file for another injunction?
Yes.
And were you involved in that?
Yes.
Who, I'm sorry, as a part of that
I hope so,
investigation,
Patricia.
concerning those complaints and that request for an injunction, was a psychological evaluation ordered?
It was not ordered by the family court, but there was a psychological evaluation that was put into place through CPS. And I believe it was Detective Moreland.
No.
Okay.
Margaret.
So at some point, a psychological evaluation of both Doug and Ashley was ordered.
Yes.
And to your knowledge, Doug participated in that.
Oh, yes.
Who was that doctor?
Dr. Brad Broder.
At some point around this time, did Doug file for divorce?
He did. In November of 2019, we filed a motion for leave to amend and then a amended petition for dissolution of marriage.
Was that your case number? Did it run along with her injunction case number as we talked about before?
Yes, they were companion cases.
Companion cases?
Yes.
Okay, thank you. When was it set for a hearing?
Again, it was a hearing that was set and then moved a couple times. So I think it was originally set for hearing in May of 2020, moved to August, and then moved to September of 2020.
And do you recall the date in September?
It was scheduled for September 30th,
Okay.
2020.
Were you ordered to mediation first?
Yes. At Ms. Benefield's request, she filed a motion for mediation. The court entered an order of referral to mediation.
And during the mediation, were you present at the mediation?
Yes, we were all present via Zoom, but not in person because it's during COVID.
Okay, but the defendant was there
Oh.
via Zoom
Yes,
and Doug was there via Zoom
yes,
and the mediator.
yes. As well as Ms. Benefield's attorney was also present.
And who was that?
Faith Brown, at the time, she had been let go from her prior attorney.
So what did Ashley say at the mediation about their relationship?
Both of them said,
It's sustained.
What did Ashley say? It's the defendant.
This is during a mediation? Is there some exception? Mediations are generally private and confidential.
I can move on. I thought it was a hearsay. You're saying something else.
No, I'm assuming, you tell me what your objection is.
Objection,
Okay.
Yeah, I mean, I don't, unless you have some case law that there's an exception to the general, I'm going to say secrecy, but the privilege, the mediation privilege. I'm not aware of any case law, but you may have some that there's an exception in a criminal prosecution.
I do not, Judge. I'll move on.
All right.
At some point after the mediation, did Ashley agree to drop the injunction?
oh, she had agreed to drop the injunction before the mediation, but it wasn't just that she was going to drop it. It was a quid pro quo situation.
And what was the quid pro quo?
That he dismissed his divorce case and again, another emergency motion for time sharing for the parenting plan, and the joint motion to release the psychological evaluations conducted by Dr. Brad Broder.
Okay. And in fact, were those things all dismissed except for the psychological evaluation release?
They were not.
Okay. The hearing that was set for 9:30, what was to happen at that hearing?
There had been a lot of discussion leading up to that, and the plan was that the September 30th hearing would not be held on the injunction because the
I have never heard, and we were talking about this the other day. I think QB brought it up that they keep referring to their split, like their custody agreement, as time sharing. I've never heard that before. Like the only time I've ever, heard timeshare, it's about like houses when you go, or like condos or things like that when you go on vacation, like once a year. It's just weird.
agreement was that once the psychological evaluations were provided, then the injunction would be dismissed and the family law case would be dismissed. So the 30th hearing was supposed to be the joint motion for release of psychological evaluations.
Right?
And what day was Doug murdered?
So that he was murdered on Sunday, September 27th, 2020.
3 days before this hearing was scheduled.
3 days after the mediation, 3 days before the court date.
And who was the judge scheduled to be at this hearing on the 30th?
Chief
Not
Judge Diane
us at
Moreland,
all.
So the same judge that had heard the rest.
same judge.
Hmm.
In all of the times that you dealt with Doug, did he ever have what I would term like an overly angry demeanor towards Ashley in your presence?
No, which was kind of a source of conflict with Doug and I, actually. He was very passive, very accepting, and always looking for excuses or reasons, not angry. Just surprising. He was also very suspicious of her, but never angry.
Okay. And did he always blame her for everything, or?
No, not at all.
You're right, QB, too,
He
about
often
this whole
blamed,
the way she talks about him.
It's Dr. Hildegard Staninger, who was related to the Carlson labs, who obtained, involved with the poisoning
Sort of a
allegations
little bit
and
more
the lab results.
personal
But
than just an
no, not
attorney
always Ashley. He was
client
always trying to look for
relationship.
some explanation as to her conduct.
Thank you. I have no other questions.
Thank you.
All right, Cross.
Good morning, Ms. Murphy.
Good morning, Mr. Taylor.
You practice family law,
I do.
and you've been doing it, I think you told us, approximately 15 and a half years you've had your own firm?
I've been practicing family law for approximately 21 years, but I've had my own firm for about
Mm.
15 and a half years.
Okay. And in the
I
course
agree,
of
Lori,
your
me
practice, have you had the opportunity to represent both petitioners and respondents in domestic violence injunction actions?
I have.
I
And
wish
have
more
you
states would
represented
follow
them,
suit.
Ms. Murphy, strictly in family court, or have you also continued in representation in those cases where the disputes end up in criminal?
And when or if Delphi ever goes to trial, I would love to see that one. But not so sure that they're going to let cameras in.
Court as well?
Only in family court. I do not practice criminal law.
Okay, so on those occasions, you would refer it out.
Yes.
All right.
Exactly,
It's the
Patricia.
nature,
Bingo.
is it not, in family court matters that the litigation is often, shall I say, spirited?
It can certainly be the case.
Okay, it's not unusual.
It's not unusual.
Would it be fair to say that the litigation can sometimes, depending upon the parties, be quite aggressive?
Never to this level in all of my 21 years, but
Okay.
it can be aggressive.
All right.
This was
Delphi
extreme.
Fund.
And it can also be determined, can it not?
I'm afraid I don't understand that question.
Litigation in general, in family court matters.
Determined meaning,
Determined meaning neither side lets up. You have two people who fundamentally develop a real dislike for one another, and they just pour their heart and souls into the litigation.
yes, unfortunately, that happens.
Yeah. You know, they shoot more family lawyers than they do
You know,
criminal.
I've heard that. I think there's more violence on the family law floor than on the criminal floor.
the litigation can often be petty as well, can it not?
Sometimes,
Yeah, where you get two parties that are arguing over a pet turtle, for example.
right. I mean,
Oh,
this
hi,
was
Pastor
the opposite
One.
of petty, but
Yes.
yes, it certainly can be.
I don't think the
All right,
death
and
penalty
you
is in
are,
play
of
for
course,
this,
like
for this
all of
one.
us, an advocate.
Yes,
And in this case,
No.
you were an advocate for Doug Benefield,
yes,
and he paid you, did he not, to be his advocate?
he did.
But yeah, welcome in. Welcome.
During the hearing that we heard, the ruling for which I think it's a safe bet that the petitioner did not prevail. But would you agree with me that Judge Moreland did recognize that your client, Mr. Benefield, had fired a gun in the home when Ms. Benefield was present?
Yes, she said that in her
Yeah.
ruling.
And she also recognized that he had apparently punched holes in the drywall.
Patricia.
She did say that.
And in fairness, I believe Ms. Murphy, she
Sorry, I
dismissed
snorted.
firing the
Big
gun
yard
in the
snort.
ceiling of the kitchen as too remote in time.
I believe that's what she said, yes.
QB
And
live
as to
tweeting
the
from the
punching
courtroom.
holes in the
Yeah,
wall,
whole
I
lot.
think she said it was not directed at Ms. Benefield, but just out of frustration.
I don't remember that she said that. She certainly could have.
Okay. Having just recently heard it. So in cases of domestic violence injunctions, would you say what percentage of your clients are females and males that seek domestic violence injunction protections?
Well, I can't tell you if it would be my clients. I think in the cases in which I'm involved, the majority is the female client is seeking an injunction against the male.
Okay.
That's not necessarily indicative that the female is always a victim of domestic violence, because men can also be victims of domestic violence.
Yes.
Mhm. They
Now,
can. Look at Johnny
through
Depp.
your 21
I can totally see. I don't know what my child is out there doing. Her dad's home, but she's out here at the door. I don't know what she. It's exactly what I said, Patricia. Yeah, men can be victims of DV as well. Just look at Johnny Depp. Entertainment value alone would be worth it. So I can just see QB live tweeting from Delphi. And like the judge would throw her out. There's no way she could keep her composure. There's no way that she would be able to keep her composure. The judge would throw her out. I know it.
1 years worth of experience in family court. I'm sure you've come to learn that there's some stereotypical factors that seem to be rather common with a lot of abusers. Would you agree?
I do not necessarily agree with that. No, there are different types of abusers.
All right. Would you say that it's reasonably common in those instances where you've represented females seeking domestic violence injunctions against males, that the males are often controlling?
That is sometimes the prevailing foundation for why the domestic violence occurs, but not always.
Is that a yes?
No, it's a no, not really.
It's a no, not really, as opposed to sometimes?
Sometimes.
Okay. I'll take sometimes.
Okay.
All right. Have you had experience in those instances where you've represented females seeking protection from domestic violence, that the males are sometimes jealous and very possessive?
Judge, I'm going to object to this line of questioning is irrelevant.
I think it may be. I don't know. The witness can certainly say yes or no, or agree or disagree.
That is one of the most rare reasons for the domestic violence in the cases that I've had in which I've represented the women. So jealousy is usually not a factor or a major factor.
So you've seen it.
I've seen it, yes, but not often.
That was my question. Have you experienced in representing some of these females seeking protection for domestic violence against males that they have employed a strategy, which obviously has not been successful, of appeasement over the course of time, and finally it builds to a sufficient crescendo that they end up as a client of yours?
I have seen that.
Okay. And by appeasement, we mean, do we not getting along, going along for fear that the reprisal will be greater?
Yes, that is true for both the female victim, if you want to use that word, as well as the male victim.
Mhm. When you bring a petition for protection against domestic violence in the family court, are you foreclosed from returning and seeking a second petition?
Do you mean if a petition is denied, can you then file a different petition on the same allegations?
Not on the same allegations.
Okay, no, you're not foreclosed. You can file as many domestic violence injunctions as you would like,
Correct.
regardless of how many times they've been denied.
Correct. So in other words, you've had a domestic violence petition denied, and then 2 months later, additional acts occur. You are entitled to go back to family court and file another domestic violence petition.
Of course.
And in fact, have you done that on behalf of clients in the past?
I just want to clarify, I don't file petitions for injunction. So a party would file that on their own at the clerk's office. So my involvement is usually after an injunction has been filed. That is when my involvement begins.
And have you represented people who have gone to court multiple times? Or do you only go one time?
Oh, no, I could go multiple times. I just don't think that I've ever had a situation where I've represented the petitioner who has made multiple injunction petition filings. I've represented several respondents who have been themselves then the victim of spurious litigation and abuse of the injunction process by repeatedly filing injunctions.
When Mr. Benefield was living here in Manatee County, he had his own apartment. Is that correct?
He wasn't not living here full time, but yes, he had an apartment at times during this period of time.
You're not aware of any point in time where he resided with Miss Benefield in the home where the shooting took place?
My understanding is that he did not.
I don't believe I have anything further. Give me a moment, Your Honor. That's all, Your Honor. Thank you.
Thank you. Redirect?
No.
Can this witness be released?
Yes.
Mr. Taylor?
Yes.
All right. Maybe release from your subpoena. Thank you very much. State, you ready for your next witness?
The state would call Amanda Conlon.
Amanda Conlon. No clue who that is either. Do you know that my tweets would be none? There would be 0 live tweets because what happens whenever I go to things, I set my phone down and I don't look at it until I leave. I will not be live tweet. I'm like this the whole time, like watching. Everything's just soaking it all in. There would be no live tweeting. I would suck as no. Have a good night, Lauren. Good night. We'll see you later. I'll be out front. Y'all. You would be, right? Oh my God. I done forgot. I was supposed to tell y'all. Yes, good night, Lauren, and sleep well. We'll see you tomorrow. See you tomorrow, girly. Thanks for hanging out with us this evening, though. Love you.
Please stand right here facing court, raise your right hand, please.
Do you solemnly swear or affirm the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth? Thank you.
Okay, so this chick is the one that we watched because we watched part of this. We watched part of this the other day. This was the evidence photos. I remember this.
As the deputy said, make yourself comfortable. That microphone adjusts up, down, left, right, however you need it. And if you speak a loud, clear voice, we should hear everything.
Good morning.
Morning.
Please say your and spell your last name for the record.
It's Amanda Conlon, C-O-N-L-O-N,
And how are you employed?
Sheriff's Office Crime Scene.
And how long have you been so employed?
16 years.
And can you explain generally your duties as a crime scene technician?
To document the crime scene through photos, video, sketches, collect evidence, process evidence.
And did you obtain any education that helped you with that position?
Yes.
And what was that?
I went to St. Petersburg College for crime scene.
And did you get training once you began working with the sheriff's office?
Yes, we're sent to training all the time.
And so that has continued?
Yes.
Thank you. I want to draw your attention to September 27th, 2020. Were you working that evening?
Yes.
And were you asked to respond to a scene at 11331 White Rock Terrace?
Yes.
And is that here in Manatee County?
Yes.
And do you know approximately what time you arrived there?
About 8:28 that evening.
And pardon me, were law enforcement officers on scene prior to your arrival?
Yes.
And without telling me what you said, did you speak to them to kind of find out what was going on?
Right now.
Yes.
After speaking to them, what, if anything, did you do first?
I went next door to the neighbor to collect a gun.
And are these single family homes?
Yes.
And where was the neighbor's home in comparison to the home at 11331?
Right next door.
And did you in fact go over there?
Yes.
Okay. And did you retrieve a firearm?
I did.
Who did you retrieve it from?
From the homeowner.
Was that a Mr. Saint or Sant?
Yes.
And did a law enforcement officer accompany you to secure the firearm or make it safe?
Yes.
Okay. And who was that?
Ackerman.
And did he in fact secure it?
He did.
Okay. And did you observe it to be loaded?
Yes.
And did you observe what type of what caliber it was or what type of ammunition was contained in the firearm?
It was a .45, and Hornady was the brand of the bullets.
Hornady?
Yes.
Okay, thank you. Did you at some point enter the home at 11331?
Yes.
And was that as a part of the execution of a search warrant?
Yes.
And what's the first thing you do when you enter a crime scene?
Start taking photographs.
And do you document the entire scene first with the photographs?
Yes.
And then after you have documented the scene as it lays, what's the next thing that you do?
Then I would place down evidence markers of evidence throughout the house.
And those are the yellow tents that we often see in these photos?
Yes.
And is that the process in which you followed in this case?
Yes.
I'm going to show you what's been pre-marked as states 2 through 19. Will you review these and tell me if you recognize those items?
Yes, I recognize them.
And how do you recognize them?
They're photos that I've taken.
And with the exception of number 3, I believe that's a floor plan.
Yes.
And as far as 2 and 4 through 19, they appear to accurately depict the scene as you saw it the night you were there, September 27th, 2020.
Yes.
And then as to number 3, does it appear to accurately depict a portion of the home as you recall it from when you were there in September?
Yes.
Your Honor, this time the state would ask to enter states 2 through 19.
Got no objection.
Received.
Thank you, Your Honor. So let's first look at states 2, and I'm going to display them digitally before you. And can you tell me what we see here in states 2?
Let me just ask, instead of turning down the lights, Ms. Conlon, are you able to see these sufficiently?
Yes.
Okay.
It's a little difficult with the lights on for us to see it.
Oh, it is?
Yes.
Okay, fair enough. Thank you. I didn't want anybody nodding off.
Thank you. Ms. Conlon, I'm going to give you a pointer.
And again, sir, if you need to reposition anywhere around the courtroom, wherever you need to go to see, please feel free.
Ms. Conlon, what is it that we see here in states 2?
It's a firearm.
And what firearm is that?
I believe Is the 45?
And is that, it's back in your lab as opposed to when you collected it at home, is that correct?
Correct.
And we see a.
QB just dropped a link in the
magazine.
chat, you guys. She sent me something through Discord and I was like, wait, what is this? But yeah, it's super cool. So she says, y'all go get your trial bingo card. You mark things off as they are mentioned in trial and there are prizes. She put the link in the chat. She said it's vetted. A lot of the larger trustworthy creatives are doing it. So it looks like Defense Diaries is one of the sponsors. Pretty cute. And I think it looks like they did a previous one for the Karen Reed trial, and one of the prizes was a miniature CSI kit, and it had like a little miniature red Solo cup. Oh my gosh. So yeah, that's pretty cool. That's super cute. I love the whole thing. You get your own personal bingo card and it gives you the instructions. I'm doing it right now. You have to bookmark the URL. It's your unique bingo card. And then it gives you post a screenshot. Super cute. Super cute. Defense Diaries, J, publicly buzzed. Save the URL for your bingo card. Very cool. Very, very cool. How do you save the URL from your phone, though? I'm not very tech smart. Okay, I just took a screenshot of my card, but how do I save the URL? I don't know. Bookmark it or send the URL to yourself via text. Okay, there, I'll do that. I'll send it to my email. Hold on, guys. Send. Okay. Cherie said save it as a PDF. There you go. I just emailed the link to myself. So everybody gets their own individual URL, right, with your own personal card. So, that's super cool, though. That's super cool. And they're giving away merch. Like there's a Defense Diaries t-shirt. There was a t-shirt from Cellubrite, some other things. But yeah. All right, let's get back to this. Thank you, QB, for the idea. That is super cool. You just have to be able to get back to the URL to mark the card. I don't think PDF will work. Okay, well, there you go. And so what do? You just take a screenshot of your card with the bingo on it if you actually get a bingo, and then send that to Phil, I think it said. Yeah, we can play together. Fun.
It appears to have ammunition in it.
Yes.
And then the firearm, which has been locked back in a holster. Is that correct?
Yes.
And then there's one round laying in this picture. Would that be if it had been in the chamber?
Yes.
Thank you. I'm going to show you states 3. This is the floor plan we talked about a moment ago.
Okay,
it's
good
not
deal.
the complete home. Is that correct?
Correct.
When you entered the home, how did you enter?
I entered through the garage, which would be right in this area.
So that the laundry room has what appears to be 2 doorways. The bottom one would be an exit to the garage?
Yeah.
So when you approached the home, you walked through the garage?
Yes.
And what observations did you make? if
Yeah, they
anything,
said
of the
that
driveway or
earlier
the garage
today, I
that you
think.
There was a U-Haul truck, there was a pod there, there was boxes. You could tell they were moving.
And when you entered the home, did the home appear to be furnished, or did it appear as somebody had already completed much of a move out?
There was still a couch in there. There was still some furniture, but the majority was being boxed up and everything.
And we see 2 bedrooms here. Were there only 2 bedrooms in this home?
No, there's a third one, and it's past the living room and kitchen.
So
So
it would be the top of this picture.
yeah,
correct?
it would be up there,
And how would you categorize that bedroom?
the master bedroom.
And then we have 2 bedrooms here on the left, one being a child bedroom and then one being Miss Benefield's bedroom. As far as you know, is that accurate?
Correct.
What, did you enter the room called the child's bedroom?
Yes,
And what about it made you believe it was a child's bedroom?
because it had kids' stuff in it, kids' clothing.
Did you find anything of evidentiary value in that child's bedroom?
No,
Did you enter the bedroom that we have on this floor plan marked as Miss Benefield's bedroom?
yes,
And did you find things of evidentiary value in that bedroom?
yes,
And did you document that bedroom in the remainder of these states?
Yeah. Yes.
Thank you. What I'm going to show you first is states 4. Oh, sorry. Can you describe what we see here in states 4?
I'm in the corner in the back, just taking overalls. There's blood on the floor, and there's a bullet hole right here.
And I think we have a
Trigger
close-up of that
warning,
floor
trigger
once you
warning,
marked it.
trigger
Yes.
warning.
That hallway there, is that the hallway we saw on the floor plan that adjoined that child bedroom?
Yes,
And what is on the other side of this wall where you said I think you can actually see the bullet hole there. And then there's a socket on the wall. What's on the other side of that wall?
the bathroom.
This is states 5. Is this the same area in the bedroom?
Yes,
And the item or the area there, that's a closet with the bifold doors?
yes,
Okay, thank you. And when you entered the room, was the mattress up against the wall like that?
yes,
Had anything been moved or touched to your knowledge prior to you taking the pictures?
no.
Where are you standing in this is state 6. Pardon me. Where are you standing when you take this photo?
I'm in the doorway.
Where the one we saw, the bathroom would have been on your right.
Correct.
And we see tent markers here, 1 through 6. Is that correct?
Yes.
Can you tell me what was at tent markers 1 through 4?
1 through 4 are casings.
And did you collect those items?
Yes,
And do you remember the caliber of those casings?
the 45.
And were they also the Hornady?
Yes.
I think I'm saying it wrong, but.
I might be saying it wrong too.
And then I see here, there's a black tripod thing there in this top picture. What is that?
It's a light.
Okay. And that's something you placed or another crime scene tech placed there?
Yes,
And how about number 5? What is that tent marker number 5, which is near that tripod?
a projectile.
And then number 6, what is number 6 marking?
Blood.
I'm going to show you states number 7. Is this the projectile you said was at state or at number 5?
Yes,
Okay. And did you collect that item?
yes,
Now states 8, I think you're looking back towards that wall in the hallway. Is that correct?
yes.
And can you tell me what it is at state 7?
The hole right there.
And I'm just going to zoom in so you can. And there appears to be something below it other than your sticky number 7.
Yes,
And what is that?
it's a ruler.
Is that just for scaling?
Yes,
Thank you. I'm sorry. I got ahead of myself. Did you find any other holes other than state 7? There was what did you call it, bullet hole?
yes,
Yes. Did you find any other holes that corresponded with state 7?
yes.
Okay. And so can you tell me about those?
So they would be in the bathroom, in the cabinet. So I marked the one after that 8, and then 9 was the exit hitting the cabinet door, and then 10 is the actual on the other side of that cabinet.
So 8
Yeah,
would have been
somebody
the
should
back of the
let
cabinet.
Correct, yes,
Side 7.
Yes.
State
And
police
then it
know
traveled
that
through
too.
the cabinet door, which you did as 9 and 10.
correct.
And then did it ultimately land or strike somewhere and come to a stop?
Yes,
And where was that?
it's right outside the bathroom door.
So I'll show you states 9. Is this the frame of the bathroom door?
Yes,
And if you could just tell us what we see here,
it's going to be the projectile inside that hole.
and you mark that 11.
Correct.
This is states 10. What do we see here in states 10?
The trajectory rods, just to show the path of the bullet.
So those are something you placed there to make sure that was the same bullet that went through those holes at number 7 and 8, 9, and 10?
Correct.
And did you ultimately dig the projectile out of tent marker 11?
Yes.
And I believe states 11 is a close-up of that hole prior to your digging it up. Is that correct?
Yes.
And then what do we see here in states 12?
That's the bullet that I dug out at
Oh,
11.
welcome back,
Thank you.
Nicole.
Did you find any other holes anywhere else in the home?
Welcome back.
Yes.
Okay. And where was that?
Welcome
The living
back.
room.
Welcome
And did you
back.
document that?
Yes.
I'm going to show you states 13. Can you kind of orient us in the home? Or if I can switch back to the floor plan if it would help. But
No, that's the front door by 16. So it's like right in the living room
Oh
area.
no, are you having storms,
And now
Nicole?
that wall that we're looking at, is that, I see a window, so that's an exterior wall of the home?
Yes.
And where would the bedroom be in this photo? Or not in this photo, but where would the bedroom be in comparison to where this photo is taken?
Behind me.
And what is this small brown item? I believe we see it in states 14.
It was struck by the bullet.
And it's some kind of canvas thing.
Yes.
So this is states 14. And then states 15, is that the bullet that traveled into the living room wall?
Yes.
And you collected it?
Yes.
I'm going to just go back to states 3. If you could kind of show us on this diagram where that bullet strike was.
It would have been right here.
So that's the door we saw and the window we saw.
Right. Yes.
Thank you. Did you find and collect any other firearms in this home?
Yes.
And how many?
2 others.
And where were they located?
One was in the bedroom with the blood, in the closet, in a backpack.
And so I'm showing you state 16. Is this the closet you're talking about?
Yes.
And where's the backpack?
Right there.
And then I believe state 17, is that the firearm in the backpack?
Yes.
Thank you. You said you found 2?
And then one was in the kitchen pantry.
And I'm showing you states 18. Is this a portion of that kitchen pantry?
Yes.
And where was the firearm?
It was below that picture. Yes.
And so we see a basket here, and then this is another
That's
basket.
one. Yeah, that's one. Yeah.
And so states 19, that's a firearm.
Correct.
Oh, hey, honey, where's that pistol at? Oh, it's up there next to the Jif peanut butter.
Okay, and you collected both of them.
Yes.
Were they both loaded?
Yes.
Did you locate any cell phones in this home?
Yes.
And did you collect them?
Yes.
I'm going to show you what's been marked as states 20 and through 22. Judge, these are entered by stipulation number 2. But are these photos you've seen before?
Yes.
And is it your understanding that they were taken by first responders when the victim was still on scene?
Yes.
And I didn't ask you, but when you arrived, had the victim already been taken away by EMS, to your understanding?
Yes.
Not the Skippy, the Jif, Margaret. Big difference. Big difference.
Were you ever given any information by law enforcement to help you in your investigation about why there was a drag
Not
mark?
chocolate QB.
Yes.
And what was the information that you were given?
That's they had pulled him out to start working on him.
And is it your understanding these pictures were taken in the bedroom prior to that?
Correct.
Your Honor, they were entered by stipulation, but the state would ask to publish.
All right.
20 through 22.
Choosy moms do choose Jif. You're
Sorry.
right, Margaret. Yes, ma'am. Absolutely.
I have them here if you want on the screen or not, either which way.
I can look at them here.
Okay, thank you.
Okay.
Peter Pan, Peter Pan.
On the night of the incident, did you have any involvement with the defendant, Ms. Benefield?
Not that night, no.
And was it your understanding that another crime scene tech took photos to document her appearance on that night?
Yes.
And who was that?
It was Megan.
And Your Honor, I believe these are entered by stipulation number 4, but Ms. Conlon, would you take a look at states 23 through 26 and tell me if those are the photos you understand? It's Megan Dvorak, is that
Correct. Yes.
she took those?
Yes. These are Megan's pictures.
I'm
Your
not
Honor,
even gonna
state-
lie, you guys. You can tell me if I'm a bad mom, but we go through a poop ton of peanut butter at my house, okay? We go through a lot of peanut butter. And um we buy the Great Value brand. Um we buy the Great Value brand peanut butter for the kids, but if I eat peanut butter, if I want a peanut butter sandwich or if I'm making like a special, you know, cooking for the holidays, I use Jif. Sorry. Mm. QB's like, I'm thrifty. I buy what's on sale. Well, I mean, if my children ate a normal amount of peanut butter, then, you know, I know, right? If my children ate a normal amount of peanut butter, I would buy Jif all the time for all of them, for all of us, right? But because they live and breathe and go through so much, yeah, we buy the Great Value. They do eat a lot of peanut butter. Mhm. I have a secret stash of Jif. What else do you keep from them? Basically, that's it that I can think of off the top of my head. If there are particular, like, Little Debbie cakes that I like over if we have, like, 2 or 3 different kinds, I will offer them the ones I don't like first. But that's really it. That's really it. They get everything else. They get everything else. No, that was strictly for me. That was strictly for mom. That was mom's jar, and it was a tiny jar and very expensive. The chocolate Jif peanut butter was really good. Notice I said was because it's gone.
They would ask to publish them. Would you like me to do it on the screen or would you like to just look at them?
Just to confirm, there you are. 20 to 22 and 23 to 26 are stipped in.
Yes.
Same,
They'll be received.
Thank you, Your Honor.
other than Jif. I like Jif.
And Ms. Conlon, later, were you asked to document Ms. Benefield's
Mhm.
appearance again?
Yes,
And do you recall what date that was?
it was the first.
Of October?
Yes,
And where did you go to do that?
at the sheriff's office.
And did you in fact take photos of her?
I did.
Aw,
I'm gonna show you states 27, 28, and 29.
Yes,
And are those the photos you took of her on October 1st, 2020?
yes,
And do they appear to
that's
fairly and
sweet.
accurately depict her appearance that night?
yes.
Your Honor, the state would ask to enter
Definitely.
27 through 29.
Any objection?
No, Your Honor.
Received?
And while you were there, did you observe any injuries to her body?
Some scratches, light bruising.
And this is 27, is that taken October 1st?
Yes,
And then this is 28, are those the scratches you were talking about?
yes,
So
And
these
29?
injuries
yes.
that she has are, I don't even know if I would call them injuries, but
Did Ms. Benefield complain of any injuries to you that night?
She never spoke.
Thank you. I don't have anything further, Judge. The defense may.
I mean,
I just
literally,
want to correct something before the defense.
the injuries that she, the scratch was barely even visible, and the I don't know. Again, I don't want to say anything. Um, I tend to want to believe someone when they say that they have been a victim of DV. Um, but yeah. Mm, Yeah, that scratch was old. Oh no, Kel. Mm. QB says, I don't either, but she's hard to believe. Yeah, I know. Mm.
That's crossed. The picture that came in as State's Exhibit number 2, it was my fault. I switched the pictures on accident. That firearm is the one that was found in the backpack in the closet, not the one that was found in the neighbor's house. But all the testimony about the neighbor's house and the gun being at the neighbor's house is accurate. It's just the picture is a different one.
Okay.
Mm.
And
Nicole.
are you gonna need the pictures or do you want the lights back up?
I think for right now, we could have the lights back up, Your Honor. I
Absolutely.
may request that they go down.
Just let us know.
Do you want the hard copies?
No, Jack.
You know that gnat came from China, right?
Deputy Colon,
I'm not a deputy, I just was a crime scene tech.
crime scene tech. How shall I address you? Miss Colon?
Yeah, that's fine.
I have a few questions for you. No heavy lifting. I first want to ask you about crime scene.
Mhm.
Your purpose as a crime scene technician is to arrive and document as accurately as possible the circumstances that you find.
Yes,
And traditionally, ideally at least, you should be the first one that enters the crime scene, if you will, so that what you document is an accurate depiction of how it existed at the moment.
correct.
Mm.
All right. In this instance, that wasn't particularly possible, correct?
Correct.
All right. And in fact, before you arrived, Douglas Benefield, who subsequently was deceased, he was moved in an effort to be worked on by not only the deputies on the scene when they first arrived, but by the EMS people as well.
Yes.
All right. So in your documentation of this scene, anything that might depict certain things could have been modified based upon prior efforts inside the crime scene.
Correct.
Now, you told us approximately, I realize going from memory is difficult. Did you write supplementary reports?
I did.
Okay, do you have them with you today?
I do.
Good. Can you tell us approximately, feel free to refer to your notes if necessary. Can you tell us approximately what time you arrived on the scene?
Approximately, it was 8:28
8:28
in the evening.
in the evening,
Correct.
PM.
PM. Yes.
And your reports, Ms. Colon, would they document what time the incident was reported or alleged to have occurred?
Not in my report, but I had the notification time that I was called, which
Yeah.
was going to be 19:37, which is 7:37 PM.
7:37.
Correct.
Okay. And would it be fair to say that notification to crime scene goes out pretty much immediately?
Correct.
All right. Because once again, you want to be first on the scene to be able to preserve it.
Correct.
Okay. So in this case, assuming that the incident occurred sometime close to 7:37, you arrived approximately an hour later.
Correct.
All right. You said something in your direct testimony that was interesting. You had entered the residence pursuant to a search warrant.
I have to wait for the search warrant. The residence I entered was the next door neighbor's residence
Yes.
to collect the gun. But
Yes, but for purposes of the incident where the shooting took place, you entered after being notified that the search warrant had been secured.
correct.
Okay. So this is what I want to establish. If you got notified of this incident at 7:37 and you arrived and entered at approximately 8:28, approximately an hour later, somewhere in between that time, a search warrant was drawn up and provided to a judge who signed it to allow you to enter.
Correct.
That's some pretty fast work, no?
That's pretty typical for our agency.
Okay, so in other words,
They're pretty used to writing them pretty quick.
okay, so the incident happens, bing, bang, you put the search warrant together and you're in.
Yes.
Okay. Now, just so we're clear and there's no confusion, and I don't mean to imply in any capacity that there was any sleight of hand involved. The actual weapon that was pictured in the slide was the gun that came out of the backpack,
Correct.
which I think is a 6-hour.
The backpack was a 380, yes, 6 hour, I believe.
380.
It was a 380 in the backpack,
Right, not the 45.
not the 45.
Okay. And the photographs that were taken of Miss Benefield, some were taken that evening, correct?
Correct.
And then there was another opportunity to take a second set of photographs a couple of days later on October 1st.
Correct.
And why would there have been a second set of photographs taken on October 1st?
To see if any more bruising would come up, better pictures.
Yeah, in other words, a lot of times bruises are not readily apparent immediately and they develop over the course of a day, 2, 3 days.
Correct.
Okay, now, give me just a moment, please. Okay.
Oh, wow. It was still alive? Well, then it didn't come from China, Nicole.
All right, Ms. Conlon, I want to ask you a few questions with the help of my very able-bodied assistant, Mr. O'Keefe. And we're going to put a few of those photographs up. I want to
Hi,
ask you
Eddie.
some questions
Welcome.
about them.
If you're going to
Others
refer
notice
to
how
any that are
fast
already
some
in evidence,
LA
I prefer
officials
we use
talk.
the ones that are already marked. If there's additional ones, then obviously
True. However, keep in mind, we've got this one going at 1.25 speed because this is a hearing, the stand your ground hearing from a while back. But I do agree. Some people talk quick.
you can lay the predicate or
Welcome,
get a
welcome,
stipulation for
welcome.
admissibility.
Welcome, welcome, welcome. You are absolutely welcome.
I just want to see.
Some people are fast, slick talkers, right? Others, not so much.
I gave him all of that state evidence.
You hope your interview goes on at 1.25. Good luck with that, Margaret. Good luck.
She does.
If you're looking for 23 through 26, those are here. These are photos of Miss Benefield.
I didn't know that was his
And my notes
paralegal
reflect
at
that
first,
23 through
QB. I thought
26
it was just
are photos from the
another
night of the incident.
Yes.
um,
Thank you.
another one of her lawyers. But all right, I'm gonna fast forward.
Good. All right, Ms. Condon, let me direct your attention to the exhibit that is now up on the Elmo. I want to ask you, with respect to Ms. Benefield's left side of the face, specifically the left eyelid, does that appear to be the same size as the eyelid on the right, or does it appear to be swollen?
Objection.
Yeah, I'm going to sustain. I mean, I can see that for myself. I don't need the witness to narrate what the evidence is, unless there's something specific that you want to draw out about it.
No, that's fine. The only other question I was going to ask was about the left cheek, Your Honor.
Okay, but I also think that she didn't take these.
I understand.
Okay, go ahead. So I'm going to sustain.
Okay. With respect, Ms. Malone, to Ms. Benefield's left cheek, do you see that as swollen as compared to the right cheek?
Sustained.
All right. Next.
Like this
This
photo
was a
here,
photograph that was taken.
I don't even, that photo right there, talking about the scratch that she supposedly got because of whatever with the box. I don't even, you don't even, can you even see anything? I don't even see anything there.
When?
That was the night, the first night.
Okay. And this was taken by you?
No, that was taken by Megan.
By Megan. Are you familiar with this photograph?
I am.
All right. Does this photograph, it's hard to depict in this exhibit under the Elmo. Does it show whether or not the scratch?
Objection, Judge.
Yeah.
Well, I understand, but let him finish the question. I don't know where he's going. It's not uncommon for lawyers to start this way and make a, not wrong turn, but left turn.
I'll
Go ahead.
withdraw the question.
Oh, no, ask your question, please, but I don't know where it was going.
I understand, but I also know what the ruling is, so.
If it's just to
I
narrate
had a
what's
concern for the court.
He's like, nah, I'll just go on because you're going to say no anyway.
It's time.
yeah,
I
I
understand.
mean, and then you can argue that certainly,
I'll be able to argue it. tomorrow.
absolutely,
Yeah,
100%.
Okay, thank you.
Redirect?
Yes, briefly. Ms. Conlon, in your many years at the sheriff's office, you've responded to homicide scenes regularly.
Yes.
And is it your understanding from your experience that a lot happens prior to your actually getting called out?
Yes.
And so if you get a call out at 7:37, you can't say how long law enforcement had been on scene prior to your getting there, can you?
No.
Because in theory, patrol arrives first.
Correct.
And at some point, there's a determination that there's a homicide before the homicide unit gets called out.
Correct.
And are you next in line after the homicide unit?
Yes. Yes.
And you're not the person writing the search warrant. You just wait before you enter.
Correct.
Okay, thank you. Nothing else, Judge.
Sir?
Nothing further.
All right, can this witness be released, state?
Yes.
Mr. Taylor? All right, maybe releasing your subpoena. Thank you very much. Oh, yes.
But Your Honor, we have her under subpoena for tomorrow also.
Oh, well, hold on then. All right, ma'am, apparently you're still under subpoena. All right, so remain available. Thank you. Go ahead.
State and call Dr. Vega.
Oh, you know what? Let me check real quick. Ms. Sarah, how are you doing? All right, if you need a break, you let me know.
Appreciate it. It's my intention to put the pictures up on the screen. Because I don't think you can.
Yeah, that's her, Nicole, right there with the brown hair.
I can see right here. I'm not going to get in the way of you presenting your case, but I'm fine if you want to put them on the overhead, and I'm fine if the witness is sitting right here, and Mr. Taylor could approach as well and see exactly where things are being pointed to without putting up the photos. Either way.
Just to remind Your Honor, we have the downward motion pending as to this witness.
Correct.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
Yes, I do. Well, Dr. Vega is sitting down. The way I read the motion was specific to one particular injury. So let's do this.
Whoa,
When we
camera
get to
dude.
that point, and please feel free to disagree if you want. I think when we get to that point, object, so it's preserved, you have your contemporaneous, let the testimony finish, then you can cross on that, and then whether if I let it in, it's all there. And if I agree with you that the foundation hasn't been laid, or it's otherwise not admissible, then it's still proffered and it's in the record. Would that be okay?
Yes, sir.
Okay. Hello, sir. Make yourself comfortable in the chair, 12 to 15 inches from the microphone. Loud, clear voice will pick up everything, and it does adjust up, down, left, right. Thank you.
Thank you, Your Honor.
Good morning.
Good morning.
Please state your name
My name is Russell Scott Vega. The last name is spelled Vega.
and where do you work?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Manatee County, where we are now.
And what is the 12th Circuit?
It includes 3 counties,
I saw
Manatee,
that
as well
TV.
as Sarasota to our south and DeSoto County to our east.
And you said Chief Medical Examiner. So what does that mean?
That means in the medical examiner's office, I supervise the other medical examiners. I set policy. I basically manage the office.
You're the boss.
Yeah.
Okay. And what is your education to do the job that you have?
I started in undergrad majoring in physics and biochemistry at Florida State University. Then I went to medical school after that, University of South Florida in Tampa. After medical school, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology, and then a year of subspecialty training in forensic pathology.
Hold on one second, I'm sorry.
Your Honor, out of respect to the court's time and to Dr. Vega, whose credentials I'm familiar with, we're happy to recognize him as an expert.
All right. Do you willing to stipulate or accept that stipulation?
Yes, I do have a few more questions about specific things that he's done though.
Okay.
Okay. And how long have you been the Chief Medical Examiner, if I didn't ask you already?
It will be 20 years, October 1st.
Okay. As part of your duties as a Chief Medical Examiner, do you still perform autopsies and do the work that your other medical examiners would do?
Yes.
How often would you say you perform autopsies?
I'm on the schedule every month, so not necessarily on a weekly basis, but certainly on a monthly basis.
Okay. And over your career, how many autopsies would you say you've done approximately?
Yeah, I don't have an exact count, but probably in the 3,500 to 4,000 range.
Okay. How many of those approximately would you say are gunshot wounds or contain some aspect of a gunshot wound?
It's in the hundreds, but I wouldn't be able to tell you more than that.
Is wound interpretation part of your duties as a medical examiner?
Yes.
Okay. And what exactly is wound interpretation other than exactly what it sounds like?
It's being able to examine a body and identify injuries present on or in that body and be able to,
I really thought they were already seated.
in that identification, determine
Oh,
what the
no.
nature of the injury is, possibly what kind of implement, tool, or weapon
Earlier
was
today, I
associated with
heard
inflicting that injury,
Weird.
and other things about the nature of the injury, such as when it occurred or things associated with the circumstances under which the injury was sustained.
Okay. Did you do the autopsy of Doug Benefield?
Yes, I did.
And when was that?
That autopsy was on September 28th of 2020.
Okay. And generally on Mr. Benefield, how many wounds did you find?
I found 2 clear gunshot wounds, 1 possible gunshot wound, and then 2 other separate smaller injuries, 1 to the head and 1 to the back of the thigh.
Okay. Were pictures taken during this autopsy?
Yes.
Okay. I'm going to show you States Exhibit 30 through 38. You can just take a look at these.
Margaret, best of luck, honey. Best of luck and prayers that it goes well and that if it's the job for you, that everything is smooth and seamless. Okay. And if, we are still anticipating your greeting card business, ma'am. Not even kidding. I'm serious about that too. Just saying. Looks like it's a go so far, unlike the one on Thursday that pulled the interview 15 minutes before the call started. Well, please let us know how it goes, okay? Because we'll probably still be here. Yes, right, Patricia. She says, remember, you're interviewing them just as much as they are interviewing you. Yes, in her poetry book. I'm looking into starting an Etsy greeting card shop with my poems. Yes, ma'am. Have a good interview. We'll be watching for updates. Love you. So cute. Her poetry book.
Why it's not coming on? Oh, because I think it's set to that. Do you recognize those?
I do.
And what are they?
These are photographs that were taken at the time of the autopsy of Mr. Benefield.
And do they accurately reflect the autopsy as you recall, parts of the autopsy as you recall?
Yes.
Statement entered evidence states 30 through 38.
Objection?
QB, before we continue, do you know if they actually show anything? Do you remember? I do have the trigger warning up, but I also don't want to have to like see something if we don't have to see something. You know what I'm saying? You don't remember? Okay. All right. Well, we'll play it by ear.
Received. Are you going to publish them now?
Yeah.
Folks, the state is about to publish photographs that were taken during an autopsy. I would imagine that most people here probably have never attended an autopsy or seen photographs from an autopsy. I didn't see them, but I don't think they're the full autopsy.
No.
I would assume they're external
Yes.
photographs.
Yes.
However, for those of you who may have an emotional connection with this case,
Have a good
sometimes
night.
these can be very difficult
Good night,
to
Nicole.
look at. So if you think that you might have some difficulties, I'm not worried. Sometimes I'm worried about a jury and an emotional response. I'm not worried about that. But just to avoid any distractions, if anybody thinks that they might have a reaction, please feel free to step out for a few minutes and then we can step right back in. All right, go ahead.
Thank you. I'm going to show you State's Exhibit 30 just so we understand who we're talking about.
They did it.
The
Dang
patient, Doug Benefield?
Yes, this is a photograph of the decedent,
The decedent.
Mr. Benefield, from the sensory
Sorry,
mid-chest
I'm blocking it out.
And I'm going to show you the next exhibit, State's 31. Can you tell me what we're looking at here?
Yeah, so this is the decedent's right arm and the right side of his chest. And this shows two injuries, really one superficial injury to the right arm. And I can use the laser pointer if you like. Okay.
Judge, this is the one that's the subject of the motion.
Understand, I'm going to reserve on the objection. And once I hear it, then I'll make a.
So I'm blocking it out just because. But yeah, I will be leaving this up until they're done with that part. So I can't make the overlay any smaller. So you're just going to hear me. And you're more than welcome to go to Law and Crimes Network's YouTube channel and watch this in its full on whatever. But yeah, I just don't want to have to go back and edit these photos out. And you get it, right? You understand.
A final ruling, but yes, noted.
So we see two injuries here, one on the chest here and one on the right arm. The chest really is a more complex injury. There are really three components here. There is what was circular gunshot perforation here. There is an incision that was made by doctors who were treating him in life-saving measures that was made from the edge of the gunshot wound downward here. That was to insert a chest tube or tube to relieve pressure and blood from the chest cavity.
And I didn't ask you this, but sometimes people are pronounced deceased at a scene, and sometimes that happens at the hospital after.
I'm going to scooch past this. Hold on. Oof. Hold on, folks. I appreciate your patience. I'm just going to scooch past these autopsy photos because I want to be able to get the overlay off the screen and get back to the video so you guys can see it. As I mentioned, if autopsy photos are your jam, that's fine. I will post the link in the chat, or one of the moderators can if they are able to. I'm still scrolling. Hold on, folks. Hold on, folks.
Such an inquiry. Is that a fair assumption?
On an individual case, it would probably be difficult to remember every conversation of that type. Yes.
Okay.
I think we're good now.
And the scalp wound that you told us about is the type wound that you said is consistent with
Just in
somebody
case.
falling and
I'm a
striking
little
a hard
bit
surface.
gun shy right now.
May I?
Oh, wait. They're using a doll. Hold on. This is kind of, you
Using
don't
this
never see this
anatomical
anymore. Hold
doll,
on.
if I can.
The defense is using a doll here to kind of show.
And for a moment, I want to ask you about the leg wound. May I approach Dr. Vega, Judge?
Yes.
So while I was impressed with how easily you were able to put your leg up on the bar, using this anatomical dial, if the individual that was shot was falling backwards and their legs went up in the air like this as they went back, would the trajectory of that leg wound be consistent with a shot to the leg that would go on the inside of the calf and exit on the knee?
If the leg were raised above the plane of the body while the body was falling, there's probably a location at which that angle could be produced. And I want to make sure I got the right predicate here, if you will. You're sort of assuming from the same position that the initial shot to the chest would have been fired. Is that accurate to say?
Well, again, like you, I can't say what the order was, but if there was a loss of consciousness and incapacitation and the individual were to start falling backwards, at some point in time, would the leg not be up where it would be consistent with that angle?
In addition to the body falling backward, the hip would have to be flexed and the leg would have to be brought in front of the rest of the body. If that were to happen, then yes, that angle could be produced.
The last question I have for you, Dr. Vega, is I want to ask you about the study of wounds. As a medical examiner, you're constantly called upon to examine various wounds and extrapolate how they were incurred, correct?
Yes.
All right. And that is, correct me if I'm wrong, a science in and of itself, is it not?
I mean, it's a field of study, so I suppose the term science is appropriate, yeah.
So we have, for example, crime scene people who study wound ballistics and the interaction between a projectile moving at a high rate of speed and human tissue and skin. Those are some of the things that you're called upon to interpret as well.
Yes.
Okay. Give me just a moment, Your Honor.
Of course.
Last question, Dr. Vega. Back to our scenario of the shot to the leg. Hypothetically, if somebody were to throw a karate kick with their leg or an attempt to kick, might that also be consistent with the trajectory of the bullet to the leg?
It would have to be a unique kind of kick to, from the front in a standing position, be able to expose the back of the leg. But I suppose it is possible if the leg were raised high enough that the back of it were exposed to the person who's facing that individual, that it could happen.
Thank you. Nothing further, Your Honor.
Yes, sir. Any redirect?
No, thank you.
All right. Can this witness be released?
Yes.
Yes, sir.
All right. Do you also have him under subpoena? Do you going to need him back? Usually when I say released, I mean the witness can go.
Yeah,
So-
we do not have Dr. Vega under subpoena.
All right, sir, you're releasing your subpoena. Thank you very much.
Thank you, Your Honor.
Is that yours or is that our clicker?
That's your clicker.
Okay,
Yes.
thank you.
Bye.
You okay? All right. Yes, ma'am, go ahead.
We have another witness that is fairly quick, or we can break.
I would just keep going through, but I'm known to do that and it's not well received. So how long do you think? I mean, I know for your direct, but I don't know how long the cross is going to be. So who is it?
It's a unit manager, the crime scene tech, Rich Talbot,
Oh, Mr.
and it's
Talbot.
just as to the stippling or lack thereof on the shirt. I have about 6 pictures.
Yeah, I think we can do that.
All right. Miss Sarah, can we do one more?
Yes, sir.
Do you need to stretch for a minute?
No.
Okay.
Thank you.
All right, let's get this witness done, then we'll take a lunch break.
Thank you, Your Honor. The state would call Rich Talbot.
Mr. Stand right here, face the court, raise your right hand, please, Swan.
Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth?
I don't mean to put you on the spot. Any issues with education, training, experience?
Maybe.
Okay, so let's go ahead and put that all on. Go ahead, ma'am. Sir, as the deputy said, 12 to 15 inches from the microphone, loud, clear voice should be fine. If you need to adjust it, please feel free to do so.
Okay, thank you.
Good afternoon.
Hello.
Please state your full name and spell your last name for the record.
Rich Talbot, Talbot,
And by whom are you employed?
Manatee County Sheriff's Office.
How long have you been so employed?
For about 23 and a half years.
And what are your duties with the sheriff's office?
I'm in charge of the crime scene unit, so I run the day-to-day operations of the unit. And that can entail anything from assigning and reviewing cases to responding out to a crime scene. I'm responsible for supervisory type issues. And then sometimes I also do crime scene processing as well if they need it.
So sometimes you function as a crime scene tech?
Yes.
And how long, your whole 23 and a half years, has that been as a crime scene tech or there in the manager?
Yes, I spent 2.5 years as a regular technician and I was promoted to supervisor.
And during the whole 20 plus years after becoming supervisor, you've continued to work as a crime scene tech?
Yes.
And can you tell me a little bit about your education to become a crime scene tech?
Yes, I have a degree in criminology, a bachelor's degree in criminology. And once I got hired here at the sheriff's office, they have sent me to, I have about 300 to 400 to almost maybe 500 hours of job specific related training courses.
And has that continued throughout your time at the sheriff's office, even more recently when you've been functioning as a manager?
Yes, a lot of the time was in the first probably 10 to 15 years that I was here, and then, but our training goes more towards the newer technicians now, and now it's more supervisory type classes that I attend.
Yes, sir. And has your training included using an infrared camera?
Yes, I attended a training class for that.
And what is an infrared camera?
An infrared camera allows you to actually create a contrast between the surface that you're looking at, the item, may it be clothing or skin, and it creates a contrast and it takes some of the colors out of the item you're looking at, and the substance that may be on the clothing or on the skin, it enhances that.
And that's a type of camera the sheriff's office possesses?
Yes, we do have one.
And you have used it regularly over the years for testing?
Yes.
And do you have to use an alternate light source? That's a mouthful for me, I'm sorry. To take the photos, or is it something that the camera does itself?
No, the
The camera actually, there's filters put on the end of the camera lens, and we hold a small infrared flashlight that actually you shine on the surface of the object that you're looking at, and then the camera takes the picture.
I see. So we'll come back to that, but I want to take you back to September 27th of 2020. Were you working that day or on call at least?
On call.
Okay. And did you respond to a scene at 11331 White Rock Terrace?
Yes, I did.
And was that as a supervisor?
Yes.
But while there, did you assist crime scene tech Amanda Conlin in some of her scene processing?
Yes, I did.
And did that include the trajectory rods?
Yes.
And so on that date, were you present the entire time Ms. Conlin was there processing the scene and learning along with her?
Yes, I was.
Thank you. Did you at some point a couple days later return to the scene to do some additional work?
Yes, we did.
And what was that for?
That was to go out and complete a scanning of the crime scene utilizing a ferro-terrestrial laser scanner.
And was that completed by yourself or another crime scene tech while you were there?
The main person completing that was CST Rudolph.
On about a week later, I guess, on the 6th of October, were you asked to actually process some items in the lab?
Yes, I was.
And what were you asked, or what did you assign yourself to process?
Essentially, there was a shirt that the victim in this case was wearing at the time of the incident, and I was asked to examine that shirt for any gunpowder residue or anything like that, stippling.
And what is stippling? And let me ask you this. Through your time as a crime scene tech and the unit manager, have you dealt with a lot of gunshot cases?
Yes, we have.
And have you received training and experience in things such as soot and stippling?
Yes, the training and experience is a lot of different cases that have involved that.
Yes, sir. Okay, so what is stippling?
Stippling is small particles that are that come out of the end of the barrel of the gun, from the ammunition, and depending on the range of the gunshot, the firearm from the surface of whatever it's striking. It's basically small particles that will show a pattern or of burn marks or little particles that land on that surface.
Because correct me if I'm wrong, when a gun is fired, I call it a bullet, the projectile leaves the end of the barrel.
That's correct.
And with it, gunpowder, which has made it go bang, might also exit.
Yes.
And is it your understanding from your training and experience that at certain distances that gunpowder could land on a victim or clothing on the victim and leave some residue?
Yes.
It's a bit leading, so.
Okay. And so what is soot?
Soot is just a like a burn mark or something like that the powder is leaving on the skin or the clothing or stuff like that.
And would that be the same where the powder, just expand a little bit on the powder from?
The firearm.
Thank you.
Or from the ammunition.
Thank you, sir. And did you in fact process the victim's shirt in this case?
I did.
And did you document using a regular camera and or an IR camera?
Yes, both. We took photographs of the shirt with a regular camera, and using the infrared camera, we took photographs of it.
And could you explain a little bit more about the process? You said there's different filters. Could you just explain so that we can understand exactly what that means?
Yeah, there's the camera kit that the IR camera uses comes with 3 different filters, I believe, and there's different levels of the light, the amount of light that it allows in from the infrared flashlight. So there's different levels of the filters that will allow it to see different light.
And based on the different levels of light and the different filters, what occurs to the item you're examining?
Depending on the filters, the more light that lets in, the more the the filter will allow more light in, and the shirt, you're looking at a shirt in this case, the colored background will fade away more using the different filters. You have different levels of the background that's taken out. And then the substance that's left on the shirt will absorb the light and basically create more of a contrast between the substance that's on the shirt and the background color of the shirt.
And Mr. Talbot, I'm going to show you 39 through 43 with been pre-marked as state's exhibits. Would you take a look at those pictures and tell me if you recognize them? I don't know. It's 39 through 44. I may have misspoke. I'm not sure if I said 43 or 44.
Yes, I recognize them.
And how do you recognize them?
They're the photographs that I took on the shirt that day.
And do they appear to fairly and accurately depict the examination you performed on October 6th of 2020?
Yes.
Your Honor, this time the state would ask to move in states 39 through 44.
Any objection? Received?
And may I publish them?
Yes.
Thank you. Mr. Talbot, there's a laser pointer there if you need it. And
Thank you.
I'm going to steal it. If you don't mind. I'm showing you what's state, sorry, this is states 39. Can you just kind of describe for the record what we see here?
This is just an overall of the shirt on the front side of the shirt as we put it back together a little bit as much as we could. You can see the cut marks in the shirt where EMS cut the shirt off the victim.
So it's kind of a cross in the middle, and that's your understanding that's from EMS.
Yes, that's what I believe to be.
Thank you. And then what's the area of interest on this shirt?
This right here is the gunshot hole in the front of the shirt. I placed a white card in behind that to be able to see the hole.
And I'm going to show you states 40. There was only one. How many holes did you find in this shirt?
Just one.
Okay. And so this is the same one we just saw in states 39.
That's correct.
Okay. And you said you placed a white card behind it.
Yes.
Okay. And so these two pictures that we've just seen, are those through a regular camera at regular light or not?
Yes, I believe they were.
Okay. And then after taking photos at regular light with a regular camera, what do you then do?
I then start using the infrared camera and just take some more of the same series of photographs, but not without the overall in it.
And during the course of that taking, are you changing those filters you told us about?
Yes, I changed the filters as I went through, going through each level of the filter to see what is going to show the best contrast.
And I believe states 41 through 44 is a sample of those photos. Is that correct?
That's correct.
Okay, thank you. I'm going to show you states 41. Do you, ultimately, when you're using this infrared camera, if there were stippling and soot, what would you expect to see?
I would expect to see the background colors of the shirt to lighten quite a bit, like where you see this dark right there and it's gray, it lightens up significantly. And if there was stippling present, you would see darker particles or powder burns around the bullet hole.
And in states 41, do you see any of those darker particles or bullet or burn marks?
No, I did not.
I'm going to show you states 42. It looks somewhat different than 41. And what accounts for that?
It's just a different filter, and the background on the darker area is lighter color now, and the gray shirt is lighter color even more to it, where it's almost like towards a whitish color.
And did you see anything under this filter that indicated to you there was stippling or soot?
No, I did not.
And I'll show you states 43. Again, it looks a little different.
Yeah, and it is just another filter we used, and again, there was no other areas of stippling that we thought it could be there.
And then finally, states 44. Again, a little different. Is this a different filter again?
It may be the different filter, but it's also a closer up shot, showing the bullet hole a little bit closer.
And now we see some faded portion there around the bullet hole. What is that? Is that attributed to anything?
In my opinion, it was attributed to just wear and tear of the color of whatever the color of the shirt is, and because you can see the wear and tear in another location of the shirt showing the same thing.
And was that location close to the bullet hole or somewhat at a distance?
Further away.
So
Looks
after
like
conducting this
normal.
examination of the shirt using your infrared light, did you find anything that indicated to
like wear
you
and tear
there
to
was soot
me.
or stippling on the shirt?
Yeah.
No, I did not.
Can I have just a moment, Judge?
Yes.
Looks like it was a good, worn out, good, well-loved t-shirt, right? Everybody loves a good t-shirt.
During your time as a crime scene tech and subsequently the manager, have you been trained on or come to know through your experience generally how far soot or stippling exit or how far away the gun would be?
I couldn't give you an expert answer on that question, but through my experience and with the medical examiners and some different firearms experts, you know, I've heard that it's outside of 3 feet, inside of 3 feet, you can start to see some of that stippling and gunpowder maybe. So that's just the general thing that I've come up with that I've known over the years to be an outside of 3 feet.
Thank you, sir. I don't have any further questions, Judge.
Cross. And do you want any of this or?
Yeah, we can have the lights and I need 2 minutes.
Yes, sir.
Do you,
Absolutely.
I'm,
No, I was just saying, were you going to use the display?
No.
All right. Yes, sir.
Afternoon, is it Deputy or Mr. Talbot?
Mr., if you wish, that's fine.
Civilian.
Yes,
All right. So, Mr. Talbot, you've told us that you examined the shirt. It had no signs of stippling.
that's correct.
And stippling being the gunpowder residue that comes out the barrel of a gun when it's fired.
Yes, the small particles that will come out of the gunpowder. And
Right. A lot of times it leaves like tattooing when it's in close range.
that's correct.
All right. And you've told us that stippling generally travels, I believe your words were outside of 3 feet.
Yeah, the distance, if you're expecting it to show up on the skin or the shirt or something like that, they would expect it to be somewhere around 3 feet. You'd expect us to see it there.
Okay. So would it be fair to say that what you're telling us by your testimony is that making believe that you are the shooter and I am an assailant, and I have previously on this occasion assaulted you, and now I am coming at you again to assault you. You're telling us that you shot me, and when you shot me, I was 4 feet or more away from you.
Potentially.
Yeah. That you chose not to let me get closer than that to assault you a second time.
Potentially, yes.
That's all.
Any redirect?
no, sir.
All
Thank you.
right. Can this witness be released?
By the
He
state.
just wanted to get his little
All right,
narrative
sir,
in
you're
there,
released.
right?
Tina, thank you very much.
Thank you.
We're not gonna let you
All
offend
right,
me a
let's,
second time.
Take a break. And it's just a little bit before 1. I think we can be back by 2. It's a little bit after the lunch rush, so hopefully everybody can get in and get out. Does that sound all right?
Yes, sir.
Sound okay? All right. The only thing I'll say is, folks, obviously, when you step out of these doors, I don't have any jurisdiction out there, but I'm going to ask that both sides just kind of go your own way, have your lunch,
Go
be
your
back by 2
own
o'clock. We don't
way.
need any difficulties.
Go your own way.
Yes, the doors will be locked, absolutely. Sarah, thank you so much. You're always a trooper. I appreciate
Dude,
it.
get your jacket out of your pants. Why does your suit jacket end up tucked into your back? Well, we got to see her face in this video here. Get to see her, what she looks like. Hmm. That guy right there looked like Matthew Broderick, a young Matthew Broderick, didn't he? Look, let's look at that again. Hold on. She looks very uncomfortable. But I'm going to rewind it because I swear, the guy that right here, the guy that's got his back to us, when he turns around, he looks like a young Matthew Broderick. All right. Da, 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 da. You can go your own way. Go your own way. All right. So they are going to launch. We are going to go zoom, zoom, zoom on through. Let's speed it up a little. All right. Scroll through till we get some audio.
Thank you. Hello, sir. Hello, sir.
Do you solemnly swear
Call your next witness.
State calls Detective Justin Warren.
Detective Justin Warren. You saw it too, Miss King, right? You do see that in him. Yeah, he looked like a young Matthew Broderick. I love Matthew Broderick. For sure. For sure. Ferris Bueller's Day Off, right? Oof, good movie. All right, I'm going to hit the play button and then I'm going to mute and turn my camera off and I'm going to run to the potty and grab a quick drink. So if you guys need to go, you didn't see it, Spins, you don't see the Matthew Broderick. He looked like him to me. But yeah, I'm gonna, if you guys need to run and get a snack or go wee wee or, any of the things, go switch your laundry out of the washer into the dryer, run and go do that. I'm gonna take my phone with me though, but I will be back in just a couple minutes. Hit the play button. Lady Hawk. Oh my God, yes. That was my mom's favorite movie ever. My mom loved Lady Hawk. Yep. Totally. All right. Okay, be right back.
do you solemnly swear or affirm the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Hello, sir. Hello, sir. As the deputy said, 12 to 15 inches from the microphone. Okay. Adjust it how you need, up, down, left, right, and just loud, clear voice should hear everything. Yes, sir. Thank you.
And Judge, we're ultimately going to need the screen. Good afternoon.
Good afternoon.
Please state your name.
Detective Justin Warren,
How do you spell Justin and Warren?
JUSTINWARREN.
Where do you work?
I'm employed by the Manatee County Sheriff's Office.
How long have you worked there?
Started March 25th of 2003, so just over 20 years.
What is your current position?
I'm currently assigned to the Manatee Homicide Investigative Unit.
What is that?
So basically, it's a unit comprised of detectives from the Sheriff's Office as well as other local municipalities. And whenever a homicide occurs within the jurisdictional boundaries of Manatee County, several of our detectives will go out to assist.
And generally speaking, when there is a homicide, do all of the members go out?
It depends. Sometimes for people on vacation, other times not everybody will come out. It depends on what the supervisor deems necessary.
But the majority of the time, do you have more than one detective there?
Oh, yes, ma'am.
Okay. And do you have what's considered a lead detective in cases that you do?
We do.
Okay. And what does the lead detective do?
The lead is essentially the person who will basically hand out assignments. Those other detectives that will be out at the scene, or they might be knocking on doors, talking to witnesses, they essentially report back to the lead and the sergeant.
Okay. So as the lead, even though you may be designated the lead, that doesn't mean you're doing all of the interviews.
No, that's correct.
Okay. Were you the lead detective on the case that we're here about today?
Yes.
Ashley Benefield.
Sorry, yes, ma'am.
Yes. On the date of the shooting, were you notified?
I was.
And around approximately what time?
I think it was probably around 7:20 or so.
Okay. So you were called at around 7:20. Do you know, was there a 911 call?
Yes, ma'am, there was.
And what time was the 911 call?
I think that was approximately 18:56 hours, so 6:56 or so p.m.
So you're there roughly 35 minutes, or,
Yeah.
or you come to the sheriff's office roughly 35 minutes afterwards?
Yes, ma'am. I started responding there.
Okay.
Yeah.
So I was starting to say that you went to the scene, but you didn't go to the scene first, correct?
That's correct.
Where did you go?
I went to the sheriff's office so that we could begin authoring a search warrant for the residence.
Okay. At that time, did the defendant, Ashley Benefield, come to the station?
She was brought to the station. Yes, ma'am.
Okay. Was she brought to the station by other members of Manatee County Sheriff's Office?
Yes, ma'am. There was a patrol deputy brought her in, a marked patrol unit.
Was she under arrest at that time?
Not by me, no ma'am.
Okay. When you saw her, were there any other people with her?
When she arrived, it was just the deputy and her. But I was soon, actually, before I even met with her, I was actually approached by a female by the name of Faith Brown.
Okay. And did she have other people that joined her throughout the evening?
Eventually, 2 others arrived. Yes, ma'am.
Okay. And do you recall who they were?
Leland Taylor and a Miss Kimberly Kuhn.
Okay. And they're all 3 attorneys?
They are.
Okay. At the time, did you have a crime scene technician take photographs of her?
We did. We had a crime scene technician respond to the office. We actually obtained a search warrant in order to get those photographs and DNA and whatnot. But yes, we did.
And why?
We asked, and initially it was told by her attorneys that they would rather us get a search warrant, so we did.
Okay. And why did you want pictures?
So initially, when I saw her, I didn't notice any kind of injuries at all. I didn't notice anything about her clothing that stood out, whether it was ripped or torn or stained or stretched out, things that you would typically see during a physical altercation.
At the time that you saw Ashley Benefield, were you aware that there was a self-defense claim?
I had been aware of what had been said on the 911 call. Yes.
Okay. And what was said on the 911 call, and we have a stipulation to this effect, but basically Ashley went to a neighbor and said her husband attacked her.
Correct. And yes, ma'am.
So you were aware of the self-defense claim at the time?
Yes.
When you observed her physically, what was she wearing? Oh, I'm sorry.
Can I request that the stipulation be read?
Which one is it?
It's number one, I think.
Number 1? Okay, it doesn't mention 911, but that's ran to neighbor's house, called 911.
Well, Your Honor, I believe it says immediately
Mhm.
ran to neighbor's house
Yes.
and hysterical.
Mhm.
Just quite different from what was repeated.
Oh, okay.
Okay.
I've read it.
So anyway, I'm sorry, this is repeated, but you did understand that there may be a self-defense claim at the time.
Yes, ma'am. That's accurate.
So what was the defendant wearing?
Like if I remember correctly, it was like a I don't know what you call it. I guess like a crop top, tube top, something like that, almost sports bra kind of thing, and a pair of shorts, if I remember correctly.
Okay. So tube top sport bra kind of thing.
There was some midriff that was visible,
exposed.
Okay.
And you said you looked at her clothes
I did.
and you didn't see anything torn or disheveled?
No, ma'am, I didn't.
Okay. And when you looked at her, did you see any injuries?
I did not.
Did you look specifically for injuries?
I was paying attention as we were standing there in the lighting out in front of the office and then on the way up to the interview room. And as we walked her into the interview room, I was paying attention to that. Yes.
Did you see her face clearly?
Yes.
Did you notice any injury to her face?
No, ma'am.
Okay. Did you speak with her attorneys about the need for documenting these injuries or,
Yes.
or lack of injuries?
Yes, ma'am, we did.
Okay. And that's when you got the search warrant, correct?
It is.
And did you have an opinion about what you should photograph?
So my initial opinion was to photograph everything to make sure that we did a thorough and accurate job in documenting any injuries or marks that may be present. And we actually even put it to her attorneys. And I asked them, I said, if you would mind, go talk to your client and try to help us determine if there are any areas of injury or any areas, because we're going to do DNA swabs of the skin as well, to try to pick up any foreign DNA, foreign to her. And
Any response, Your Honor? I think we're heading into a dangerous area.
Yeah, I don't know if you're going to start talking about attorney-client privilege information or.
No,
Okay.
no, I just wanted to get across that this witness asked the attorneys, where should I photograph? And then what the response was. And that's
Okay.
why.
All right, I'll overrule.
So you asked, should I pay attention
right.
to any areas?
Yes.
And go talk to your client and let me know.
Yes.
And they came back and said what?
Arms, legs, neck, and hands, I do believe was the final.
Arms, legs, neck, hand. Did they ever mention, or did anybody ever mention to you eye or face?
No, ma'am.
Did anyone ever mention to you midsection?
No, ma'am.
Did you ultimately arrest her that day?
No, ma'am.
Why not?
Because she had made that claim of self-defense. We wanted to make sure we conducted an accurate and thorough investigation. There was obviously a lot going on here with her past history, and we wanted to make sure that we did a thorough job.
Okay. So you said with her past history, so at least you were somewhat aware of some previous reports.
Yes, ma'am. There were some reports that were in the Manatee County Sheriff's Office computer records database that we were able to view.
Okay. And did you ultimately get another search warrant to take pictures of the defendant 3 days later?
We did.
And why'd you do that?
Well, sometimes with injuries, they don't readily show up right away. Bruising sometimes doesn't come up initially. So we wanted to make sure that we did our due diligence again and check 3 days later, giving those injuries time to appear.
Okay. And have you seen those photos?
I have.
Do you recall how many photos were taken?
Of her in total.
Yes. Let me be more specific. So the first day and then 3 days later, there was more taken. So together, about how much were there?
100 or so.
Okay.
Something like that.
So a lot of pictures.
There were a lot, yes.
And did you at any time, either at this first meeting in the sheriff's office or after the fact, see anything on the defendant that appeared to be an injury?
There was a small scratch. I believe it was on her side. But that actually came up during an interview that we did later on, and it was very minor.
Okay. As part of the investigation, was Doug Benefield's phone taken into evidence?
It was.
And was that phone searched or downloaded to gather the information?
It was. It was taken to our technical services unit, and they did an analysis on the phone.
So you don't do that?
No, ma'am.
Okay. So once the information is downloaded from a phone, is it in some sort of a format that you can read it and search it?
They do use certain programs that allow you to search through and help organize what you're downloading. I don't know the exact ins and outs of it, but I mean, I'm capable of using the program and reading through it, but
Okay.
I don't know the technical aspects of it.
Did you review certain information, some information from his phone?
Yes, ma'am.
Okay. And did you find anything about a U-Haul on his phone?
Yes, ma'am. There was a confirmation email. The U-Haul was supposed to be picked up locally. Then I believe it was supposed to be dropped off in the Bowie, Maryland area.
Okay. And were you able to examine his searches on his phone?
Yes.
And did you find anything interesting about his searches?
Yeah. So one of the searches was actually, it looks like he was looking for a roommate. Like he was looking for a place to move into. It was like roommate finder or something along those lines. But in the Bowie, Maryland area.
And why did that seem of importance to you?
Well, some of the information we'd received was that everybody believed he was moving in
Okay.
with them. And obviously this kind of contradicted that.
Okay. Moving in with them, meaning Ashley
And
and,
her mother
her
and
mother.
their child.
okay, in Maryland.
Correct.
I am going to talk to you about State Exhibit 45, and I know there may be objections to this. These are the text messages. There is a stipulation, which I think is number three, that this does not need any further authentication, but I don't know if the defense has a further objection.
That's correct, Your Honor. We stipulate that.
I'm back, guys.
it's authenticated. However, we still preserve any appropriate objections, one of which includes hearsay and two references.
And Judge, generally my response is that these are text message exchanges between the defendant and the victim for the 7 days right up to an hour before he's murdered. While there may not be anything, explosive on these text messages, that is the reason I'm putting it in, is that there wasn't any fighting going on. There wasn't any.
Question, Your Honor?
No, I'm.
Yeah, I think she's just responding to the objection.
Yes. It is to show the nature of their relationship leading up to the incident. It's expected, and because of what is written in the stand your ground motion, the state feels it's necessary to show the tenor of their relationship and how the relationship was at the time in question.
All right.
So,
I guess my first question is, I haven't seen the text. I don't know what's in the text. I wasn't provided a transcript or a printout of the text. So I don't even know what the subject
go
matter
over
is. I don't know how many there are.
a few. Yeah, we were going to go through it, and the detective was going to help me read these.
Right. I don't know how to make a ruling when I haven't even seen them yet. Maybe they're hearsay, maybe they're not. Well, we've got defendant statements, at least for one side of it. So is the other side of the conversation being offered the truth of those statements, which would then be hearsay, or is it just to show the natural flow of the conversation, the effect on the, I don't know.
Yeah, I do think, Your Honor, it has to be relevant to some fact in issue.
And then you got relevance. So
Yeah, and it is not.
And
I don't know how to make this decision without seeing them.
And I do have some further argument depending on what the actual objection is and what the response is.
So what I'm thinking is going to happen is that we're going to keep going pursuant to, or I'm sorry, subject to your objections, but I got to see them to even have an idea how to rule.
I understand. So, Judge, we can continue.
I left my quarter upstairs.
We can continue on as the court suggested earlier. I'm confident the court will rule.
All right, thank you, sir. So this is subject to any objections.
Okay. And if we could just dim the lights a little bit right in front, just the ones in front of the screen would be okay. And the state would enter into evidence states exhibit 45. I don't know that I actually did it after the objection. Or would you like me to wait?
Well, yeah, we're gonna make, we
Okay.
have to wait on all of
Okay.
it.
Okay.
Now, ultimately, even if I don't allow them, I imagine you're gonna want to put them in
Right.
the record for your proffer and appellate purposes. But for
Right.
right now, I'm delaying ruling on all that.
Those guys got stuck in traffic. Or else they went back for seconds at the buffet at the Golden
Now, you
Corral.
have
I
a
don't know
pointer
what.
right in front of you.
Yes, ma'am.
Yeah, if you wouldn't mind. It's really hard to see on this screen, so I'm going to zoom in a little bit. Let me go all the way to the top. What are we looking at here? If you could just tell us what information is in this.
So this appears to be a timeline of text messages. Down here, it's telling what type, because there are different types of messages, instant messages, and depending if you have an iPhone, it might be an iMessage or an SMS. Over here shows the direction of the call or and/or text message, whether it's an outgoing or it's an incoming. This would be the date that it was sent, and sent, and this would be the sent or received, I should say. Then this would also be the date and time. Then obviously direction from and to, and then the owner's information of each phone.
So are you aware of the reports that came into the sheriff's office? We heard testimony earlier about it from Stephanie Murphy, that there were at least 5 abuse complaints against Doug Benefield, saying that he was abusing the dog.
There were several, yes, ma'am.
Okay. And were all of those complaints before this date of 9/20 of 20?
Yes, ma'am, I do believe so.
So I would like for you to just, I'm going to make it a little bit bigger. If I'm just going to have you go through some of these so we can get sort of the tenor of what's going on here. So the ones in light blue are from who?
Okay, so the ones in light blue are from Doug Benefield,
And two,
and they would be to Miss Ashley Benefield,
and the orange.
and the orange are from Ashley to Doug.
Okay.
Yeah, it might be better, you know, if you look up here, you might be able to, the video is horrible. Okay, so the first instant message is 9/20 of 20 at what time in the morning?
9/20 of 20 at 8:20 a.m.
Okay, and now it looks like there may be not a message necessarily, but an attachment.
Correct.
Okay, so now, you've seen this before. So do some of these attachments work and some do not?
So yes, ma'am. Some of them do, some of them don't.
Okay, do you know why that is?
I think 'cause some of them are actually based on the internet, not something that's downloaded. So sometimes if you're not connected, the link won't work, and
Okay,
various other reasons.
so this is the first one. And what is this?
Looks like a Bible verse.
Okay. And that was from Doug to Ashley, correct?
Yes, ma'am.
Okay, and then if you could just go through the next few lines.
Okay. On 9/20, so the same date, 10:36 a.m. Loved an image. So typically with some images and posts, especially with
Well, wait, I want to go back and see what that said. Am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bond servant of Christ. Galatians chapter 1, verse 10. Okay.
And that was from Doug to Ashley, correct?
yes, ma'am.
Okay, and then if you could just go through the next few lines.
Okay. On 9/20, so the same date, 10:36 a.m. Loved an image. So typically with some images and posts, especially with iPhones now, they really have this thing going where you can actually laugh at an image or love an image, or you can do different reactions essentially. So as far as I'm aware, that's what we're actually when it says loved an image. I think it's her reaction to that.
Okay.
Okay.
Most recent text message. 10:36 and 36 seconds. So 5 seconds later, she sends a message, good morning.
Okay. And then he says,
He replies with good morning.
and then within an hour after that, there is what looks to be an attachment. Is that one that you're able to open?
I'm not sure if that is or not. I don't think it doesn't have a line under it. So I'm not sure if we're able to open that one or not.
Okay. So then the next text message is from,
This is going to be from Doug to Ashley. It says, run, baby, run.
and if you could just continue down the line.
Sure. Then Ashley sends a message, laughed at a movie. Ashley sends some smiley face emojis. That's what they look like. Doug replies, ready to rock and roll, laugh out loud. question mark. I was at 12:20. At 12:31, she replies, give me a few, LOL, trying to round up the cats. It's like trying to teach ballet to squirrels.
Okay, so I'm just gonna scroll up. What's the next entry?
So within, looks like within seconds, he responds, ha, that's funny. Give me a few, LOL. He's basically saying he liked this comment. So essentially, like I said, it's a reaction to the comment that was given.
Okay, and then he says, or the next entry is her. What is
Yes.
it?
So at 1:06 p.m. it says OMG or oh my God, I'm exhausted, LOL. You can come over now. Sorry.
And at this time, it's your understanding they were living in separate houses, correct?
Yes, ma'am. He had an apartment down the road. I believe it was called the Green.
Okay,
And then she was in a subdivision.
so this here is Ashley telling him you can come over.
Yes.
And he says,
Sorry. He replies, need to video the rodeo. Okay, headed that way.
okay.
That's at 1:08 p.m.
And then she likes the comment, but then at 1:20, what does he say?
So at 1:20, I'm walking around to back.
And she said,
I can let you in the front or whichever. He said, okay, front's good. Then she gave him a little thumbs up.
okay, so that entry was at 1:22 p.m. The next entry is several hours later at 5:37 p.m., which appears to be from Doug. What does it say?
Me and XS boxes arrived.
All right. And Ashley's response?
Is LOL. Then it looks like it's 6:40. Doug sends some other type of an attachment to her.
Okay, and we'll view that attachment.
How do you know what it's doing? I think it's giving you clues that I gotta get. Get real. Real.
Working mother, not a working mother.
Oh, that.
Working mother, not a working mother.
Sorry. I have to go back and watch that video in normal speed because this chick here is like, it was killing me. I gotta rewind that and watch that in regular time. I can't with that fast eating. Mm-mm. Mm-mm. No. All right. Let me change this to normal speed. Normal. Okay. Let's play this over. And you guys, I'm getting ready to put a poll in the chat. So watch for that so you can vote in the poll.
Like it's 6:40. Doug sends some other type of an attachment to her.
Okay, and we'll view that attachment.
How do you know what it's doing? I think it's giving you clues that I gotta guess. Get real. Real.
Working mother, not a working mother.
Working mother, not.
Okay, she's still a weird eater. I'm sorry. I don't know who she is, but you know how some people you can't stand to watch. It's not even that you can't stand to hear them. It's that you can't stand to watch them. I couldn't sit across the table from her and watch her eat. Mm-mm.
Not a working mother.
Not a working mother. I live in a
Slum.
I'm confused about what is even going on in this video. Can someone explain this to me? Smacking the pickle. I know. Can someone explain to me what's happening in this video? I'm going to rewind it one more time. For those of you that are new here to this channel, I'm a serial rewinder, just so you know. Okay.
Like it's 6:40. Doug sends some other type of an attachment to her.
Okay, and we'll view that
I
attachment.
think so, Morgana. Yeah.
I don't even know what it's doing. I think it's giving you clues that I gotta guess.
Okay, they're playing Heads Up, the game. Yeah. I was like, what is it saying Real Housewives there? I didn't see the heads up part, but yeah, they're playing that game called Heads Up. And I think he has to give them clues to get them to say Real Housewives or something. I'm not positive.
Get real.
Oh, okay. He has to put it up to his head, the phone, and it's telling them the words Real Housewives, and they have to give him the clue, and he has to guess it.
Second part.
Really?
Working mother, not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum. Oh, that's running out of time. House. Real house. Wife. Oh, the housewives of. Oh, real. Oh.
So the person on the left, that's Ashley, correct?
That's correct.
And then on the right, do you know who that person is?
That's her mother.
Okay.
Okay, we have an update from Margaret. Yeah, now the sound effect makes sense. I was really confused. I was like, what is this sound? And then I was making the poll in the chat too, which it's up. You guys go vote. But yeah, it was very confused and I didn't know what was going on and blah, blah, blah. But now, yeah. Yeah, Kel, I played that before, but it took me a minute because I didn't see the word heads up. And I played it with the phone before too, but yeah. Margaret's back. She says, I think it went well, but I do not think it would be the job I'd want. I know beggars can't be choosers, but it sounds like a carbon copy of the job I just left. Okay. Well, there you go. At least you know, right? Right? But I hardly think that you're a beggar. I hardly think that you're a beggar. No, know your worth. Know your worth, Margaret. You are worth everything. You are worth everything. And a bag of chips.
Then at the next entry is about 40 minutes after that one is what?
Let's see. We have, was there a response to that? I'm sorry.
I'm sorry. It looks to be a call log phone call. Yeah.
So that looks, okay. So yeah, a call log, sorry. Incoming.
3 times
It
the
looks like
work.
there's about a 13-second call
From Ashley.
From Ashley
Okay.
to Doug.
And then the next entry.
Next entry is from Doug to Ashley. It's 9/20 of 2020 at 8:58 p.m. And it says, good night, sweet Theta waves. I'll be done by 1 tomorrow and plan on joining the party.
And she does what?
She loved the message at 9:22 p.m.
And then said,
Then good night. I'm sorry. Good night, huh? You sure want to come hang out at the slum? Or are you sure you want to come and hang out at the slum? So basically indicating what they were joking about in the video.
on the video. Okay. And his response.
Yep, be smashing at the slum.
Then skip down. The next one is that she liked that message. And then the next entry is from Doug at what time?
That's at 7:36 a.m. on 9/21, so the next morning.
The next morning. Okay. And there's an attachment.
There is.
Okay. We'll look at the attachment. And for the record, what is this?
It's another Bible verse.
Okay.
Whoa, don't run off. I was going to read that one too. There is no fear in love. Dread does not exist, but perfect, complete, full grown love drives out fear because fear involves punishment. So the one who is afraid of God's judgment is not perfected in love, has not grown into a sufficient understanding of God's love. I think the AMP stands for amplified. And usually, I think that if I'm not mistaken, the Amplified Bible usually does that right there. They go into detail on certain words, what words mean in certain contexts and stuff. But anyway. So he sent this to her or she sent this to him? I have to go back and see. There's no fear in love, but perfect love drives out fear because fear involves punishment. So the one who is afraid is not perfected in love. So who sent who? Let me go back.
Skip down. The next one is that she liked that message. And then the next entry is from Doug at what time?
That's at 7:36 a.m. on 9/21, so the next morning.
The next morning. Okay. And there's an attachment.
There is.
Okay. We'll look at the attachment.
So he sends that to her. Why would he send her that? Why would he send her that, you guys? I mean, I'm just playing the, devil's advocate here, devil's clavicle. Why would we think that he would send her this scripture that says there is no fear in love, but perfect love drives out fear because fear involves punishment. So the one who is afraid is not perfected in love. I mean, I know that it's not talking about, it's talking about who's afraid of God's judgment and perfected in love has not grown into a sufficient understanding of God's love. I know it's talking about, in relation to God, but I don't know. Any thoughts? Any thoughts on, I mean, looking at it just head on, it's kind of like, it looks like just on its face that she shouldn't be afraid of him. But what makes him think she's afraid of him? Is she said she's afraid of him? And so he's like trying to tell her, look, there's no reason to be afraid of me. You know what I'm saying? Maybe because she is protected by his love. I don't know. I'm a little confused by that.
And for the record, what is this?
It's another Bible verse.
Okay. And what's the next entry?
The next thing I see is, at 9:55 a.m., Ashley loved an image. Then she says, good morning.
Okay. And what does he say?
Doug replies at 9:56, good morning. And there's some little emojis behind it here. Then later at 12:46 p.m., headed that way in about 30 minutes.
Okay. And her response?
Her response, that's at 1:09. Oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now, not in a rush to get started today. LOL. We'll have to round up the cats when we get home anyway.
And his response.
So his response at 1:13. Oh, nice. A little breezy, which helps. Getting an early start can finish up early to come over and be with y'all and play with Emerson, free y'all up some. Just ping when good to head over.
And she likes that.
And she likes that at, yes, 1:51.
And says.
Then at 1:51, a few seconds later, will do.
And then she also asked.
So on that text, QB, do you think the scripture, how do you see it? Do you see that he's sending her that text message to tell her that God loves her? You know what I mean? Or do you think, okay, and more in reference to God's love? And I mean, I would like to think that that's what he meant. You know, I'm just saying, I could see how people could look at it the way I'm looking at it and be like, you don't have to be afraid of love. Love doesn't have to be punished, you know. I don't.
Asks him.
So yeah, 2:47. Want to grab a can opener at Publix on your way over? LOL. I of course packed the one that we had.
Okay. So I'm going to run a little ahead. So.
Oh yeah, right, Morgana. Yeah, I get that
This
too.
is the next day. If you could read that, what's at the top, that date.
All right, so we have an outgoing
I
from
remember
Doug
that.
to Ashley on 9/22 of 2020 at 4:11 a.m. And it looks like it was an attachment that was sent.
Okay, and we'll look.
It's just strange because of the whole her being afraid of him and blah blah blah, you know. This one says, for this reason I'm telling you, whatever things you ask for in prayer in accordance with God's will, believe with confident trust that you have received them and they will be given to you.
Look at that. And for the record, if you could say what that is.
It's another Bible verse.
From Doug.
From
Correct.
Doug to Ashley, yes.
All right. And then he says.
Sorry, then he says, good morning, hope you slept okay.
That's
her
Penny
response.
Margaret.
Looks like she loved the image and then replied with good morning.
I'm going to scroll up. How about later on that day at like 1:36, which is the top entry, and he says to her.
So Doug sends Ashley a message. Can you think of anything we need at Lowe's or anywhere?
And the next.
After that, at 1:42 p.m., it looks like Ashley reaches out to Doug via phone because there's a 48-second call.
Okay, so it's a phone call.
Correct.
And then the next entry.
The next entry is at 3:23 p.m. and that's from Doug to Ashley. Headed that way in a few. I'd nothing need.
Okay. And I'm going to scroll up. And then I want to go to the next attachments here at 9:22 at 9:27 p.m. What is that entry?
So looks like an image, or I'm sorry, some kind of an attachment sent from Doug to Ashley at 9:27.
Okay, and we'll look at that. And for the record, what is that?
It's a picture of Ashley and her daughter on the beach.
And the next entry is right after that?
Yes, ma'am. It's at 9:28 p.m.
And it also has an attachment?
It does.
Okay, and I'll open the attachment.
Mm-hmm.
What are we looking at, just for the record?
Again, it appears to be Ashley and her daughter at the beach.
Okay, so Doug sent these to her.
Correct.
I want to go to the next yellow square there. What, is that the same evening?
Yes, so 9:22 at 9:30 p.m. Another attachment is sent.
And this is what?
This appears to be their daughter at the beach, and I believe that actually I can't see who that is there in the background very well.
Okay.
But it appears to be the same location.
Okay. So then I'm going to scroll
Right.
down
I would be in a world of trouble if somebody looked at my.
until we get to the next day, 9/23 of 20, at 6:47 a.m. What is that entry?
Be like, no, 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 no. I have a true crime channel. You guys would vouch for me, right? if if worse come to worse, right? You would vouch for me that yeah, no.
So that is a message from Doug to Ashley, and it appears to be another attachment sent at 6:47 a.m.
Okay. And the attachment again.
It's another Bible
sure.
verse.
Anywho.
And then after that, he says,
So at
Dude, why are they zooming past those
another
scriptures,
Bible
man?
verse.
Why are they doing that? Like, give us a minute. Crime Cafe, what? Y'all are rotten. Dirty little rotten scoundrels. Study and do your best to present yourself to God approved, a workman tested by trial, who has no reason to be ashamed, accurately handling and skillfully teaching the word of truth. Just kidding, I got you. Yeah, you got me. And then they're going to go check your phone. You're going to vouch for me. Then they're going to go check your phone out and they're going to be like, whoa. It's just, no. We have a problem here. Book 'em, Dano. Facts.
and then after that, he says,
So at 9:23, he says good morning. And at 9:28, he replies again and says, got email from Stephanie after she talked to Faith. Since order to mediate, we meet for 1 hour tomorrow to stop court next week. You dismiss injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs order for a report. As soon as she signs order, we file dismissal and we're done.
and what else did he say?
At 9:30, and we have joint session with Dr. Q Friday to wrap up our adventure in Florida and leave with understanding of double knots and red-blue inversion.
And the next couple of entries.
Okay. 9:49 a.m. She loved an image. Then at 9:49, looks like 10 seconds later, good morning. Doug then actually, it says emphasized on good morning. So her response. Then Ashley sends another at 9:50. Okay, I'll reach out to Faith to follow up on all of the above with the thumbs up.
Okay. And then he likes that.
Yes, ma'am. So at 9:50, he likes that. At 9:51, and we're all done. Or I'm sorry, and we're done.
Oh, God.
At 9:52, Doug sends another message, and all in first 10 days of Jewish New Year, LOL.
Okay. So
And then she likes that comment.
We're going to scroll down to the 9:23 or 9:23 at 10:13 a.m. from Doug. What does that say?
9:23, 10:13 a.m. Doug to Ashley. So perfect outside.
And she loves a previous comment, but what is the next comment underneath of that?
So her comment at 10:14 a.m. says, "Oh yay, we should do Selby today."
Okay. And his response?
His response is at 10:14, "Oh yes." Then he responds, "Yum."
Okay. Then I'll scroll through some of this. The message at the top from 11:39 a.m. Who's that from?
So that's from Doug to Ashley. And the text is, Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do. Just a one-pager.
And next?
Then he sends another text, what time thinking Selby?
And then she liked the first comment. And then what was her response to Selby?
So her response at 11:44 was maybe 1:30-ish. I'll text you when we are heading that way.
And then he says, let me scroll up here. There.
So at 11:44, he replies, okay, I can come pick you up too. 12:12, he again sends a message, more time with my baby, a happy face. Then at 12:14, mediation tomorrow by Zoom at 10:30, and be quick.
Okay. I'm just going to scroll up here.
Better get rid of your
So
phone.
the
and
next
stop
entry I
digging.
want you to read is from 5:53:38 on the same day.
Okay.
And what does he say?
So it's an outgoing message from Doug to Ashley, 5:53. Do you want to get together tonight or in morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out.
Her response.
Her response at 7:02 is, ha, okay, thumbs up.
And his response.
And his response at 7:05, thumbs up, prefer tonight, maybe run over Pandera or in morning or AM, sorry.
And she says.
At 7:24, she says, sure, can do Panera tonight.
And the next entry.
Next entry is outgoing from Ashley to Doug at 7:24. It says 8 ?
Okay. And he
Then-
sends a thumbs up.
Yeah, 7:27, he sends a thumbs up.
Okay. And then they're telling each other good night. Good night, sweet dreams.
Yes.
And the next day in the morning,
So
7:00. Who is that from Doug?
yes, it is. It's from Doug to Ashley on 9/24 of 2020 at 7 a.m. And it's another attachment,
Okay. And for the record, what is that?
another Bible verse.
I'm going to scroll through. This entry here is 9:24 at 10:09 a.m.
Okay.
Can you read what that says?
9:24 at 10:09 a.m. It's from Ashley to Doug. It says quick and easy, LOL.
And his response.
His response, he emphasized quick and easy, LOL. Then at 10:26, so nice to experience quick and easy, finally, LOL.
Okay, so I'm going to scroll again. On the same day, 12:50 p.m., can you read this?
Okay, so yeah, 9:24, 12:50. This is from Doug to Ashley. It says, just to ponder while I finish up, thinking about getting all the cars up there. And I thought was to ship the Cherokee up there by transport, which is 900, and either tow my truck or tow your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul more flexibility, like taking things straight to storage.
And she says.
Her reply at 1:27 is, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and Cats will go in the Jeep and I'll drive with Emerson in my car.
Okay. I'm scrolling up again for the record. And the next day, 9:25. This is 2 days before the murder.
So 9:25 at 5:45 a.m. There's a message from Doug to Ashley, and it's another attachment.
And what is this?
It's another Bible verse.
What is the next entry?
So the next entry is 9/25/2020 at 6:03 a.m. It's from Doug to Ashley, and it appears to be another attachment.
And if you could read what this says? It's
Sure.
an attachment, but what does it say?
Live a life filled with love.
And he says, good morning.
Yes, so at 9:26 a.m., he sends her a message saying good morning.
Right. And then what is the next thing he says?
The next thing he says is at 9:27 a.m. and it says Dr. Q is at 10:30. Do you want a chai?
Okay. And they go on talking about the tea. I'm scrolling. This is one day before. This is 9/26/20 at 6:43 a.m. What is this?
So this is a message again from Doug to Ashley, and it appears to be an attachment.
And what is that?
Another Bible verse.
And he says,
And he then sends her a message, good morning at 9:40 a.m.
and she responds,
9:54, she loved the image. Then at 9:54 and 17 seconds, good morning.
okay, and then I'll scroll a little bit. So this is 9:26:20 at 12:27 in the afternoon from Ashley. What does she say?
So Ashley sends a message to Doug, want to come pick me up and we can go get the truck.
And he says,
He replies, sure, heading that way. Then later, let's see if at 12:41, I be here.
And
Then at 9:04, good night, sweet dreams.
okay, and she likes the image or loves the image. And
Yes.
says good night.
Love the image, and then replies good night at 9:23.
Okay, so the next day, 9:27. This entry's at 6:42 a.m. What is this?
So this is another message from Doug to Ashley at 6:42, and it's another attachment.
And this must be one that we can't open. So he says after the attachment,
So at 10:02, he sends a good morning, some little emojis.
and she loves the image, and then,
Love the image at 10:06, and then 10:06 and 10 seconds replies with good morning.
okay. So there are several short messages, and then at 1:03 p.m., this message appears to be from Doug. What's he say?
So Doug sends a message to Ashley, what y'all working on?
And she responds.
She replies, last cram, LOL, using the big boxes and getting the last loose stuff packed up and ready. That was at 1:15.
And then she also says,
She also says, how's it going over there? Making progress.
and his response,
His response at 1:18, loose stuff should be a chapter in our book, LOL. Got everything out and in garage, ready to throw on truck, except couch, AKA bed, pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go.
and he says
And
after
then
that.
at 1:19, I'll come there and drop him off at 3.
And then she laughed at the message
Correct.
from him. She also liked the message, I'll come there after 3.
Yep.
And then what'd she say?
Then at 1:20 p.m., great, could you run by Lowe's before you come over? Grab a few more large and mediums.
And he says,
Sure, I need a few too.
she likes that. And then she says,
She likes that. And then at 2:36, just to be safe, let's do 10 of each just for the last bits here.
and he likes that.
He likes that. And at 2:36, he also replies, okay, let me know. I'm sorry. Okay, let me know anything else if think of.
And then she
Fall
says,
for the win.
Tape. At 2:50, she replied tape, but then also LOL.
and he responds,
At 2:50, he says, ha, okay. Then at 2:51, just finished the vet, headed to the spa, LOL.
and she laughs. And
Correct.
then the next entry,
At 3:45, he advises that he's headed there.
and she says,
She replies at 3:51, okay.
then he says,
At 3:54, I'm out here out front. Or I'm sorry, I'm here out front.
and her response.
Her response is at 3:55, okay, 1 minute.
Okay, so he must have left at some point. This jumps 2 hours or an hour and a half. And the next entry is from Doug to Ashley and says what?
At 5:10 p.m., it says I'm about to head back.
Okay.
Then at 5:11, there's some kind of an attachment that's sent from
That we
Doug to
can't open.
Ashley.
And then at 5:11 p.m.
At 5:11, Doug sends another message to Ashley. Everything in except couch and 10 medium boxes and 2 cab, LOL.
And she laughs at that.
And she laughs at that at 5:14. At 5:14, she then sends a message to Doug, ha, OMG.
And he says,
And at 5:32, he sends a message back, trucker on the way.
and what time was the 911 call again?
Was it 6:56? Approximately.
When was Ashley arrested?
A little over a month after this occurred.
Okay, and why'd you wait so long?
We were trying to do an in-depth and thorough investigation, look at every aspect of what was going on. She had made a claim of self-defense, and we wanted to make sure that we did everything possible to either prove or disprove that.
Okay. Was a booking photo taken of her at the time?
Yes, ma'am.
Okay. And what was the date? Do you recall?
Not off the top of my head, Alex. It was a little over a month.
Okay. Beginning of November?
Yes.
Yes. Judge, this is the certificate of business records that the state did a notice of for the booking photo of Ms. Benefield.
Okay.
Object relevance.
Relevance is she looks exactly the same as she did in the other two sets of pictures that were taken.
Okay. Go ahead, sir.
Same objection.
Overrule.
I'm just gonna put this up.
I don't know. What number is it?
Oh, I'm sorry. Statement entered into evidence states 46.
Subject to the objections that I've overruled, received.
Okay. Thank you. I have no further questions. Thank you. Oh, Judge, I don't know that we ever got a ruling on 45, but I'm doing some objection.
No, go ahead and do your cross, and then I'll hear all of the
Don't
arguments.
let me forget. So
What was the number on that one?
45,
There we
the
go.
one that there's an objection?
Yes, 45. Okay.
Now,
Yes, sir, absolutely.
Detective Warren, afternoon.
Good afternoon, sir.
So you testified that you were the lead on this case, and a couple of questions I think would be appropriate. The lead is kind of like the quarterback, no?
You could say that, I guess.
All right. And the lead is also the one with the most comprehensive knowledge of the investigation and how it's shaping up and where it's going.
The lead is typically the person that has the overview in mind.
And so that's a yes?
I'd say we work as a team, but sure, yes.
All right. And correct me if I'm wrong, but as the lead detective, you developed the theory of the case.
We all actually sit down and look at the evidence. Like I said, I don't go out to every scene. I go out to a lot of them, sure, but we have other individuals that do certain things. So it's really a group effort.
Well, let me ask you this. Do you remember sitting down for a deposition with me?
Yes.
And do you remember that that was testimony under oath?
Yes.
You took the same oath for the deposition as you took this afternoon when you came in before Judge White, no?
Yes.
All right. Do you remember being asked the following question on page 9, paragraph 3? Okay, so as part of your responsibility as the lead detective, you would develop a theory of the case, would you not? Answer, sure.
My answer is still sure.
Okay. Now, you've told us on a couple of occasions that you wanted to make sure you did a thorough and comprehensive investigation.
Is that a question?
Yes, sir.
Yes.
All right. And that is because you certainly wouldn't want to jump to a conclusion on any case, much less a homicide accusation.
That's correct.
All right. And as a result of that, you spent quite some time after this incident running down leads and doing the investigation so you could make a fair and objective determination of what, if anything, was to be charged.
Correct.
What, if
And that
anything?
included you investigating self-defense and things of that nature.
Absolutely.
All right. So I'd like to ask Jack if he would assist me on this. I'd like to put up on the screen, if I can now, the warrant that you authored.
And Judge, no, I'm exact. Is there impeachment here?
Yeah, I mean, was this impeachment?
Yes, it's coming.
We need to ask him the question.
Hold on, as to which question so far, the thorough investigation, which,
The thoroughness of the investigation, its objectivity and fairness.
okay. I think there should be some specific questions to impeach with the document. I mean, is there going to be an inconsistent statement? or-
QB went,
Yes, if you give me a
no.
little leeway, Your Honor, I think I will satisfy the court that the questions that I'm about to direct are appropriate, and I will tie it up.
All right, I'm not quite sure because he hasn't answered any questions about the search warrant,
What is,
No, this is the arrest warrant.
the arrest warrant.
Yes, sir.
Okay.
I think the question needs to be a little more pointed. What exactly is this different than? What are you saying this is different?
Hold on,
from?
no crosstalk, just go ahead, put your arguments on the record.
I would like to know what exact statement is being impeached and what he's using to do.
All right, thank you. Yeah, that's my question too. I'm not exactly sure what specifically you're impeaching from the testimony he's stated so far.
Okay, if the court will allow me to approach the witness,
Okay.
I think I can set the predicate.
All right.
Second, let me show you this document and see if you recognize it.
Bears being arrest warrant? Yes, sir.
And whose arrest warrant is it?
Ashley Benefield.
And did you fill out and execute that arrest warrant?
I did.
All right. And that arrest warrant, correct me if I'm wrong, is a statement by you under oath that you took to a circuit court judge.
It is.
All right. And when we say a statement under oath, same oath again you took before you came to court this afternoon.
Yes.
And you represented to the judge that the facts stated in the attached affidavit to that arrest warrant were true and correct.
To the best of my knowledge.
Okay. Now, if I may, Your Honor, I'd like to put a select portion of that warrant up and ask him some questions. And I will demonstrate.
What's being impeached.
Well, I have to ask the question first.
Right, so generally, the police report itself would not be admissible, so I need to know what the questions are, and then I'll need to see if that's materially different, so that it could be used as a
Yes.
impeachment, as a prior inconsistent, I assume you're doing prior inconsistent statement.
Yes.
Okay.
And what I want to ask him about is first I want to establish what he said in the warrant. And then I'm going to show that a select portion of the warrant is in fact not accurate.
All right, well, I think that's kind of putting the cart before the horse. I think we got to have the testimony here, and whatever that testimony is, and then we'll figure out if there is a prior inconsistent statement.
Okay, I understand. So that is the warrant and attached affidavit that you actually served.
It appears to be.
All right. Now, everything that you had to say in there is true and correct based upon your oath.
Based upon everything I know to the best of my knowledge.
Would you tell Judge White whether or not prior to you submitting this affidavit, you authored two prior affidavits, two versions?
What do you mean, two versions?
Did you author two separate and independent versions of that affidavit before you finally settled on the one that is before you?
I worked on the arrest warrant, so I don't think I ever set anything up. This was the first time.
No? Okay, so you know about Florida's public records law, do you?
Sure.
All right, and you know it applies to the Manatee County Sheriff's Office as well.
Absolutely.
All right, so let's see if you can identify this.
These are some, Judge, first off, I would object. This is conversation between me and the witness about drafting the warrant. It has nothing to do with what he submitted to the court. This is conversation between he and I about how it should be phrased. So I don't really understand what's being done right now.
Your Honor, these are two proposed prior warrants of the same version that was actually filed that are statements of this witness. And I'm going to show the court the difference between them and what was intentionally misrepresented and intentionally omitted.
To the court?
To the court that signed the actual warrant. In other words, I'm going to show that this witness has materially made prior statements inconsistent with that warrant, and that there were things intentionally omitted from that warrant that were previously included in the other warrants.
All right, so this is where I'm getting confused. If we're going to impeach with a prior inconsistent statement, I don't think you can start that process with an out-of-court statement and then impeach with prior inconsistent statements. It's my understanding we've got the testimony here today, whatever that might be, and then there might be prior inconsistent statements, inconsistent omissions, commissions, who knows. But I'm not familiar with this. Do you have some cases about impeaching a witness who hasn't yet made any statements using three potentially disparate out-of-court statements?
Well, I think, Judge, if I can break it down for the court, I think we've had a statement by this witness on direct to the effect that this case took time because this detective wanted to be objective and fair and make certain that a proper investigation was done. And I am going to impeach that statement by showing that he knew otherwise and had already concluded otherwise, and that the statements delivered today in front of this court are false. And I can do that through his prior inconsistent statements.
Can I have them?
Absolutely.
Possibly, if they were prior inconsistent statements, but
I don't know.
I would just also ask for a copy for the state. These were never provided in discovery. I just took pictures of one of them on my phone so I can at least read it. The other one we've never seen except for briefly this morning.
Are you asking for a Richardson hearing?
I'm just asking if it's possible for defense counsel to provide us copies or something so we know exactly what's going on. We may have just gotten.
Can I suggest maybe, Your Honor, the court excuse the witness?
Sure.
And we take
Detective Warren?
Yes, sir.
The rule's been invoked, so
Yes,
I'm
sir.
going to have you step outside.
Sure.
Please don't discuss your testimony with anybody, your answers, the questions asked, anything like
Did
that.
bump it up to
Yes, sir.
1.5, but I dropped it back down to 1.25 just now because I'm fine at 1.5 with everybody else talking except the prosecutor. And she talks too fast for 1.5. I'm glad you asked that, QB, because I didn't, or
what I intend to establish.
Spence, because I didn't know what she meant by CLE either.
It's the highlighted portions, Your Honor, in particular, that I plan to go to.
Highlighted portions of must be.
The proposed affidavit.
They're not, first of all, Judge, we need to make clear that these are not sworn affidavits. These are emails. So these are not sworn to documents. It's just the proposed. This is the proposed body of the PC.
I understand.
All right. Just got a tweet from Kathy Russin that says breaking. Jury has been selected in the Ashley Benefield trial. Opening statements tomorrow morning. Court begins at 8:45 Eastern. So there we go. All right. Oh. I need to think about that, Spins. I need to, because I would like to start later than they do so that we can speed through lunch and stuff. I like being able to do that. So I think they said 8:45 Eastern is when court starts, but I got the evening yawns, you guys. Evening yawns.
Okay.
Ma'am?
Proponent,
Yeah,
you
so
want to
here's what I would,
impeach the detective with the highlighted portions of what I'm holding in my hands.
yeah, let me walk the court through it if I may. If the court looks at the proposed warrant of November 2nd at 2:06 in the afternoon,
Yes.
the court will see in the highlighted portion on the second page that the detective says the day before the shooting, Barbara Russell, Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the second proposed warrant, which is approximately an hour and a half later on 11/2/20 at 3:37 p.m., instead of Barbara Russell, her name is now removed and she's no longer an identifiable witness. Now it says the day before a witness, and it says Doug Benefield scraped Ashley Benefield with a box. Then if the court looks at the actual warrant that is submitted on 11/4/20, it says, Judge White, the day before the shooting, a witness, no longer Barbara Russell, explained that Ashley Benefield was inadvertently scratched when someone, no longer Douglas Benefield, but someone walked by her carrying a box. This witness before the court, Your Honor, sought a waiver so that he could speak with Dr. Russell. He got the waiver and he spoke with Dr. Russell. And Dr. Russell told him, and he admitted in his deposition to me, that she told him that Douglas Benefield was increasingly rough and would body check Ashley Benefield with a box, that he would slam it against her, and that it happened on the day of the shooting. And what is in those affidavits, both the actual and the proposed, is not that at all. When a detective comes to the court with a proposed warrant, it's not unusual that the court might ask some questions. And in this instance, if the court saw in the affidavit that it was Douglas Benefield who slammed Ashley Benefield with a cardboard box, the court might ask, being a student street smart, a question such as, what was the relationship between these two? Are they siblings or are they husband and wife? And when told they are husband and wife, Your Honor might say, well, is there a history of domestic violence here? And if the answer to that was yes, then the court might say, could this be a self-defense situation? The point being that the detective might have left without that warrant being signed. I think this is clearly in contradiction to what he's testified to about a fair and objective investigation that went on for several weeks before he submits this actual warrant. So I propose to ask him about his actual warrant and then go back and go over the two proposed warrants to show what he left out and ask him why he left it out. And if he did not think that relevant to a judge that he was submitting the statement under oath.
To prove or disprove what material fact? How is this material?
That this was anything but a fair investigation and a diligent investigation in direct contradiction to what he has told us here today. And just so the court knows, this is not my only point. I have coming behind it even stronger.
Ooh, an even stronger point.
Just to be perfectly honest, I have no idea what we're talking about. The witness was not asked anything that was inconsistent with anything he said before. If the defense wants to try to disprove that it was a thorough and accurate investigation, then the defense can put on evidence in their own case. I don't think bringing in extrinsic evidence, I don't think the evidence is appropriate evidence to use for that purpose anyway. But even if it were allowed in, I don't know that you could do this extrinsic evidence at this point to impeach him for, I said I did a thorough job, but no, you didn't. I'm just a little confused by that. So I would object to any of this coming in at this moment. Sorry, I just don't know what rule of evidence we're proceeding under.
Goes directly to bias of this witness who testified on direct. I didn't ask the question. The prosecutor asked the question, why did it take so long for you to get this warrant? Because we wanted to do a fair and objective investigation. That was what he testified to. And I am going to show with his own statements that that was not the case. It surely goes directly to this witness's bias and motive. And I have additional very strong evidence, Your Honor, to support that as well.
All right, well, whenever I start doing an analysis of these kind of arguments, what I want to hear is, well, what are you trying to do? Because that informs me to which folder to go to open up to see what's the predicate that needs to be laid and then what's the procedure for doing something. I don't see this as impeachment by prior inconsistent statement. Because I don't think, yes, he said I did a thorough job, but I don't think that that is
fair
necessarily then opens the door to, well, why did you put a comma here and not here? And I'm being a bit melodramatic on that point, but because as I look at some of the highlights on the papers you've handed up, I mean, it's really a simple matter of just reordering some of the words. Now on the issue of the Dr. Russell, I see we're in the 2:06 p.m. email, Dr. Russell is mentioned.
Correct.
In the 3:37 email, Dr. Russell's name is now a witness.
Correct.
And I'm trying to look amongst all the talking at the actual arrest warrant that was submitted. It looks like it was attested to November 4th of 2020.
Yes.
I'm not seeing the incident with the.
I can show the court. I have it marked. Yeah.
Yes.
I think, Judge, what distinguishes it from something that's inadvertent clearly is not only is Douglas Benefield now removed from the actual warrant as being the one who scraped Ashley Benefield with the box, but now there is the statement that that whoever this person was inadvertently scratched her with the box. And that is in direct contradiction to what this witness was told prior to him filing that arrest warrant. He asked for a waiver which was given to him so he could interview several psychologists. He went and interviewed Dr. Russell. He acknowledged in deposition to me that Dr. Russell told him
Good
it was
point,
Doug
Dean.
Benefield, and that he was becoming increasingly objective on that date by slamming a cardboard box into Ashley Benefield as he passed her in the hallway. And it was on the day of the incident, not the day before.
Right. But that testimony itself, you're just introducing that's what he was told, not for the truth of that's what happened.
Correct.
Okay, because that would be, how many layers of hearsay? Three
Yeah,
or four?
no, look, I'm trying to show what he knew. Because he's the one who filed the affidavit, Your Honor.
Yeah, so I'll allow it for the very limited purposes of the fact that if you think that this shows that, and you're going to link this up, that he didn't do a thorough investigation, okay, we'll
Trust
see.
I will link it up.
But, I mean,
I'll link it up.
yeah, I mean, I don't know about you guys, but when I write an order, there might be 4 versions of it as I go through.
Well, Judge, at the risk of embarrassing the court, as far as Your Honor's authorship of orders, I have never seen an order like the order that the court wrote for the motion to compel.
Well, that could be taken 2 ways. couldn't it?
I've never seen a better order, Your Honor, or more thorough.
Enough of platitudes. All right.
I would just like to object to him using emails between he and I discussing probable cause as some form of, I don't understand.
Ms. O'Donnell, I'm not quite sure yet either,
Okay.
but we spent a lot of time on this.
Yes.
I want to keep plowing through. I think I'll be able to figure it out when we get to the end of this. I'm pretty sure I'll be able to figure it out and where this fits in, and I will put it in its proper place and give it its proper weight. All right.
Thank you, Judge. And just for the record, I have no intention of involving Ms. O'Donnell in this. It's
Yeah,
going
if
to
you
be,
call her as a witness, we got a problem.
it's going to be limited strictly to the,
All right. You can, but that's a monkey wrench.
we're not going down
All
there.
right.
She's been very professional.
Wow.
Yes, I'm sorry. I apologize. Yes, sir. He was standing at the door waiting on me.
Check.
Mm-mm-mm.
I tell you what, though, let's not plow this earth too many times. Let's plow it, make your points,
And move on.
get in and get out.
And I think you'll find I
All
will
right.
do
Thank you.
exactly that.
All right, so go ahead and take your seat. You're still under oath
Yes, sir.
as you're approaching your seat. Did anybody talk with you about your testimony or discuss anything with you?
Yes, sir.
All right, sir, have a seat. For your purposes, from where you left off, I have overruled the state's objection. Mr. Taylor has some questions for you.
Sure.
All right, Detective Warren, I'm going to put your actual warrant up on the screen, the affidavit. You recognize it, no?
Yes, sir.
Okay. Are you able to see it?
It's a little blurry.
Okay.
Oh, Carol,
Yes.
thank you.
Let me give you this actual copy.
Okay.
So that'll assist you. Now, this was the affidavit that you took to the judge, correct?
Yes, sir.
All right. So I've highlighted on that affidavit in that particular paragraph that you see, and I have a couple of things boxed in red, correct?
Yes.
All right. I want to ask you about them.
Mm.
Does it say that upon further investigation, hold on a second. All right, does it say, Detective, in the third sentence of the top paragraph, upon further investigation, a witness explained that Ashley had obtained the scratch on her right side the day before the shooting when she was inadvertently scratched when someone walked by her carrying a box?
So in the fourth sentence, I do see that it says that, yes.
All right, now. I'm going to pass to you a document and ask you if you recognize it.
Appears to be an email from myself.
Don't tell me what it is. I'm just going to ask you some
Sure.
questions.
Okay.
does that document contain a proposed affidavit that was written by you?
There is an attachment to it. I mean, I can't say indefinitely that's the same one that was sent with it, but there is an attachment to it.
All right. Now, that document was sent on November 2nd, 2020 at 2:06 p.m. in the afternoon, correct?
According to the email you provided me with, yes, sir.
All right. And if you would turn to the proposed affidavit that's attached to that document that I just handed you,
Okay.
not the actual warrant,
Yeah, correct.
the email of,
The alleged attachment, yes, sir.
yeah. All right. So if you would tell me, instead of it saying now, a witness explained, is in that proposed affidavit, does it say Barbara Russell?
I'm sorry. Yes. So on the second page, we conduct an interview with Barbara Russell.
Okay. Now, Barbara Russell, her name has been removed from the actual affidavit, has it not?
Yes.
All right. Does it also then say that Douglas Benefield scraped Ashley Benefield with a box?
It does.
Okay. And going back to your actual warrant, does it say Douglas Benefield in your actual warrant?
No, it says someone,
Someone.
which
Okay.
could mean Douglas Benefield.
All right. And does it also say in your actual warrant that that someone who scratched Ashley Benefield with a box did so inadvertently?
While walking by. Yes.
Now, do you remember, as part of your investigation, you obtained a waiver for you to be able to go speak with Dr. Russell?
That's correct.
And that included also a waiver for Dr. Quintal?
Yes.
All right. Is
Yeah,
it
you
not a
can tell
fact that
she
you admitted
is
to me
like,
that in your
"I'm telling you
conversation
to."
with Dr. Russell, before you filed this actual affidavit to your warrant, that she told you that Douglas Benefield had become increasingly rough and would body check Ashley Benefield with a box?
I think those were your words.
And did you not agree to them?
I'd have to go back and listen to the interview. I apologize, sir.
Did you prepare to come here today to testify?
I did, sir.
You chose not to listen to it?
Objection.
Sustained.
Do you recall being asked the following question on page 23, line 14? This is your deposition of May 16th, correct?
I don't know. I don't have a copy in front of me, sir.
May I approach the witness, Your Honor?
Yes.
May 16th of 23. Okay.
You recall being asked the following question. All right, and does it say on there, starting on line 11, so she said, this is Dr. Russell, so she said he had become increasingly rough, like he'd pick up a box to move it, pass her in the hallway, body check her. Your answer, that's what it says. Do you want to see it?
No.
All right. Then the next question, all right, do you recall her making that statement to you? Your answer, vaguely. You recall that?
Yeah, I still vaguely remember that.
Can I just ask for verification of what you were referring to, the first question? The first question was, you said this excerpt says, what was the excerpt that you're looking at?
That Dr. Russell had, may I respond?
Yeah, you're gonna have to, because I don't know what we're talking about.
The excerpt was that Dr. Russell had told the witness that Douglas Benefield had intentionally slammed the cardboard box.
Excerpt from what? Excerpted
From Dr. Russell's statement that this witness took. I was questioning him about the statement that he took from Dr. Russell. And I asked him, is it not a fact that this is what Dr. Russell told you? And that was the answer that he gave.
And this is where I was concerned. We're now impeaching with a prior inconsistent statement, conceivably. Statements that they were made in one version, but not the other version, and left out of another version, or changed in another version. And you're impeaching with a statement from, an out-of-court statement from this witness, received from a doctor who I haven't heard from, that was made to her, presumably by the defendant.
No.
So we're just so far afield. And this is where I was saying, make your point and get out, because I've tried to give you that wide berth, but
I'm on my way out, Judge.
okay.
All right.
All right.
You plowed
I
it
get the
3
point you're trying
times
to make.
now.
Yeah,
The
okay.
point is, this witness has made multiple prior different statements, spoke with the state, changed it again, left out some what you believe to be material details. I get it.
Okay.
The message is clearly received, if that's the point you're trying to make.
Thank you.
I just believe there's going to be numerous things like we're dealing with right now with this cross-examination.
Let's see how I do, Your Honor.
Okay.
All right. When you bring an arrest warrant to a judge, are you ever asked questions before it's signed?
Excuse me, what kind of questions are you referring to and by whom?
Have you ever been asked questions by a judge about a warrant that you have brought for signature?
Sir, I've submitted numerous warrants. Most of the time we don't talk to the judge.
You've never been questioned by a judge,
Most of the time we don't. Most of the time it's submitted via e-warrants, which is an electronic system.
and it's never happened to you, is your testimony.
Oh, I'm not going to say I've never talked to a judge. I just don't recall an incident off the top of my head.
All right. Let's talk about the wounds to Douglas Benefield and your perception of how they occurred. You stated, did you not, in your affidavit, that based upon the entrance wounds to Douglas Benefield, it does not appear that he was facing Ashley Benefield when she began shooting.
Sustained.
Okay, so I'm not sure if they're going to show photos or not. I'm going to have my little button here ready just in case I need to throw an overlay up real quick.
Did you draw any conclusion as to whether or not Douglas Benefield was facing Ashley Benefield when he was shot?
Do you want me to read the warrant?
No.
No, so this is
Okay.
just testimony.
Just answer the question.
So yes, based on my observations and the work of the team that was assigned to work this case, it appeared that he was not facing her at that time.
And you know that the medical examiner said that he was.
I don't know what the medical examiner said, sir. I wasn't in here.
Oh, you've never seen the medical examiner's report?
Sustained.
I have seen the medical
Hold on,
examiner.
no, no, I sustained it.
Sorry.
It's improper impeachment to impeach this witness with a statement of an out-of-court statement of another witness.
Did you contact the medical examiner's office before you secured and drafted the final version of this warrant?
No, I did not. A detective would have been present at the autopsy, though.
Do you dispute now, as you sit here today, that Mr. Benefield was facing Ashley Benefield when he was shot?
Oh,
Relevance of his opinion.
Well, I think he's made the one conclusion. I think he could be asked, you have the same conclusion today, so overruled.
Thank you.
I don't dispute anything the doctor said. He's the ultimate person that would give you that answer.
All right. Now, you also concluded that the wound to the right leg was from the outside of the leg to the inside. Is that correct?
Objection, relevance of his opinion.
Again, I don't recall ever hearing him testify to that fact, so I don't know where that's coming from. I have not heard this from his mouth.
Did you reach a conclusion as to the direction of the gunshot to the deceased's right leg?
Objection, relevance of his interpretation of the direction of that wound. The state is the one that filed the charge, not the detective, so.
Right, I appreciate it. Overruled. If you can answer.
Sure.
I'm sorry, can you repeat the question?
Did you reach a conclusion, Detective Warren, as to the gunshot wound to the deceased's right leg?
Okay.
Okay, yes, you
As
reached.
to the direction?
Yes,
So like I said, I would defer to the doctor, to be honest with you. I think he has the best opinion on that.
I understand and I appreciate that, but I'm interested in what your conclusion was.
So based on my observations, I wasn't there when he was there and I never saw him in person, would be that the right side of his body was facing Mrs. Benefield.
That's not the question I asked you, Detective. Did you not understand it?
Apparently not. Can you repeat it,
Okay.
sir?
So my question to you is, did you reach a conclusion as to the gunshot wound to Mr. Benefield's right leg?
Based on what I saw and everything at the scene, I believe that his right side was facing her. So that would have been what was struck first.
Did you state that the entry to the leg wound was on the outside of the knee and the exit was on the inside?
I could refer back to the warrant if you'd like, sir.
Please. If that helps refresh your recollection?
Sustained. Well, if he's refreshing recollection, it's a different issue.
Yes.
But
Refer to your warrant, Detective, see if that refreshes your recollection.
Oh, Lord, have mercy. Hmm.
So in my affidavit for the warrant, one of the rounds entered the outside of the right leg and exited the inside of the right leg. That was based on what I was observing.
And as you sit here today, is that still your position that the entry wound was on the outside of the right knee and the exit wound was on the inside as opposed to it being reversed?
Based on my training experience, what I observed, sure. But like I said, I would always defer to the doctor. I would never argue with the medical expert.
So I would assume then you would defer to the doctor as well as it relates to the proposed wound to the arm.
Absolutely.
All right. So you got wrong. One, whether or not Mr. Benefield was facing Ashley Benefield when he was shot, correct?
sustained and
All right. Your conclusion was inaccurate.
sustained.
All right, moving on.
She is.
You told us that you observed Ms.
Irritated.
Benefield that night, and you did not see any signs of domestic violence, struggle, or things of that nature, such as torn clothing.
That's accurate.
Okay. And is that, in your experience, always the case with domestic disputes?
No, not always.
All right. And you're aware that the shirt that you observed on Ms. Benefield that night, where it came from?
I'm sorry, which shirt are you referring to?
You said that you did not observe any
Right,
torn
TV.
clothing on Ms. Benefield.
Look, I'm just going to stand
night.
up.
I did not.
Like her shirt was not torn, her shirt wasn't torn.
I didn't see anything, no.
Okay. Where did the shirt that you remarked that you didn't see torn come from? Do you know?
I have no idea where she purchased the shirt or where she got it, sir.
Isn't it a fact, Detective? Now, you're the lead detective, correct?
Sure.
That shirt was brought to her by another deputy while she was sitting in a squad car, was it not? That would be
I
Deputy
wasn't at the
Paul.
scene, sir.
But wouldn't that be something you'd be expected?
I don't know if it is or not. Let me finish the question.
Wouldn't that be something as the lead detective you would be expected to know before you make the statement that you didn't observe any torn clothing, which is inconsistent with domestic violence?
No, and I think if you actually play it back, I already testified to the fact that she was wearing a sports bra.
All right. I want to ask you a couple of questions about the home. You drafted a search warrant for the house, correct?
That's accurate.
All right. And you drafted that search warrant pretty much immediately based on your experience of knowing that you wanted to get into the house to conduct the investigation.
I drafted that search warrant based on the other detectives on scene advising there was probable cause to assume that a potential homicide occurred inside. Yes, sir.
Okay. Now, I'm glad you referred it that way, because isn't it a fact that that warrant that you were drafting less than 75 minutes after the shooting, isn't it a fact that you didn't describe it as a homicide, you described it as a murder? Did you not?
I'd have to look at the warrant again, but that's
I'm
possible.
happy to
Sure.
show it to you.
Yeah. So what's the relevance?
I think the relevance is to show that this detective had already reached a conclusion that this was a crime rather than homicide, despite his testimony that he wanted to do a fair and objective investigation over the course of an extended period of time, and that he was referring to it and calling it a murder within approximately 75 minutes following the incident.
All right.
He'd already made his mind.
Detective Warren, can you step out in the hallway? It's easier if you step. We just send you
That's not a problem,
having them approach. The rules may invoke, don't discuss your testimony. Don't let anybody talk to you about your testimony.
Yes, sir. Thank you.
Perry Mason moment. Right, Kel? I know. It was murder. I mean, I don't know, unless
So
he's
I don't
trying to
think I
say,
have any
oh, well, it could have been
search
like
warrant.
accidental,
What are the attachments? I don't recall.
because 75 minutes into the investigation, you may not have known that, you know, what happened. If it accidentally went off and nobody was even pointing at anybody, you know, but still, he's going to slap this man.
Seeing it.
I'll give the court a copy.
Well, let me answer this. So the point you're making is that instead of using the word homicide as the crime that's being investigated, the detective used murder.
Yes. And
So what statute would you have proposed that he should have used? Because as we know, a search warrant, what's the point of a search warrant? That a crime's occurred or is occurring or has occurred, and that there's probable cause or a reasonable probability that the fruits of that crime or the evidence of that crime is going to be found within the place to be searched.
yes.
So a search warrant will list a crime or crimes that have alleged to have been committed. So what I'm saying is, what is your argument that he should have put as opposed to murder with 78204?
Yes, sir.
Yeah.
As opposed to 78204?
My argument is that every single member of the Manatee County Sheriff's Office but him described this as a homicide, including the medical examiner, rather than a murder. But that's not enough. This detective, in his deposition to me, believe it or not, under oath, said and represented that every homicide is a murder, and anybody who shoots and kills somebody is a murderer. That is his perception of murder. As opposed to an objective evaluation, what I am tying in is that within 75 minutes after this incident occurred, this detective had already decided that my client had committed murder. That's what I want to bring out.
All right. I appreciate all that. I'm happy to receive that. I'm going to respectfully, as you said today several times, suggest that there is a much more direct route to get where you want to go. There's no jury here, so, impeach, but
Okay.
okay. So I think you
I got
can
it.
get there. I think we can be a little bit more direct about it.
Yes.
I
I understand.
Yeah.
I'll go right to it.
think, you want to say, hey, you said murder in your
Right.
search warrant. Yes, I did.
Yep.
That was within 75 minutes of being called out. Yes, it was. And then you can make all those arguments you want to make about how that was biased and his mind was made up and it was predisposed, how this was going to go. And I'll receive all of that.
Understood.
Okay. There was one other issue you were asking about.
Judge, before we move on from that, just so I can understand from defense counsel, is because I'm looking at the actual search warrant and the only time it refers to murder is where it says the statute number. Is that the only instance in which he's referring, or is there some other? I couldn't find another one. I just want to make sure before we continue that we understand.
I assume that's the issue.
Oh, thank you. I just want to make sure.
Whew. Sorry, I keep yawning.
I think we can bring him in.
Yes, he's on his way.
Did you say murder? Was it within 75 minutes?
All right, Detective Warren, take your seat back. Did anybody
You
discuss
can't
testimony
handle the
with opposed to
truth.
talk with you?
No, sir.
All right. So I have sustained the state's last objection. Mr. Taylor.
So Detective, you described the incident that you were investigating within 75 minutes of it happening as a murder.
In the search warrant?
Yes.
Sure.
All right.
I think all of our search warrants actually are for the same thing. We're investigating murders.
You did the same thing for 2 other search warrants.
Yes, sir. That's what our unit investigates, are murders.
Now, did you tell me under oath that every homicide is a murder?
I believe I might have misspoke when I said that, but so basically the intentional killing, unlawful and intentional killing of a human being is a murder, yes.
Did you tell me, just to make sure that it wasn't a mistake, did you not tell me that anyone who kills is a murderer?
Well, there's differences in whether it being
Is the
justified or
answer to
not.
my question yes?
Objection, is this impeachment?
I'm going to sustain.
Thank you.
Again, I think when we're impeaching with a prior inconsistent statement, we don't lead with the out-of-court statement that might be inconsistent. I would need to hear the testimony here today, what the answer is, and then I can determine if the prior statement is inconsistent. So
How
I'll
long
sustain.
has this guy been a lawyer?
Do you remember me asking you at the deposition the following question? On page 11, line 20, you could have a homicide that's,
Objection and proper impeachment.
I'm going to sustain. I need the answer. I need an answer here in open court, and then we can discuss whether that's a prior inconsistent statement.
are all homicides murders?
The unlawful killing of a human being is a murder. Yes, sir. There are some cases where it may be justified.
It may also be excusable.
Sure.
Is everybody then who kills a murderer?
And that's a matter of opinion, I guess. But I mean, by the definition, a murder is the unlawful killing of a human being.
Is it your statement that anyone who kills is a murderer?
Objection, asked and answered.
Sustain.
Would you be surprised to learn that you were the only one
Objection.
Let the question finish, please. Go ahead,
in
sir.
the Manatee County Sheriff's Office throughout this case who designated it as a murder as opposed to a homicide?
Don't answer. Sustained.
Another interview that you did was of Dr. Quintal, was it not?
I did an interview with Dr. Quintal, yes.
And you conducted that interview pursuant to a waiver that was given to you by Ashley Benefield so that Dr. Quintal could share with you the health information that he derived from interviewing Ashley Benefield, correct?
Yes, sir. We were trying to gain an idea of what their relationship was like.
Did you learn during your interview with Dr. Quintal that Ashley Benefield was afraid of Douglas Benefield?
He may have made some statements indicating that she made some, or he had some feeling about that.
Did you learn that she was scared of violence from him?
Like I said, he said a lot of things. He also said he didn't understand why Douglas was with her.
Did you learn that Dr. Quintal told you that Douglas Benefield was a controller?
Objection, this is.
Sustained.
Not offered for the truth, Your Honor, offered for what this witness learned knew during the course of his investigation.
And that's.
Well, what does that have to do with, I'm not understanding what the relevance of that is. That a doctor told this witness that the defendant said the victim was
Not the defendant,
controlling.
Your Honor, that Douglas Benefield, the victim,
Right.
was a controller.
Right, but the doctor would have heard that from the defendant?
Yes,
All
but
right.
it's also the doctor's opinion. He was giving this detective his opinion of Douglas Benefield, and he was describing Douglas Benefield to this detective. And there's a reason why I'm asking. I'm going to follow up with a question.
It sounds like you're offering that for the truth.
No, sir. I think you'll see why I want to show that this witness was aware of this.
Okay, I don't know, but we're going to see.
I will tie it up for the
Okay.
court very quickly. Do you recall Dr. Quintal telling you that he believed that Douglas Benefield was a fake who used God as a pretense?
I remember the topic of God did come up. I don't remember, like I said, every word that he said verbatim, which is why it would have been tape recorded.
And you have that recording, do you know?
You should have it as well. Yes, sir.
And do you recall Dr. Quintal telling you that Douglas Benefield,
Yeah, listen, I'm really, sir, not understanding. I mean, what is the point of all of this?
next question. If Douglas Benefield had a violent background, is that something that you would want to know?
Sure.
Is that something that would be significant for purposes of your investigation?
one of the things that we looked at was he violent with her? That's why we went through all of the reports. We wanted to know the background because, as I stated earlier, we wanted to do a thorough and accurate investigation before anybody was charged with a crime.
Would you tell His Honor, Judge White, whether you ever did a background investigation to determine whether or not Douglas Benefield was violent?
We did searches based on what was available through the Manatee County Records database. And I believe we also got some information from Charleston or somewhere, one of those places up there where there were some allegations, but that was it.
Do you remember me asking you this question at your deposition?
Well, I don't know if it is yet. It might be inconsistent with the statement that was just made about the investigation that was done, but I don't know.
I asked the question.
Forget about tying
you
it up.
remember being
Dude
asked the
needs
following
some
question on
Gorilla
page
Glue.
84, line 16. When you investigate a case like this, you told me that you don't recall whether or not you did a background on Douglas Benefield himself. Your answer was, I don't recall doing it myself. No.
I have
You're talking
some
about
if you
background
need
meaning the
to
criminal
borrow
history.
it.
I don't recall doing a criminal history on Douglas Benefield to see if he was a convicted felon, but a background check, it's actually listed, I believe, in some of these other reports where we looked up Manatee County computer records databases and pulled those reports.
So is it your position, Detective Warren, that only convicted felons can have violent backgrounds?
I overruled.
Thank you.
If you repeat the question.
Is that what you're telling us?
Can you repeat the question?
Yes.
Thank
The
you.
question was, are you telling us that only convicted felons can have violent backgrounds?
No, but there is a difference between doing a computer record check through our personal database and doing a criminal history check through NCIC, FCIC.
So let me ask you the question again, but perhaps you didn't understand it.
Perhaps.
Did you ever do a background investigation to determine what you've told us you would want to know, whether or not Douglas Benefield was prone to violence?
Like I told you, sir, we did searches to find out what information was available. You can change the definition of background check all you want to. Yes, we did our due diligence.
Have you read, by the way, have you had an opportunity to read or discuss the stand your ground motion we filed with the prosecution?
I did, but it was months back, I'm sure.
There's a representation that Douglas Benefield grabbed Mrs. Benefield by the left hand to prevent her from leaving. Do you recall that?
No, not off the top of my head, sir.
All right. You, as
We
part
need
of your
some,
duties and
right?
responsibilities as the lead detective on the case,
Buttered.
you requested swabs, did you not, of various parts of Miss Benefield?
We did.
All right. And that would include her left hand, would it not?
It would have included the areas that we were explained by her attorneys to pay the most attention to.
Did it include her left hand, detective?
You would have to probably direct that towards the crime scene tech that collected the swabs.
Well, how about if I use your report?
Okay.
Objection, Judge.
Yeah, if he's just relating what someone else said or did,
No,
I'm going to sustain.
I'm asking if he requested that swabs be taken of her left hand.
Okay,
That was the
that question can be
Yeah.
asked.
That was the question. Did you request swabs be taken of Miss Benefield's left hand?
I requested the swabs be taken of her arms, legs, hands, and neck.
Okay. As part of your duties and responsibilities as a lead detective, did you ever get the laboratory results of those swabs from FDLE, Florida Department of Law Enforcement?
Was it FDLE or DNA Labs International?
Actually, I believe it was DNA Labs International. I stand corrected.
Okay.
Did you get the results back?
Yes.
Did you learn that out of all the people in the world,
Objection to asking this.
Burn.
Again, you can ask your question and then we'll have the objection. Again, I make this ruling because there's no jury here.
I know.
So if I sustain it, I sustain it.
But he's testifying by asking the question.
You know that the lawyer was like, dang it. He got one over on me.
did you learn that of all the people in the world, only two people could not be ruled out for having left DNA on Miss Benefield's left hand? John Sant, the neighbor, and Douglas Benefield.
I'm sorry.
No, do you have an objection?
Yes, that calls for hearsay and
Sustained.
misrepresentation of the report.
I haven't seen the report, but it's.
Lord have mercy.
sustained. Absolutely.
All right, Detective, I have a few questions now I'd like to ask you about some areas that we discussed previously under oath. I had asked you at the deposition various things about Douglas Benefield. For example, in
I don't know.
I gotta say the question.
Yeah, so a deposition is an out-of-court statement, which is the first phase of hearsay. I don't know why it's going to be offered, but I don't know if you're refreshing our recollection, which is done a different way. I don't know if you're impeaching. If you're impeaching with a prior consistent statement, all I can say is, again, I need a statement here in open court, and then we can figure out if that prior statement was inconsistent.
Here comes the statement. Detective, do you have an opinion? How would you describe Mr. Benefield admitting that he shot a gun in the house, in the kitchen, to intimidate Miss Benefield to stop speaking?
Objection.
Sustained.
How would you characterize such?
Hold on, I didn't hear the rest of it.
Yeah, I'm just asking him how he would characterize such an act of shooting a gun in the kitchen to intimidate someone from speaking any further.
You want this witness's opinion about how he would characterize without any frame of reference? I mean, what do you mean?
Okay. Detective, were you aware that there was an allegation that Douglas Benefield had shot a gun in the kitchen ceiling of their home to stop Mrs. Benefield from speaking any further?
I was aware, or I heard that there was an incident allegedly that a firearm was discharged in the residence into the ceiling.
And would you describe that as a violent act?
I guess it all depends on the purpose and how it occurred.
Such as?
Objection as to his opinion.
Yeah, I'm going to sustain.
Well, I gotta
on
see
the-
that,
and we're getting
QB.
into a collateral matter, how this witness would characterize an act that he did investigate.
I gotta see that. Can you find it and give us a timestamp and we'll watch it before we end for the day? Which, if I'm gonna be honest, you guys, we still have like 2 hours left. There's no way we're gonna finish tonight. So, yeah. Yeah, there's no way we're gonna finish tonight. Oh, it was a full day. Maybe go to you know how whenever you're scrolling through a YouTube video and you can see the like little blue across the thing, and that tells you where like the most engagement was at? Usually those high spots are the most watched spots, you know, if that helps. They're like this. You see on the screen right now? I don't know if you can see that, but on the screen, there's these like gray marks, and those are usually like where the most replayed sections are. But anyway. Okay. If you can't find it, don't worry about it. I mean, we can find it later, you know. But we're going to go a little bit more, maybe another 15 minutes, and then I'm going to call it done for the day because it's 8:15. And we got to do dinner, and I barely seen my husband today. So,
Investigate, he wasn't there for, he's heard about through some unknown source. So, no, what his opinion of that, I would find is irrelevant.
All right. Were you aware during the course of your investigation, detective, that there was an allegation that Mr. Benefield would punch holes in the drywall of their home?
I believe that I had heard something like that, but I don't recall where that was from.
Were you aware that there was an allegation that Mr. Benefield had beaten his first wife up on their honeymoon?
Objection, Judge, what is it? It is irrelevant what this detective may or may not have known about his past.
Well, actually, Judge, this detective has testified that whether Mr. Benefield had a
sorry.
violent background is something he would want to know, that it would be significant to his investigation.
Right. You know, I'm not
I'm
taking
a
any of the truth
maniac.
matter,
You
so-
know that, right?
I understand.
You just, did you hear this?
Those.
It doesn't prove that those things happened.
I understand that.
So I'm not sure why we're asking them this problem.
And that would be the second question is, so what's the relevance of whether he heard that the decedent may have been violent towards, I don't know, would you say a first wife? I don't even know who that is. I don't know when they were married, how long they
Yes.
were married. I don't know the
First
nature of their
wife, Renee.
relationship. So I'm going to sustain as irrelevant.
Okay. You are aware, are you not, of an incident where Mr. Benefield was seen by a neighbor at night standing in her yard? Sorry.
Yeah, actually, we discussed that during the deposition. I remember because I had some questions about it myself.
There's a police report that accompanied it. Have you
Yeah.
reviewed it?
I did it one time, and I believe that the witness said that there was a person standing there. And I asked you how we got him identified because I guess they identified him by his voice, is what you told me, which I found odd because why would you sneak around and then talk? Kind of, you know.
Did you review that witness's deposition?
I did not.
It's Exhibit 5 to our standing ground.
I don't have access to those, so.
Have you ever placed a tracker on anybody's car?
I'll overrule.
Have you ever placed a tracker on anybody's car without the appropriate legal authority?
No, but I've done it with the proper legal authority several times.
I want to lastly ask you about some photographs of Miss Benefield. There were two sets of photographs taken you testified to, correct?
Yes, sir.
Some were on the evening of the incident, and then there was a set that were taken a few days later.
Yes, sir. That's accurate.
So to cut to the quick, if we can, and not test what has up to this point been the judge's considerable patience, the scratches that were preserved in those photographs on Miss Benefield on the night of the incident, you saw them, did you not?
In the photographs later, yes.
Yeah, and they show was red and fresh, do they not?
They appear to be red, yes. I
Okay.
can't tell you how fresh they are. I'm not a wound expert.
Okay, well, they weren't scabbed.
Like I said, I saw a photograph later on.
Let me show you the photos.
Sure.
Let me just show them to you. Because I don't think that picks it up.
Thank you, sir.
I asked you 4 photographs that have been previously considered. Do they depict scratches on Miss Benefield on the evening of this incident?
They appear to.
Okay, and do the scratches appear fresh?
I don't think necessarily the one up under the sports bra appears
Are
to
they,
be.
what color are they? Are they pink?
Like I said, I'm not a color palette expert, but I would go with sure. It could be pink or red.
Okay, are any of them scabbed?
It's kind of hard to tell because they're so minute.
Do you see any scab?
No, and I don't actually even see an open wound on this one that would scab over. So,
Okay, let me show you the photographs that were taken a few days later.
okay.
Okay, thanks, QB.
Thank you, sir.
We'll finish with fitness and then
Why are these not marked? Yeah,
and
if you're gonna
then
use
watch
photos, I
that
want,
one.
you either need to mark the ones you're using or use the ones that have already been admitted. Because we need to have a record of what you're showing the witness.
Jeez Louise.
And Madam Clerk, I'm fine if it's just defense 1, 2, 3, 4, 5, 6. You don't have to use the letter.
Good, Your Honor. Detective, I previously showed you defense exhibits 1 through 4, correct?
Yes, sir. That's correct. There you go.
Now I'm
Can
going,
I just see them? I'm sorry.
now I'm going to show you defendant's exhibits 5 and 6.
Thank you.
Mm,
I'm going to ask you if those are photographs that were taken several days later.
yep.
You would have to talk to the crime scene tech about that for proper identification, but I believe so. Yes, sir.
And is the color of those scratches different than the color of the scratches in the photographs that were 1 through 4?
Well, the scratch that was on her hip, the red scratch that I said didn't have a scab, that's not even photographed in any of these, just so you know, it's actually gone.
Mhm.
Other than that small little minute thing you can barely see,
Yeah.
there does appear to be some scabbing, but it's very, like I said, very tiny.
Very tiny.
Are you familiar with the concept of blading?
I am.
And tell us, educate us a little bit about what blading is in the sense of it being a defensive posture.
Are we talking about it in regards to law enforcement?
No.
Okay, well, I'm just, I'm not a jujitsu expert or anything, so.
I understand. I'm talking about with respect to minimizing the area of your body that is exposed to potential gunfire.
Margaret.
Okay, I guess if you were trying to minimize the area exposed, you would possibly turn your smallest side to it. Which would be your side, sure.
Okay.
What are you
Otherwise known as
awarding,
blading.
Margaret?
If that's what
What?
you want to call it. Blading typically isn't a complete turn. It's more of a 45-degree angle or so.
Okay, again, to minimize the exposure.
Well, blading or interview stands, those types of things, blading is typically done like for our purposes. If I'm out interviewing a suspect, I'm going to blade my body and turn my gun sight away from them because honestly, that's more of a threat if they're looking at my gun while they're thinking about fighting me. I want to keep that away from them. It also provides for balance.
Right. You want to make sure that they can't get the drop on you.
It's more of a safety thing than a.
The people you just interviewed with, Margaret? Are you going? Like I didn't even this interview, but 2 hours ago, they already want me to come meet the person in charge. Yes. I'd say thanks, but now I have to be in court. So what are you going to do, Margaret? I thought you were like, I'm going to have to think it out, she says. Well, just don't forget what you came in here saying was that you had vibes and that they want you to do the work of 3 people, Three people. Don't jump. Really think about it. Okay, no rash decisions. I know it seems a little off to me, and I think they're desperate to hire. I won't jump, I promise. Up your asking salary to 3 times. Yeah. All right. Just wanted to burst in with that breaking news. The salary will have to come up. Yeah, right? Mm, quite a bit. Well, I'm glad that you shared that update with us because we were asking, we did want the updates. Okay.
Offensive thing, at least in my opinion.
Yeah, to protect.
Like I said, I'm not an expert, so.
To protect you. As part of your investigation, you determined that the firearm that was used to shoot Mr. Benefield was owned by Ashley Benefield.
One of our detectives, I'm sure, did would have done that part of it. I don't recall doing that part myself.
All right, but you do recall it was lawfully owned by her.
As far as I'm aware, yes.
Yeah, and that she had a concealed weapons permit.
She may have. I don't remember she did at that point, but it's possible.
I don't believe I have anything further, Your Honor. Thank you for your patience.
State, redirect. All right, can this witness be excused? Defense, can the witness be excused? Mr. Taylor, can the witness be excused?
Yes.
All right,
Okay.
Detective, you're excused.
Thank you, sir.
Can you reach me those papers?
Yes, sir. There's a couple papers. You want those too?
Good.
Yes, sir.
That dude's like, let me out of here right now. Or so help me, so help me. Do they want you to commit to taking the offer before meeting the boss? No, no offer yet, and I wouldn't dare. Good. Yeah, because no. Those are the ones that usually are a problem. If they can't give you a minute to think about it, something is wrong. He's going to have to testify again. That ought to be fun. That ought to be interesting, right? All right, let me go run into and grab a quick link that QB sent. Oh, okay, cool. Judge gets heated in hearing ahead of trial. So this was 6 days ago. All right, let me share this tab. All right. Let me make sure I got the right one up. Okay. All right, let's see the judge lose his wig, right?
Right words. Searching for the right words. My level of confusion as to what both sides are doing and arguing is about pegged. Multiple times throughout multiple hearings, including on July 11th of 2024, Mr. Taylor and the defendant have emphatically stated this is not a battered spouse syndrome case. I've heard that multiple times, and I specifically pick the hearings we had on July 11th on other matters because it came up right at the end.
about the deposition of the expert, Mr. Ferris, was coming up. And Ms. O'Donnell had said, I don't have a transcript, this is from my memory. Ms. O'Donnell had raised an objection that if Mr. Ferris was going to talk about, or he was a battered
Lemonade.
spouse syndrome expert, the required notice under the rule had not been given. And Mr. Taylor said again that this is not a battered spouse syndrome case. And so I left the courtroom on July 11th saying, okay, this is not a battered spouse syndrome case. We'll see what happens at the deposition. The very next day on June 12th at 4:33 p.m., the defense files notice of intent to rely upon battered spouse syndrome defense. And I looked at the notice of intent, and it complies with the rule. It gives the required notice. It talks about what evidence is going to be used to support the battered spouse syndrome defense. It provides the essential facts upon which the defense is going to rely. It provides a list of witnesses, including G, Bruce Eric Ferris, as witnesses who are going to support the battered spouse syndrome defense.
He's scratching his head.
And I don't recall if it was at that hearing or another hearing, we had a fairly in-depth discussion about the case law, including Oquendo and the differences between PTSD and reasonable person, and how battered spouse syndrome can be used in a stand your ground or a self-defense situation. But the emphasis was still, this is not a battered spouse case.
Judge, in fairness, I footnoted that.
In Hickson, I'm sorry, and so I'm confused there. On the state side, I've looked at the state's motion in limine to request a proffer of expert testimony. What I don't see in here is authority for that, where I can order the other side, you will give me a proffer of your witness's testimony for me to make a decision. I've made decisions based on a transcript that's been provided to me on discrete areas that may or may not be admissible. What this screams out to me, and I have no idea why we're not doing it, is a Daubert hearing. That certainly one side or the other can move for a pretrial ruling on the admissibility of scientific or technical evidence under 90.702 and the federal Daubert standard, where all of these issues, the qualifications of the expert, what they relied on, are those sources reliable? Did they apply reasonable and scientific methods? I mean, all the, I don't have the predicate in front of me, but that's where that hearing would be. Ask for a Daubert hearing, the other side needs to comply. So I don't consider today a Daubert hearing. This is just a straight motion in limine where I haven't heard from the expert. I haven't heard anything, I don't have any facts in front of me about the Daubert factors or 90.702 factors. I haven't even been provided a copy of his transcript. So I don't know why we didn't do that. Next, my confusion is we discussed Hickson at a prior hearing, and it talks about as reflected in the rule, and I think, if I remember correctly, Hickson was a Florida Supreme Court decision that predated this rule and essentially laid out the framework of what eventually became Rule 3.201, I think it is, the battered spouse rule. And so Hickson kind of laid that out and fleshed out what then the Rules Committee turned into the actual rule that was then subsequently approved by the rulemaking process. And what Hickson talks about is if it's a battered spouse case, and the rule as well, and the expert interviews the defendant, then the state has every right to get its own expert to do its own evaluation of the defendant. Now, what I've heard is apparently Mr. Ferris, during his interview or during his deposition, said he interviewed the defendant for several, and I'm just relying on representations now. I have not seen it with my own eyes. Interviewed the defendant for several hours. There was some initial veracity or some initial interview. I don't know how long that was, but then there were 2 subsequent interviews after he was retained for this case. On the flip side, if the expert does not evaluate the defendant and is going to just speak about general, non-specific traits, which is what I've been hearing for the defense, it's going to be very general. It's going to be very non-specific. There was talk from the defense about there's going to be hypotheticals posed, but I will say that in the back of my mind, I was always wondering what those hypotheticals were going to be, if they were going to be very generic and non-specific. And then those hypotheticals started bringing in the facts of this case, how that would play out. But here nor there, that'll be a decision to be made later. But in this situation, what I'm hearing is the expert evaluated the defendant twice. And I only say this has nothing to do with my ruling on whether I'm going to order a proffer or not. It just goes to I want to just flesh out the issues of my confusion about, is this battered spouse? Is it not? What part of Hickson are we talking about? Is there been an evaluation? There's going to be hypotheticals and opinions expressed based upon the facts of this case?
Facts.
Or is this just going to be a very generic, he hasn't interviewed her, it's going to be a very generic discussion about domestic violence victims? We all know what brackish water is. I don't think Hickson allows for some kind of brackish presentation here. It's either battered spouse syndrome and there was an evaluation and the state has a right to do its own expert evaluation, or there was no evaluation and it's purely generic information and hypotheticals. I say all of that with, just so you guys have the walking away knowledge of, we're less than a week from trial. And I am so confused. Is this a battered spouse syndrome case or not? I keep hearing it is. I keep hearing it isn't. I've heard everything I'm going to hear. I mean, I gave you both multiple opportunities to tell me. You just need to know. I still don't know where we're at. But my answer is this. I don't think there's I can't think of any provision under the law. I'm not aware of any authority under the rules that would allow me, and I haven't been provided any case law authority that gives me the discretion to say, defense, you will proffer your expert testimony. It's usually the opposite, right? That somebody wants to put something in, I have an objection, I rule it's out, and the defense or the state will proffer it so it's in the record. And of course, that proffer is, if you read the appellate court decisions on that, this is why it's so important for the proponent to get that proffer in, because it gives the trial court that opportunity to hear the evidence and hear the questions and hear the cross and make a ruling that avoids trial court error. So with that lengthy explanation, the state's request for the court to order the defendant to provide a there it is. Proffer is denied.
Well, it appears that even when he's heated, he's not overly heated, right? He's a very calm judge. He's a very calm judge. I don't know. I don't know. I don't know.
Searching.
He went off calmly. Yeah. No, I know. He did. He did. Yeah. He was angry. But he's very chill. He's very chill. QB said, I'll see if I can find it. Find what? Is there a difference, a different time when he loses his cool? Oh, well, I want to see the one where he's not chill. He was super chill in that one. He was super chill. All right, let's take a look at the poll. We have 20 votes. If you are wanting to let your vote count in the poll that's in the chat, I'll give you a couple more minutes to QB said, I thought that was it. I had no notice, ma'am. You know how I roll. QB, hey, because I don't realize that I'm being impatient. And QB's like, give me a minute. I've only got one hand. I only got one arm. So, yeah, I'll give you a couple more minutes to vote. You did not fail, QB. You are not a fail, ma'am. Facts are you are epic. And we love you. And you do not fail. What's getting stronger, your arm or the facts? The fax machine. You'll have to tell us which one you're talking about. I'd say your arm because you've been good and you've been taking care of it and doing your PT and stuff. See, there you go. I worked out with a whole rubber band today. There you go. Do you want me to look for it, QB, or are you looking for it? The one where he flips out. Gold star. Oh, she said, I'll find it, but not before you get off here. Judge fires back at ballerina's defense for claiming court has bias against women. Is that one it? Wonder if that's it. A whole rubber band. It's one of those big exercisey ones, I'm assuming, right? Play it. Morgana said, that's what she said. The storm. Ay, 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 ay. All right, let's see if this is the one. Judge fires back. Let's see if this is it.
Here's what we have in this case. And
We have
I
a
know
failure to
that the
communicate.
court didn't appreciate it. Bias against women is endemic to America's institutions.
Did you just say I didn't appreciate something?
I'm sorry?
Did you just say I didn't appreciate something?
I don't know if that's what I said.
Hold on, I'll check. So here's what we have in this case, and I know the court didn't appreciate it. Biased against women is endemic to America's institution.
Yeah, I'm getting
So
ready.
what do I not
I'm
appreciate?
getting ready to tie in what the court didn't appreciate. I footnoted in my notice of battered spouse syndrome that it wasn't traditional battered spouse syndrome, because traditional is the woman is still in the home. In this case, she was not still in the home. All right. But bias against women is endemic to all our institutions. And what we have in the testimony of Justin Warren is my opportunity to show that that bias was at stake. And the court is prohibiting me from the granting of its motion in limine that the state filed from questioning Detective Warren.
I'm sorry, point out in my amended omnibus order where I said you may not do that.
You granted the state's motion and said that until such time as I show it is relevant.
So I didn't say no. I said any impeachment must
Correct.
be relevant and material.
Correct. And
Okay.
I have filed this clarification to show the court that it is both relevant and material, and that's why I cited this case law. I don't want to be in a position, Your Honor, where my cross-examination throughout the trial is methodically interrupted by either an objection from the state, or we have to send the jury in and out on multiple occasions, because that's going to create, it's not only going to render my examination less effective, it's going to create animus. I don't know if the jury's animus, I don't know where it's going to be directed. I only know that I'm here with an obligation to defend Ms. Benefield to the best of my ability. And under the case law, such a cross-examination of the lead detective is clearly relevant and material. So I have filed this clarification so that we could get past that. That's the purpose of this. I attached to my motion an excerpt from the deposition of Detective Justin Warren, wherein he says all homicides are murders and all who kill are murderers. Now, to me, Your Honor, that is clearly a bias. And it makes me wonder what chance Miss Benefield had in the mind of Detective Warren when he was already describing this as a murder less than 45 minutes after the shooting, when he was drawing up his first search warrant. That is indicative of bias. I am allowed to probe that detective on cross-examination to show that his decision was motivated by bias. Whether or not I'm successful is a separate collateral issue. That'll be up to the jury. But the court, nonetheless, provisionally granted the state's motion in limine. Again, I filed this clarification so that we could get past that. Especially given the fact that self-defense is Ms. Benefield's defense. And if you have a lead detective saying that all
Storm bad.
homicides are murders, it's not only a complete misstatement of the law, but it clearly shows bias. According to him, the 90-year-old motorist who has a diabetic incident while he's driving his car and hits and kills a pedestrian is a murderer. And the fact of the matter is, under the law, that would be an excusable homicide, assuming no drugs or anything else was at play. The court is provisionally restricting me from questioning the detective about that. That shows bias. It's a fair inquiry on behalf of Ms. Benefield, and I should clearly be allowed to make that inquiry. And I think the court restricting me from doing it is an impermissible preclusion of Ms. Benefield's right of cross-examination. That's my position, Your Honor.
State?
Judge, I would just say this is not a motion to clarify. This is a motion to state everything I've already stated that the court has already ruled on. And I think your order is clear. Thank you.
Mr. Taylor, rebuttal?
No.
All right. After I reviewed the defendant's motion, request for clarification of the court's amended omnibus order, I read it as a motion for rehearing. I reviewed it carefully to see if there was any legal points or factual points that weren't addressed or needed clarifying. I will note that the state had filed a motion for clarification, and as I reviewed my prior order, I did notice that I had neglected to put the actual legal ruling in and the basis for that. However, I've had a chance to review the amended omnibus order, and I don't think it needs clarification. And quite frankly, I think, and I find that the request for clarification is really a motion for rehearing, and I'm going to deny it.
He doesn't take no very well, right? That's a fact.
All right, we have two things left. The jury questionnaires and the request for paralegal to remain at counsel table. But I have a plea at 11 o'clock. And I don't, did Miss Glenn come in? Not yet? All right, I've got a plea at 11 o'clock, so I'll need to take a little bit of a break. I think it's negotiated. Are you covering?
No.
I don't even have the state here for it. All right, we'll just keep going.
Judge, I think there's a third issue, unless perhaps I misunderstood the court's earlier response denying the proffer of the expert. I have also moved to exclude the amended discovery that they sent, designating Kimberly Griffin as an expert and her CPT notes.
I think that's I think that's
Did you file a
basically it.
motion? Did you file a motion?
Response.
Oh, in the response.
Yes. And in my response, ended discovery was like.
Yeah.
So my copy is long as
Bear
you
with
want
me, and it might be in the court file too, but bear with me.
Yeah, that's it. I don't know. Hopefully, you know, days on into the trial, maybe he'll yeah. Maybe he'll come into it and do a little rawr, you know. There's more. He filed a continuance because the judge denied his motion to have the paralegal at the defense table. Yeah. He's done with him, right? Well, this video is ended. The judge fires back at the ballerina's defense for claiming court has bias against women. I don't know. But yeah, that's what it was for last week. Well, they're supposed to be back at 8:45 Eastern. Hopefully we'll have, 8:45 Eastern tomorrow morning. So we'll have openings in the morning. Um, yeah, I think it'll probably be, they start at 9. If I skip through, I think usually I start about 11. That's what we did through Karen Reed and they were on the East Coast time. So I think if I start about 11, we'll be able to skip through breaks, skip through lunch, skip through sidebars, and then still be able to end. I think we usually would get caught up with like maybe I'd end up running maybe 10 to 30 minutes behind, by the end of the day. So that's what I'll plan on doing, is starting about 11 a.m. Okay. So Eastern, 11 a.m. Eastern. So that'll be the plan. All right. I'm going to get out of here. I just got a text that it's time for dinner. So going to go eat a bite and yeah. So thank you guys for joining me today. I know, right, Patricia? Ooh, it's going to be exciting. Exciting. I didn't mean to highlight Nightbot's comment, but QB said he was like, what didn't I appreciate? I'll tell you what I don't appreciate. You, sir. Tell your friends. Yeah. Yeah. Give us a thumbs up. Let me end the poll. I forgot to gotta end the poll. Gotta end the poll. Gotta end the poll. Hold on. All right. We're ending the poll. And the poll results are, the question was, how are you leaning so far concerning Ashley Benefield? 80% of you say she's guilty. 15% of you say, who is Ashley? LOL. That was me a few days ago. And then 5% is leaning towards she's not guilty. So, yeah. Wow. That's a big jump. Yeah, tell your friends and your mom and them. Tell your mom and them. Yeah. So thank you guys. Thank you, new subscribers that have popped in and hung out today, even if you're lurking in the background, right? So super happy to be growing with you guys. It's exciting. No, you're the cutest, Kel. You're the cutest. I love you. I love you. All right. I'm going to go. I'm going to eat and spend time with the family. Okay. But we'll see you back tomorrow, 11 a.m. Eastern Standard Time. Eastern Standard Time. Hashtag replay. If you're watching this on the replay, yes. 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 I like my Eastern Standard Time. All right. I love you guys, and I'll see you back then. Have a great rest of your night. All right. I love you guys. Bye.